Love you, Linda. Love you.
The courthouse the other day in the hallway, you're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Well, good morning, my Justice Served TV group. I am ready for you today. I have my pink hoodie, my pink crop top on. It's not the hoodie of Justice Served TV. I just felt like promoting it a little bit, Barbie pink, a little bit for whatever it's worth. And some of you will say that's because the pink is a free Karen Reed color. Others will say it's just Linda wearing Barbie. But today is casual day, actually. Michel Bryant is working his way up to Dedham right now. Amazing. He landed from his trip to Portugal, repacked, and is heading up to Dedham for 2 days, for today and tomorrow. So by lunch hour at 1 o'clock, we should have our show with our own Michel Bryant. If you watched last night, of course, we had Nan Gallagher on for the first time. It was Women's Night. Women from New Jersey, actually, and I'm going to even refine that more. Women from New Jersey who drive stick shift cars, or as somebody said, two badass women from New Jersey. Okay, so I hope you enjoyed it. It was an interesting discussion. We discussed the Fifth Amendment. We discussed one of my favorite all-time witnesses, Ms. Deor, and I have to share with you, I won't tell you who it's from, but let me share with you a message that I received from somebody who is in law enforcement way up, a fabulous person, somebody who has the respect of everybody all over the world, right? Just all over the world. And she sent me a picture of Miss Deor, okay? And as we discussed yesterday, every time she testifies now, every defense attorney is going to ask her, have you as a trained police officer ever remembered facts under oath that you thought were, shall we say, fantasy facts, all right? Her restored memory of some sort. So that's going to be something. And the end result was that this person concluded that, quote, Ms. Deor's career took a hit today. A hit today. She may think she testified really well. You know, she's the one who, when Alan Jackson asked her a question, simple question about the statements she had made to the Federal Bureau of Investigation. He said, Miss Deor, and she said, just as you can't remember my name, I can't remember the answer to your question. She was snarky. I even called her something that I don't like to do. I don't like to denigrate women, but this had nothing to do with gender. I called her a cocky-ass bitch, okay? And you know me. I am not exactly, I've done 2 shows last week on trying to uplift women, but what she just did to women police officers all over the United States is just terrible. She's put them in, this is your best. And think about it, a 20-some-year-old recruit to Boston, coming from Canton, she gets called into the commissioner's office one-on-one, just her and him, about this case. What was that about? And are you kidding me? Are you kidding me? I mean, there wasn't enough made about that, but boy, all right, that doesn't happen, all right? A 20-some recruit on a case doesn't get called into the commissioner's office if there wasn't a serious reason for it. Supposedly she was told to do the honorable thing, do the right thing, but this was not the right thing, okay? False memories. The defense created false memories in here. Yes, let's play the snark. Let's listen to the snark.
My question is, just answer my question, Officer Deor. Did we read to you, were you read the exact same thing that I just read to you on that phone call?
Like, you can't remember my name. I don't remember.
I can
Oh.
remember your name, Miss Deborah.
Okay, so
And that was my unfiltered reaction. Now, if I were in the courtroom, of course, I wouldn't be doing that. But my unfiltered reaction is it was as if I saw a rattlesnake, okay? Oh my God, what is she doing? And do you know, I bet her superiors think this was great. Why? Because if they're telling her to keep that blue line intact, okay, if they're telling her to keep that simple blue line intact, what do you think happens to her? Nothing, nothing, unless they're going to say she embarrassed the Boston Police Department and bring charges against her and try to have a specification against her. And I guess that all depends on what the commissioner and she had that private conversation about. Okay. Quite frankly, I think that if there was that private conversation, he needed to memorialize it because maybe that private conversation was exculpatory to Karen Reed. All right, that's something we didn't get into last night. But when you start seeing all of these things that are going on, when you start hearing all of these things that are going on, you know that there's something else. And she didn't do her career any favors. If she thinks she did the case any favors, she's also really, really out of sorts. All right. So Miss Dever, you may never see this podcast because I'm sure you're only into you and you're only into your rah-rah, and you probably got patted on the shoulder by fellow cops that want to hide the truth. All right. You are in big trouble as a police officer because from now on, your false memories that are being implanted are going to be challenged in every single case you do. And not only that, your attitude, every defense attorney knows they can now get to you, and you're going to have that frown and that look. And that, as I said, she looks like she was taking a bathroom break every time she had to answer a question. It was just disgusting. It was a terrible performance. And I don't know who talked to her about doing it that way. She said she has a team of lawyers. What does a person who witnessed something in a Sally Port and Karen Reed need a team of lawyers for? And here was the upshot. She was called in to come off the road and do dispatch, okay, by her sergeant, right? So good how to go back on the road. And so she did dispatch. She says she leaves at 3:45, but it's very clear that there's somebody, there's a female in that Sally Port during that period of time. She says initially, by the way, oh, thank you, Donnie Nat Wahlberg, gifted Justice, One Justice Served TV membership. Thank you very much. Really appreciate it. Anyhow, going back to her, she says that she tells the FBI that she sees the Chief Berkowitz, right? You know, absolutely, right? And you know that she sees them in the Sally Port, and and Higgins and Brian Higgins. Let's not forget Higgy, the ATF agent who has an office in the Canton Police Department. She sees him for an extraordinarily long time together at Karen Reed's car in the Sally Port, and it was a very weird, strong thing that she saw. And when she's talking to the FBI, and I'm not sure she just talked to them. It wasn't clear whether she actually testified before a grand jury or this is what she told the FBI agents. That wasn't clear to me, all right? Because remember, they were investigating. I don't know if they had a grand jury in the FBI. I have no idea. But that's all not become clear. Why? Because Judge Beverly Cannoni has put this thing that we can't speak about the FBI. So we have to talk about other law enforcement agencies. Well, she blurted it out. I think the jury now knows. But the attorneys still can't say FBI. It's such a garbage, this whole idea that you hide things from a jury instead of telling them the truth. All you have to do is say, ladies and gentlemen, you're going to have some evidence that there was some questioning by the FBI on some of these witnesses. It's not your concern what the questioning was about, what the whole scope of the nature of the questioning was about. All you're concerned with was the questions and answers that the witness gave to the Federal Bureau of Investigation agents. And we know that's Jen McCabe, and we know they learned that she lied to the FBI or another law enforcement agency. We know Kerry Roberts came clean that she never heard Karen Reed ask Jen McCabe to search House Long to Die in the Cold. We know she came clean on that. She was just repeating what Jen McCabe told her, and she told the grand jury that, but then she said when she got caught that, well, she misunderstood. All these people have been told that if you misunderstood or you made a mistake or you whatever, you won't have any liability for perjury. In other words, it can't be proven beyond a reasonable doubt. So they've all been advised of this, and they're all part of this big, grand, shall we say, you want to talk about conspiracies? That's where your conspiracy is. That's where your conspiracy is, when you're trying to hide the truth in a murder case. And that's why people are saying this is not just Occam's razor. This is not just, oh, there's a few pieces of tail glass here. Karen Reed may have backed up into a three-point turn. And I say may because I don't buy it, okay? And I'll tell you why in a little bit. At the house, and then she somehow hit John O'Keefe and left him to die. I don't buy it. And I think the jury is now hearing some things about why. Let's talk first about Mr. Judd Welcher the other day and his data with Shannon within one end Burgess before we go into court. And I'm seeing the fans, so I may get cut off. You know, that 1162-2 trigger or texting event or waking up of the black box, right, type bit, that may have occurred when the car was in the possession of the Boston Police Department, of the Massachusetts State Police Department, you know, or in Canton, right? When the car is taken from Dighton and moved to the Sallyport. I think that's when it occurred. I think you're going to hear that later on from some of the witnesses from the defense, because the three-point turn we heard that she made was at Crestview, okay, was at Crestview. And then there's no reason for her to be, you know, going in the other direction. She's got ways on and apparently, and she can go home. Our own Michel Bryant did the trip both ways. It's on our Justice Serve TV webpage. You can see it took about 7 or 8 minutes. I guess he did 8, but he could do it in 7. I think he said if maybe he did it a little bit differently, a little bit faster, whatever. But again, in the conditions that were there, the black box showed that when she left the waterfall to go to Fairview, she was only doing about 21 miles an hour. Okay, I think the average at some point was 28, but mostly about 21 miles an hour. So the fact that this door was opened by the witness, Judge Kenney does not care because she's going to stick to her ruling. All right, so we have all these ridiculous things, but Deor was ridiculous. Oh, Deor. Now let me call her Deor. You know why? Hank Brennan in his papers about getting the information about any contacts with her called her Denver, Denver. You didn't see her go after the Commonwealth for not just mispronouncing her name, but mistaking her name. So she had an agenda and she did not look good. Deor, you took a dive and your career is going to take a dive. I will guarantee it, because you will never be able to be trusted to be on the stand with the false memories that can easily be created in your mind. Quite frankly, if I'm not her supervisors and the commissioner, I am sending her for psychological review, right? What is in her that she's creating, that she says she has false memories that are being created because somebody shows her a timeline? Are you kidding me? Are you kidding me? I think that she is the person that's in the video at the Sallyport, because it's not the other woman who was not even on duty that day. There was only one woman in the Sallyport. There was only one woman who came back to the station. And let me tell you, if you have a body in your count, well, this is a great Tom Goley show. It's Deor pronounced habitual liar. That's a great comment. If you have a case, think about this. There's a body of a dead police officer on another police officer's lawn. You don't think you're going to stay around and find out what happens and see what you're going to help and what you're going to be doing? And especially when you have a self-importance that she seems to have. Oh, and she seems to have a self-importance, doesn't she? She has gotten a huge raise. She's gotten a double raise since she's gone to Boston. Why do you think she went to Boston? Okay. Why do you think she went to Boston? Okay. All right. Ridiculous. Just ridiculous. Hold on one second. I'm getting a message from somebody. I just want to see who it's from in case it is important. If you just bear with me, sometimes clients, have to be, they need to be answered, hold on. If you just bear with me 1 second. Let me answer this client real quickly because it is important. All right. Thank you very much for that. I really appreciate it. You all know that I'm practicing law, so it's kind of, when a client calls, I try to answer. All right. So where are we today? After that, Deor. And let's not even forget the fact that the text we read last night on our show, because there was the text went in, but they, not all of them. You heard some of them with Yuri Buchanan, that's Proctor's text, and some of them yesterday with the chat with the high school guys, who Proctor was still acting like a high school guy, talking about a leaking balloon and how Karen Reed defecates in her underwear and things like that. It was pretty disgusting. All right. Now, this man was uncomfortable reading the tweets, but he was in the tweet chain, the text chain. Okay, he was in the text chain with Proctor. And what happened was the texts were authenticated by Yannetti, but they weren't read by him. And I'm not sure why. There obviously was a reason. But then Hank read them because he had to read them, because the witness, Diamandis, was not comfortable saying things like the C word. Okay, he didn't want to be on TV reading these terrible words, which tells you how bad they were. When the witness says, it's like when Tues sees like a horse and he doesn't want to go near it and he backs up, it was just like that. I'm not, hands off. So then Hank had to read it, and he didn't even have the gumption to read the C word, did he? The word that the Proctor, the lead investigator, the lead case agent said about Karen Reed. He didn't have the gumption to say that. Why? Because it just shows how biased that investigation was. And the one thing that was able to get in, that Yannetti was able to get in, when Hank Brennan tried to rehabilitate Diamandis about, he's fired over these texts, and then he got in, he's fired over bias, right? Yes, bias, because those texts show bias between everything. Now, then we went to Dr. Marie Russell, and we've called our episode today, Russell Bites Brennan, because we think that Dr. Marie Russell is holding up very well. Why? She's had a lot of experience, because Hank Brennan made a tactical error. He did a 2-day Daubert hearing on her. So they were able to pick up her testimony, sharpen it because of that Daubert hearing, and get her prepped. And she answers the question, yes, no, you're wrong. And then Hank Brennan got caught in a big lie. He said he talked to her about the medical examiner's testimony, Dr. Scordi-Bello, and about the wounds and how she had incorporated some of that into her opinion. And then he said, but you didn't incorporate into the opinion that he didn't have these marks that were puncture marks and the deepness of them and all that kind of stuff. And she said, well, I incorporated what she said. I agree with her in my opinion. And then she asked, and he said, well, it's in the autopsy report. It's in the autopsy report. And then she said, may I see the autopsy report? And he's like, well, I don't really have it right now. I don't really have it right now. And the reason why, he apologized. He said, yes, you're right. It's not. It's in her testimony. He got caught in a lie in front of that jury. Okay. And we're not sure what's in her testimony that he now wants to read, because I'm not sure he can read her testimony. This was why the Commonwealth objected when the defense tried to cross-examine Welcher about opinions that he had, incorporating other experts. Here, this is the danger, because the attorney here, Hank Brennan, who's supposed to be seeking justice and the truth, lied. He basically lied to the witness. He told the witness, Dr. Marie Russell, that something was in the autopsy report and she was wrong. And then that was a lie, because he was trying to trap her, and it was not in the autopsy report. He was trying to trap her. I think it's outrageous. I think it's misconduct, quite frankly. But you know what they're going to say? Oops, I just made a mistake. Sorry, I made a mistake. That seems to be what everyone says when you're the Commonwealth, okay? Now, will the jury buy it? I don't know. when you try a case before a jury, the only thing that you have in front of that jury as a lawyer is your credibility. That's it. They need to trust what you say is the truth, because they're going to be given, though, the charge that what the lawyers say is not evidence. But what the lawyer says guides them. It guides them. And if they can't trust the messenger, they're not going to trust the message. It's an old adage, but it remains true in this case. So we're going to see when we come back, and I see the fan is running. We're going to see when we come back whether Hank Brennan gets off that line of questioning or whether he goes somewhere else. Now, of course, he's had the night to go through his questions and answers, and that's always That's always helpful when you're on cross-examination, because you can sharpen where you were going to go. You know, that's where we are. He's going to try to badger her. Now, I do think he was told, excuse me, apologize. Let me take my Justice Served TV mug and take a sip. As you know, I run on Duncan, holding my mug. I think he's been told not to badger her like he did in Daubert, because it looked bad that Hank Brennan was acting like the attorney for Whitey Bulger cross-examining this older woman, you know. And, you know, she has pretty unique credentials. And people don't generally die from dog bites, but there are cases medical examiners have taken a dog bite from Canada. I looked on my Twitter account and on the Access to Take a look at it, because it involved a whole commission in Canada that had to do a report about how this medical examiner, Dr. Smith, was so wrong. Dr. Russell has a unique experience. So now that we're going to do this, let me go back. Let's see whether they have to start with the sidebar or whether they start with Dr. Russell. And I will see you when I can next speak with you.
The Commonwealth of Massachusetts. This court is in session. Please be seated.
Good morning, counsel. Good morning, Ms. Reed.
Good morning, jurors.
Good morning,
I
Judge.
have to ask you those same three questions. Were you all
Okay.
able to follow my instructions and refrain from discussing this case with anyone since we left here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about the case since we left yesterday? Everyone said no or should be. Is Dr. Russell in the back there?
I don't hear
You
anything.
can set up if you want to.
I don't hear anything about a sidebar. This may be one of the first. Let's go, Dr. Russell. Hold your own again. Don't give in to the bully. And don't agree with him, because as you see, he tried to trick you. And by the way, that's when we left yesterday. I can't imagine how the jury slept on that one.
Doctor, I'll remind you, you're still under oath. Thank you.
Thank you.
Good morning, Dr. Russell.
Good morning, Your Honor.
May I?
Yes.
Good morning, Doctor.
Good morning, Mr. Brennan.
I had asked you yesterday if your opinions regarding the wounds on Mr. O'Keefe's arm changed between when you testified last year and then the more recent hearings that we've had over the past 4 or 5 months. Do you remember that question?
Yes.
And when I asked you that question, I asked if you had help with your report, and you told us that there was a woman who helped you with your report.
I told you that there was someone who helped me or made suggestions in organizing the report, having certain sentences placed in certain categories.
When I asked you about the identity, the person who actually helped you, I asked you if it was one of the attorneys, and you had said no.
That is correct.
May I approach, Your Honor?
Yes.
May I ask a question?
Yes.
Thank you. You had testified in December 22nd, 2024 in this case?
I believe it was that date, yes.
And when you testified back in December of 2024, do you remember I asked you who it was that had assisted you with your report?
I don't remember that specifically.
Well, I'm going to show you a page from the testimony. This is from the hearing. And I asked you, line 21, page 207, did anybody help you write this report? And what did you say?
I wrote the report.
If you could finish, please.
I had some help with some minor edits, rearranging, some paragraphs or whatsoever, but putting things in the right category.
Then I said, okay. And you answered?
No, I wrote the report.
And then finally I asked, who helped you with your report? What did you tell us?
I said, Mr. Lessie.
And Mr. Alessi, is that gentleman the attorney who asked questions on direct examination?
Yes.
Okay. And so, did Mr. Alessi help you with your report?
What I recall is we discussed the report, but I recall that it was someone else that actually helped me rearrange the report. That's my memory right now.
Is your memory different now than it was last December?
Well, I don't think so, but, you have something in writing.
Do you think you would have testified to that if it was inaccurate?
Mr. Alessi did not help write the report. He may have helped organize and make a suggestion about what is training versus what is experience, but he did not help me write the report.
Did you have any help trying to describe methodology?
No.
You had any help talking about differential diagnosis?
No, I'm very familiar with differential
And
diagnosis.
so, after that report was written, is there any reason why some of your opinions have changed?
I don't believe my opinions have changed.
When you testified at the hearing last year, June 21st, 2024, did you express that you couldn't say with 100% certainty what type of animal, in your opinion, caused those wounds?
100% certainty, that is absolutely correct. And I'd like to see that, but yes, that's my recollection.
If it's your recollection, I'm happy to show you what
Yes,
you
please.
testified to. You want to
Yes.
see it again?
Yes.
Okay. By the way, between last night and today, did you get any advice from anybody suggesting you should ask for a transcript when I ask you a question? Did that advice come your way?
That's my general advice from previous times.
Well, did you have any advice last night about that?
Yes.
Who told you last night that you should always ask for a transcript when I'm asking you questions?
Well, I think it was just Mr. Alessi.
So did you and Mr. Alessi, you know there's a sequestration order, don't you?
Yes.
That's a sequestration order that you're not supposed to discuss the case at all with anybody?
Well, we
during the
didn't discuss specifics.
Do you know that the sequestration order mandates that you not discuss anything about the case from when you start your testimony until you end your testimony? You know that, right?
I understand that there is a sequestration order.
Do you understand the sequestration order mandates that you're not supposed to speak to people, including the attorneys, about this case overnight? Did you understand that?
There were no specifics discussed.
Or did you understand that you weren't supposed to, is what I'm asking? Did you know that's a violation of the sequestration
No, I
order
didn't.
to speak to the attorneys overnight.
I did not know that that particular conversation would be a violation.
So did you meet with Attorney Alessi last night?
No.
How was it that you had a conversation with him?
Actually, it might have been in the vehicle.
You drove together?
Yes.
So did you commute to and from court together with Attorney Alessi?
There's a driver.
Okay, who else is in the car when you left court yesterday?
The driver.
When
Oh,
you-
no, I wasn't with him yesterday, no. Not in the car yesterday, no.
Well, you just said that you spoke to Attorney Alessi yesterday. And I'm trying to figure out, when was it that you were having conversations with Mr. Alessi relative to the sequestration order that you're under?
This morning, riding to court
Okay, so you and Attorney Alessi drove to court?
with the limo driver, yes.
Well, who was in the limo with you and Attorney Alessi on the way to court today?
That was just us.
Just you two?
Yeah.
What else did you both talk about other than that you should ask for a transcript every time I ask you a question?
That's what we talked about specific to this case.
Was it a long conversation?
No, not at all.
The entire ride here, there must be more you spoke about other than just the sequestration order.
We did. We spoke about Boston, how I love Boston area. We spoke about New York. We spoke about other things. And in fact, I have to say that even on the ride back to the hotel yesterday, with others in the car, nobody spoke about the case.
But I'm talking about this morning when you did speak about the case. What else? Not about the Red Sox or the weather. What else did you talk to Attorney Alessi about this morning other than you should ask for a transcript every time I ask you a question?
We talked about what I did last night.
About this case?
No,
I'm sorry, but I'm asking about this case.
that was it.
I want to know what all the discussions were between you and this attorney today or last night about this case.
Just that I should ask for a transcript.
Well, there must have been some there must have been some context. He didn't just turn to you talking about the weather and say, hey, you should ask for a transcript. You must have been talking about something.
He also generally, not today, but generally says, be honest. Always be honest.
Fantastic. But this morning about your testimony, what did he tell you? Did he tell you this morning you should be honest?
Not this morning.
Okay. Does anybody need to remind you to be honest when you testify?
No.
Okay. What else did he talk? How did it come up? Hey, by the way, ask for transcripts.
I don't even know how it came up. I didn't put much significance to it.
Well, it was just moments ago it happened because you just got to court. You can't remember the context of the sage advice of Attorney Alessi?
No.
You have any memory issues?
No.
May I approach?
Yes.
Transcript, page 46. Since you've asked for the transcript, I have it for you. Dr. Russell, this is June 21st, 2024. I had asked you whether you expressed that you couldn't say with 100% certainty. You agreed with my answer, so there's no need to try to refresh your memory, but I'm going to show it to you because you asked. Take a look at line 16. Is that now consistent with the questions I asked you and the answer that you gave, that you were less than, you couldn't be 100% certain?
That looks consistent.
Okay. You want more time with the transcript?
No.
Has anybody else talked to you about your testimony today overnight, Dr. Russell?
No.
When you testified last year, same transcript that we just looked at, do you remember when you gave your opinion to a reasonable degree of medical certainty, you said that you thought the wounds were from an animal, possibly a large dog?
On that same date?
Yes,
May I see the transcript?
of course. Pursuant to Attorney Alessi's advice, let me approach.
Objection, Your Honor.
I'm going to strike that, disregard that, Jones.
May I approach?
Yes. What page you on, Mr.?
23.
Snarky Alessi, he just couldn't. Not Alessi. Snarky Brennan, he can't control himself here. Oh, she's so honest.
June 21st, 2024, Doctor?
June 21st.
Although even that comment
Page
shouldn't have been
23,
made, but I know why it was
line
done
14.
because we talked about it just before we got on.
You asked the question based on everything we've discussed today. Is it your opinion based on a reasonable degree of medical certainty these injuries were from an animal attack, possibly a large dog? What did you say?
I said yes.
Thank you. Have that back?
Yes, you may.
Okay, thank you. When you gave your opinion, not this year, last year, you agreed when you were assessing the wound, you used the word, or adopted the word possibly, didn't you?
Explain the context of it?
Sure.
That sentence?
Sure. Go right ahead.
No, you. I'm sorry.
Okay.
Then I'm sorry. Please
When
rephrase
you-
the question.
When you were asked about your opinion last year, not this year, last year, about whether to a reasonable degree of medical certainty the injuries were from an animal attack, possibly a large dog, you agreed with that characterization. A large animal, possibly a dog, didn't you?
Yes, an animal, possibly a large dog, last year, yes.
When you were on direct examination, there were tons of questions about this word methodology. Remember all those questions you were asked?
In June?
Yesterday.
Yesterday, okay, yes.
Yes. And when you were asked about methodology, was that an attempt to try to explain that you weren't just looking at an abrasion and guessing or eyeballing it? You were trying to suggest there's some type of scientific or medical process to give some type of certainty to your opinion?
That is the process I used.
When you talked about methodology yesterday, you talked about your experience in methodology with knife wounds and gunshot wounds, correct?
Yes.
But there was no methodology whatsoever regarding looking at a photograph and then identifying whether that is consistent with dog bites, is there?
I disagree.
When you described methodology, you were asked by Attorney Alessi whether or not you've engaged in that methodology regarding dog bites. Did you agree that there is really no methodology regarding dog bites?
I disagree.
When you use the word methodology regarding dog bites, there isn't something specific you're looking at as if you were looking at a fingerprint. There are points of comparison. You don't do that, do you?
There are no specific points that are published by a organization, for instance, on how to determine something is a dog bite. However, I did use different methodologies, including what we talked about, the differential diagnosis, the pattern recognition. Pattern recognition, again, is so important in medicine. It's what pathologists use to diagnose tumors.
There
For
is no
instance.
standard. There is no recognized standard anywhere for methodology on how to identify a dog bite wound, is there?
There is no published standard from an organization that I am aware of.
So there is no source, there is no recognized community, there's no certification, there is no recognized method in identifying a superficial abrasion as a dog bite. Isn't that fair to say?
As in many conditions in the medical field, there are no certifications.
How about published standards? Is there any published standards whatsoever, any, regarding claims that a superficial abrasion is a dog bite? Are there any published standards by any organization?
No, but there would have to be thousands of published standards to identify the causes of the thousands of different types of abrasions. So no, there's no published standards.
No published standards. There is nowhere you can point to where the so-called methodology that you were telling the jury yesterday is a readily accepted standard in the dog bite community. You can't point to anywhere, can you?
There are peer review articles which list recommendations on how to determine something is from some wounds are from a dog. These are peer review articles written by esteemed physicians that have analyzed dog bites and have published these and have published an approach to identifying, particularly a forensic approach to identifying dog bites.
Let me ask you the question again, Dr. Russell. Can you point to one place where there is a readily accepted standard in the dog bite community for identifying dog bites?
Objection
One article,
asked
one
and
journal,
answered.
one book. Can you point to any?
Well, I'm going to mention the articles I mentioned earlier. The article with the lead author of Dr. DeMunick and the article with the lead author of Dr. Pollack. And although they're not standards, they are recommendations.
I'm going to ask you the question one more time before.
Objection.
Can
Come
you
on,
point
let's
to
see
one
objection.
place, one, where there is a readily accepted
Badgering,
standard in
asked
the
and
dog bite
answered.
community for identifying dog bites?
No.
She said that. She said that. But there's peer-reviewed articles that give recommendations. Is Alessia asleep at the
And
wheel
so with
here?
no readily accepted standards in the dog bite community, no defined methodology, when you look at a photo like you do of John O'Keefe's arm, you're just eyeballing it based on your personal experience with dog bites, rather than relying on some type of scientific foundation that has been published and accepted in the community.
Objection, Your Honor.
I'm going to allow that.
Finally.
Isn't that
But
fair
she's
to say,
going
Dr.
to
Russell?
allow it.
No, absolutely not. There are many, many conditions in medicine where there are no standards developed, and yet doctors make, and nurse practitioners and the like, make diagnoses all the time on these various medical conditions, and more importantly, they treat them because they require treatment. There are not published standards on every single of the 10,000 or more medical conditions that exist, including dog bites.
I'm not talking about a stuffy nose or a broken leg. We're talking about dog bites here. So let's focus on dog bites, if you would, if you can indulge me, doctor.
I think this is badgering. at this
Regarding
point.
dog bites, since there is no standard practice, there is no accepted methodology, and since there is no accepted and approved guidelines, you are essentially simply looking at a picture, a photograph, and just using your past experience with treating dog bites as the basis for your opinion. Isn't that fair to say?
I don't think so. I'm using my past experience, my strong interest in dog bites over 30 years, and the and the articles that I read, the numerous articles I read, but the articles that have recommendations. I'm using all of that combined to come up with a methodology for determining that those are the result of a dog.
When you say coming up with a methodology, are you saying that you're creating your own methodology, that you're the person who has the standard and nobody else? Is that your position, Dr. Russell?
No, the phrasing was not good there. I use standard methodology of pattern recognition and differential diagnosis.
There is no standard in the medical community relative to differential diagnosis and pattern recognition as it relates to dog bites, not other areas of medicine, dog bites. There is no accepted methodology, is there?
That's true.
You mentioned that you have this strong interest in dog bites. Let me borrow a phrase. Do you think you had any confirmation bias when you got into this case?
I don't think so.
Well, you definitely wanted to be in this case. You weren't sought out, you sought the case.
That is incorrect.
And you said you had a strong interest in dogs, and that is one of the reasons you wanted to get involved in this case. Isn't that fair to say?
No, that's actually an unfair statement. I did not want
Go,
to get
Dr.
involved.
Russell.
I wanted
Go,
to
Dr.
offer
Russell.
my knowledge and experience to help clarify issues. I did not want to become an expert witness in this case. And I used, again, as I do on just about every medical condition that I look at and every wound that I look at, I do a differential diagnosis. What else could this be? What else could have caused these scratches and abrasions and wounds? What else before I come to my conclusion?
On your ride over here today, were you instructed that when I ask a question, rather than answer it, give a long explanation about something else?
No.
Oh, go away, Hank. You're so rude.
I would like
I'm
to
so rude. This is so
put up
rude.
an exhibit of Mr. O'Keefe's arm, and I want to ask you some questions about it. You and I have had many conversations about Mr. O'Keefe's superficial scratches before, haven't we?
Yes.
And would you agree, looking at these, they are superficial abrasions? Do you agree with that characterization?
Yes.
When we last spoke, just for background, to remind ourselves, we broke these into separate parts so we could discuss them by number, just for a sense of clarity. And we discussed this as wound number 1. Do you remember that?
Grouping number 1, yes.
Number 2?
Yes.
Number 3?
Yes.
4?
Yes.
5?
Which did you call
sorry, this
4?
one.
4,
5.
5, 6, maybe.
Okay. So as we go through, I'm going to identify them by number. That wasn't done by anybody else. It was just during our discussion so we can have clarity. Is that fair?
Okay.
Sustained.
Is it fair if I refer to this as 1, 2, 3, 4, 5, 6?
I think so.
Okay. When you testified on June 18th of 2024, last year, when you came in, you were asked questions before the actual hearing. You were asked questions about this particular superficial abrasion, weren't you?
I'd have to see the transcript. I believe
course.
so, but I'd have to see the
Do
transcript.
you remember when you were first giving opinion testimony about this specific abrasion, wound number 1? Do you remember you saying that you thought it was either teeth or nails?
I'd have to see the transcript again.
I will give you the transcript, and as I'm doing that, let me ask you, do you remember your testimony about what you actually said?
So, do you remember your testimony?
For each specific day, no. I remember generally, but not for each specific day.
If you
I've
have
been
an
here many
opinion-
times.
I'm going to bring your transcript up to remind you, but if you have an opinion, it shouldn't change, right? It should always be the same?
Generally, yes.
Okay. So let me ask you before we talk about what you said at the beginning. What is this from? Teeth or nails?
It could be either, but I think that's from teeth.
So when you say they could be either, if you have a methodology and you have a certain standard where you can identify something based on a standard, there wouldn't be so much uncertainty, would there? You'd be able to look at this, consider the methodology, and either come to an opinion whether it was teeth, nails, or something totally different, right?
You know, Mr. Brennan, perhaps I didn't explain earlier, but the nail of a dog tends to be cone-shaped, conical in shape, and very similar to the nails that the canine teeth of dogs. So the shape and the fact that they come to a point makes some wounds indistinguishable.
Are you saying that nails of a dog are so similar to the teeth that you can't tell the difference between them when you're looking at a
What
wound?
she said.
I'm saying that they can cause similar-looking abrasions.
Are you able, as the premier expert in the United States on dog bites, able to tell the difference between teeth and claw nails of an animal when you're looking at a wound?
Individually, well, okay, that's a very interesting question. Sometimes it's difficult because they can have similar appearing wounds. So you have to look at the overall pattern in order to make some conclusions.
Well, when you first started testifying in this case, you never suggested you had to look at everything in totality. You were giving opinions regarding individual wounds. Isn't that fair to say?
Argumentative.
No,
It wasn't until I began asking you questions and you had inconsistent answers that you've now changed from, rather than identifying
Objection.
individual wounds, now you're saying I can't identify individual wounds, but I can tell you in totality.
I disagree with that. I believe that the very first time I testified, I mentioned that the overall pattern was important.
When you first testified, so today, before we get to your testimony, you're saying this could be either teeth or nails, but you think it's probably teeth.
Correct.
How probable? Do you think it's certainly teeth, to a reasonable degree of medical certainty? You're not sure? What is the value of your certainty or lack of certainty about what
100%
caused
sure
this
it's
wound?
either or.
Reasonable degree of medical certainty.
What is a reasonable degree of medical certainty? That what?
That those are caused by teeth.
Teeth. Okay. When you first testified, your position was it could have been teeth or nails. That is different than saying, to a reasonable degree of medical certainty, teeth, isn't it?
No, there is a small possibility that they could be caused by nails.
When you first testified, you didn't qualify it as a small possibility, did you?
I perhaps wasn't asked.
Well, you answered.
Boom.
Remember when you were asked about it and you answered? You talked about that it was a pattern close to the shoulder with parallel marks. Do you remember?
Do I remember what?
Saying that this is a pattern close to the shoulder, right? That they're superficial. You agree with that still?
Yes.
And did you say they were consistent with teeth and nail marks?
Yes.
Okay. Nails on a dog, oftentimes or most times, are horseshoe shaped, aren't they?
They're generally conical shape.
You don't think that nails on a dog in your studies have a horseshoe shape?
I think it depends on the grooming of the dog and if the nails were cut recently. But in general, they come to a point. They're at the, you know, at the end of the paw. They come to a point. And by the way, the paws can open and close. So the distance between the nails can vary depending on how that claw impacts the skin. So in many ways, they resemble the overall shape of canine teeth.
And so to get back to my question here, you're saying that this could have been caused by dog nails?
It's possible.
Do you know, or do you think that the teeth in a dog are different shapes and sizes?
Oh, yes. Depending on the tooth, there's different shapes and sizes. Absolutely.
When you testified the first time and you said that you thought it was teeth or nails, do you remember testifying a couple days later in front of a group of people
Saying
and
the
you
same
again
thing over and
iterated
over ago. He's trying to make
that
it
this
different.
could be teeth or claw marks? That was your testimony last year. Teeth or claw marks, right?
You know, I'm going to object to the characterization of that prior.
Finally.
So just prior proceeding, folks, that's all that we
Did you testify at that prior
And
proceeding?
of course, Judge
last summer,
Kenney
that this could have been teeth
never
or
sustains.
claw marks?
I would need to see the transcript.
Good for you, because Hank lied with the transcript yesterday on the autopsy report, and so she needs to see the transcript. So whether Judge Kenney does something like fines Alessi or something, I don't know. But quite frankly, you know, she's so honest, because any other witness who had that discussion with an attorney probably would say they had no discussion. I need to see the transcript, Mr. Brennan, because yesterday when you were showing me the autopsy or talking about the autopsy, you were wrong and I needed to see it, and then you said you made a mistake. That's really what she should be saying.
When you first testified on June 18th, doctor, you were asked questions trying to identify what you thought that wound was. And this is your June 18th, 2024 testimony. On page 37, line 7, the questions begin. And you were asked what you thought they were. You can read any part you want, but line 7 might be a starting point.
Yes, I said that which are consistent with teeth marks. They also could be possibly consistent with nail marks.
It's the same thing. She's saying within a reasonable degree of medical certainty, her opinion is basically those are teeth marks, but because medical certainty is not 100%, it could also be consistent with nail marks. That's basically it. So maybe it's 95% teeth, 5% nails, but it's a dog. It doesn't matter. It's not an exploding tail
That was
light.
your first testimony last year, yes?
Yes.
And then did you testify a couple days later and again repeated the same opinion, teeth or nail marks?
May I see it?
I'm asking
for
if you
you.
remember.
Yes, I remember testifying.
Do you remember after you worked on your report and submitted your report,
Yes,
after your consultations, do you remember changing that opinion regarding number one? Do you remember changing that opinion?
no.
I could answer that. You can ask her 100 more million times.
Do you remember changing from either teeth or possibly claw marks to being very specific, claiming that it was definitely teeth marks?
No.
Are there different types of teeth in a dog?
Yes,
Okay. The pointy teeth, the big ones, those are called canines,
correct.
and the smaller ones are incisors.
Correct.
There are 6 incisors in a healthy dog on the top and bottom between the canines.
Correct.
Okay. Did you, when you testified subsequently to the original proceedings, did you change your opinion from teeth or claw marks to specifically teeth and even more specifically canines?
Do you have a transcript?
I do, but I'm going to ask you the question. Do you remember changing your testimony from teeth or nails to
No.
being
Say
very
no.
certain that it was canines, not just teeth, canines that caused that wound?
I became more certain, yes.
You had never said that the canines caused these wounds before you filed the report, ever, did you?
I may not have, that's true.
And so after you did your report, you shifted from teeth and nails to canines. Do you remember that?
I don't think it's a shift.
No one would ever refer to a dog's nails as canines, would they?
No, I don't think so.
That would be inaccurate, wouldn't it?
Yes,
That would be a mistaken use of the word.
I believe so.
When you testified December 2024, you didn't say nails could have caused this wound. You didn't say generally teeth. You said canines.
I believe that, and that's true. I believe that canine teeth caused that wound.
Did you have any new information about
you say teeth
photographs
and you
that
didn't
would
say
help
canines,
you
it's
change
dog
your
teeth.
opinion
What are we
from
talking
teeth and
about
nails
here?
to canines?
Well, I had been challenged. I had testified several times. I reviewed the case several times and challenged, and each time I reviewed the case, I became more certain that these were from canine teeth. And actually, there's other marks there, but these are from teeth.
You say more certain. You had never said canines before, ever, until that recent hearing. Isn't that true?
I said teeth.
Canines.
It doesn't matter. I said teeth.
Top-
Canines are some of the teeth.
Upper or lower canines?
Upper.
And if it's upper canines, you
When I call my
testified
dentist, I
previously
don't say I want to see my
that the point of
canine.
entry would be here at the bottom, and the dog would pull this way. That's what you testified to. Yes?
No, I believe you misunderstood then. The point of entry is up there. The first initial point of contact is there, and the dog pulled this way, or Mr. O'Keefe pulled his arm the opposite way.
Dr. Russell, you don't recall that you said that the bigger circles are the point of entry, the dog pulled this way, and then I asked you, how could a dog pull this way when the arc is like this? The dog's mouth would have to be in backwards. Remember that conversation we had?
Objection, Your Honor.
Were you allowed?
Do you remember that
Of course you
conversation?
are.
You said
Of
that the
course
point
you
of
are.
entry would be the bigger circle pulled this way, and then I questioned, how could a dog's arc look like this if the teeth went that way?
No, I don't recall that
Do you
at all.
remember that conversation
No.
we had? Okay. And so, inevitably, when you look at
And so
this
since he's not
part
showing
of
her
the
the
wound
transcript,
alone,
that conversation didn't exist.
have you expressed an opinion that you're unable on its own to be able to tell whether this was caused by a dog.
Which part of the wound?
Taking any of these alone, let's start with number one. Haven't you expressed an opinion that taking this alone, you would not be able to say that was from a dog bite?
That is correct. In and of themselves, they're not that specific or characteristic. However, as a group, they are highly characteristic of a dog
So if
injury.
Mr. O'Keefe's arm only had this wound and nothing else, by virtue of what you're telling us, you would not be able to offer an opinion that this was consistent with a dog bite.
That very first wound
Yes.
up there, closest, I agree, yes.
In fact, you've testified about this very issue before. If this was the only wound on Mr. O'Keefe, number two, you would not be able to say that the injury is consistent with a dog bite.
Correct.
I'm going to go through all of these just so we're clear. Same thing with number three. You've provided opinions on this before. If you look at this wound alone, in isolation, you would not be able to say that it came from a dog bite.
Correct.
Four, pardon me, yep, four,
If you look at my
Same.
toe
Looking at the
individually,
wound
you wouldn't
alone,
know
you
it
would
came
not
from
be able to
me.
say
But
it
if you
came
look at
from
it
a
with
dog
all my
bite.
other toes, you can
Correct.
tell it's part
same
of
for
my foot.
five and same for six.
Correct.
Now, when you testified before your recent testimony, you never had that qualification. When you came into court, you were saying that when you looked at these wounds individually, you were saying that you could identify it as a dog bite.
I disagree with that characterization.
Number two, what caused this wound, Dr. Russell?
Number two, I believe that was dog bite or scratch, but mostly I believe dog bite. And because there's a punctate, little tiny, pinpoint almost, lesion there and there, which could represent bottom teeth.
Okay, so you're using words like could, and we're talking about a reasonable degree of medical certainty.
You should take it all
So
together.
when you look at this
asshole.
wound here, you said that you are sure or not sure what caused this wound.
I'm saying that individually, that wound, that's correct. I'm not sure individually what that wound was caused by. However, again, as I mentioned earlier, the overall pattern of wounds is what I am convinced of.
I want to go through each of these wounds separately so we understand what you actually recognize with your methodology and what you don't. So looking at wound number two, based on whatever methodology you've been using, are there any signs, indicators, objective criteria you can look at and tell us this is or is not a dog bite based on this methodology you have?
There are some characteristics that are suggestive of a dog bite or dog claw, including the fact that there are parallel lesions, and many of these, overall, by the way, parallel lesions are in the same general direction. So there are parallel lesions, and here they're associated with some punctate or point-like other abrasions right here. So they're consistent with being inflicted by a dog.
I appreciate you using some medical terms to describe this, but my question is more pointed. Is there
Oh,
anything
no,
about
it
your
was not.
methodology, something that stands out about these wounds, that you can say to a reasonable degree of medical certainty that these are consistent with a dog either biting or scratching?
These wounds all by themselves, not to a medical degree of certainty, no.
You said on this first wound, you thought this was from the canines. Those are the big upper teeth is what you're claiming, right?
Yes.
And you're saying today, anyways, starts here at the bottom and goes up. Is that
No.
your position today?
That's not what I said. I said the
Okay.
exact opposite.
So it starts here and comes down.
Correct.
Okay. And these two scratches, they're linear, just like these are linear, aren't they?
Objection.
Yes.
But you have a
Objection.
problem with
Objection.
these because if these are the canines, you see
I
the
think
spacing
Alexi
there?
thinks she's holding her
This is
own
nowhere
and is not
close, is it?
objecting. And Canoni's not
I
gonna
didn't
do-
say that these were
sustain
caused
them,
by
but
canines.
Sometimes you gotta,
And
in there.
spacing also, there's reasons why the spacing could be different.
Well, we can talk about that in a second. Are you suggesting that these exact, well, not exact, these two linear abrasions, just like 1 and 2, are you suggesting the canines caused these?
I don't know what caused those, which teeth caused those, or which nails caused those.
When you testified last year on June 18th, you said that this was either teeth or claws. Can you give us any development of your opinions, whether or not you think that is teeth or claws?
Objection,
Excuse me?
argumentative.
No, well, I couldn't hear because of the fan.
When you testified on June 18th, you said wound number 2, the top 2 linear abrasions, you believe were either teeth or claws. You've shared with us now you have improved your study and have new
Objection,
opinions.
argumentative.
Do you have a clear opinion whether this is teeth or claws?
Objection, Your Honor.
Sustained, ask it differently, Mr.
Do you have an opinion whether this is teeth or claws or not something totally different than a dog?
I believe they are teeth or claws caused.
When you testified at trial and in that hearing that they were teeth or claws, you changed that opinion as well at the most recent hearings, didn't you?
Objection.
So, Mr. Brennan, word it differently.
Sorry?
Word it differently.
Okay. Did you testify at a more recent hearing that teeth made these, not teeth or claws, but teeth?
I may have, and I would like to see that.
May I
Could
approach?
you just hold 1 second? Could you please turn the fan off, Paul? Jerry, is it okay if we turn the fan off so we can hear better?
What did she ask, the fan to be turned off?
Thank you very much, Officer Deor.
May I approach?
Yes.
From your December hearing, page 100, line 5, when you were asked about that second wound in December, and I asked whether you changed your opinion from teeth or claws to just teeth. Weren't you asked specifically about that on page 100, line 5?
Yes. But may I read it?
Sure, I'll read it with you.
Okay. I said, I'm not sure on the second set. So this is the set just above the elbow.
I'm not sure exactly what teeth made these. They could, one of them could, one set of these could be canine, one part of this, and then adjacent incisor tooth. But I'm not sure on the second set, so this is the set just above the elbow.
Yeah, I think the first part of that paragraph is talking about the first set
Yes.
up there close to the shoulder, and then the sentence, but I'm not sure on the second set, so this is the set that's just above the elbow. I said I'm not sure.
And then,
This is what she's
Go
been
ahead.
saying all day today.
Oh, yeah, actually, I did make another comment. What is it? However, what is interesting and certain is that there's an upper set and a lower set. So this mark was an upper tooth. This is a lower tooth. What I was referring to is this mark here and that mark, and then this mark here and this mark here. So it appears that this is from upper and these are from lower. That's what I was referring to.
That's why it was good advice.
so when you
to
first
ask to
described
see
these,
the
this wound,
transcript.
as teeth or claws, at the most recent hearing, you had a certain opinion that this was teeth, didn't you?
Yes, I was leaning towards teeth. Correct.
Well, it didn't seem like you were leaning. You said these were from the upper teeth.
Yes.
You said it matter-of-factly, not with any qualification. Your claim at the last hearing is this was from teeth.
That's what I believed.
And today, you're saying you don't know if these were teeth or claws.
Not with 100% certainty.
You didn't qualify 100% certainty. You were asked your opinion, Dr. Russell. You
Yes.
were asked,
My
what do you
opinion's
think?
within a
And you
reasonable
didn't say
degree of
without
scientific
100%
certainty, which is never
Your
100%,
claim,
jerk.
The first time you testified, teeth or claws. Recently, you said teeth, and now you're saying you're not sure.
No, I'm saying I believe that those marks are from teeth, but I'm not 100% certain.
Suffice to say, looking at wound 2 alone, you cannot say this was caused by a dog.
In and of itself, no.
What tooth do you think caused this wound?
I don't know.
Do you think this in any way could be caused by dog teeth if you're claiming that this is dog teeth?
Excuse me?
Do you think there's any way these two could be caused by dog teeth if you're saying that these two are caused by dog teeth?
Yes, it could be, but I don't know which teeth. And I don't know the extent of the bite, how much impact there was, and how much pressure, how much contact there was between the teeth and the skin.
The canines are the longer teeth in a dog's mouth, aren't they?
They are.
And when a dog bites, it's very common for the canines to puncture, isn't it?
It's common if there's enough force, and it's common that you might have two canines if the strike is perpendicular to the skin. But if you have a tangential strike, a partial strike where only part of the teeth impact, you'll get different configurations.
Look at the spacing, Dr. Russell.
Spacing is irrelevant because you got movement.
Strike with a K.
Look at the spacing, Dr. Russell. A dog causing these wounds, the canines are not going to have such a dramatic distance between them because dog canines don't move, do they?
They don't, and I'm not claiming that these two parallel stripes in this case, or abrasions here, I'm not claiming that those two were caused by canines.
You think a dog is going to leave a wound with linear abrasions using its incisors as opposed to its canines? Is that your opinion?
It's possible if that's the only part of the mouth or the jaw that actually touched the skin, if it didn't go back as far as the canines.
Did you ever look at the underside of Mr. O'Keefe's arm?
I did.
Posterior side?
Excuse me. Pictures, yes.
Yeah. And when you looked at the photographs of the posterior side of Mr. O'Keefe's arm, did you find anything conspicuously absent from underneath his arm?
Well, first of all, let me clarify. Part of this is the posterior aspect of the arm. So are you asking me, did I look at the underside of the arm, the fleshy part
That's
of the arm?
exactly what I'm asking. It's a question I've asked before. When you look at the other side of Mr. O'Keefe's arm, did you notice anything conspicuously absent?
Yes, there's an absence of wounds.
When a dog bites, I don't care if it's a law enforcement dog or a domestic dog.
I have dog bites all
it's
over
like a lever,
my
the
body.
dog's mouth, isn't
They're
it?
not on both
It
sides.
can be if both jaws strike the skin. However, there are
Is it like
cases,
that?
there are many times when only the upper jaw
Right.
strikes the skin.
Dog bite
The
here,
lower jaw is a
dog
lever,
bite here.
locks, and that's part of the clamping and pulling process of a dog, whether it's a law enforcement dog or a domestic dog. You know that, don't you?
I know that they are attached.
Your claim is that there's many, many different dog bites on Mr. O'Keefe's arm. Are you suggesting, to a reasonable degree of medical certainty, that these are a number of different dog strikes, and coincidentally, every single one of them lacks any wound to the underside of his arm?
Yes.
Your claim is that a dog penetrated the sweater on the top,
Not a sweater.
but the lower jaw did not leave any wounds?
I'm claiming that that's not what I'm claiming. No. As I mentioned earlier, These could be from lower jaw. Those right there.
You're saying could be.
Could be.
That's speculation. We're asking you for your medical opinions. Your medical opinions. Do you have any evidence that the dog's lower jaw, you said maybe upper, maybe, that the lower jaw, even just once in this whole event, penetrated Mr. O'Keefe's skin?
No, nothing penetrated the skin. There was no actual penetration of the skin. These are abrasions. But yes, I believe that these small marks right here, punctate marks, may be the result of lower jaw impact.
Rather than deal in speculation and maybes, can you tell us to a reasonable degree
Objection,
of medical certainty
argumentative.
whether or not this was caused by a tooth?
Objection, Your Honor.
We're going to strike the first part. Why don't you ask the other part?
Can you tell us
Finally.
to a reasonable degree
Come on,
of
Alessi, wake
medical
up.
certainty whether this superficial abrasion, could you put that back up, please, was caused by a dog?
In and of itself, that part only, no.
Can you tell us anywhere on Mr. O'Keefe's arm to a reasonable degree of medical certainty where the lower jaw impacted Mr. O'Keefe to leave even a scratch?
Not with a reasonable degree of medical certainty on individual wounds.
And not just individual wounds, I'm talking specifically the lower jaw. Can you point to one wound, one abrasion on that arm where you can say to a reasonable degree of medical certainty the lower jaw caused any of those abrasions?
I believe there are several areas where there's impact from the lower jaw. However, I cannot say with reasonable degree of medical certainty that part only.
Let's look at number 3 to move along. When you
She's really a
first
good
talked
witness.
about
She has
these
honed her
wounds,
skills.
again,
She doesn't go beyond
is it
what she
fair
knows.
to say that you described that it could have either been teeth or claw?
I'd have to see it.
Okay, I'll bring it to you. You don't remember that testimony?
I remember, again, I've been here many times, so I want to be,
Well, you have the
Specific.
opinion today, and I'm getting the transcript for you, Dr. Russell.
Thank you.
Do you have the opinion today that that those were either teeth or claws?
yes.
What's your opinion today?
Well, I think that most likely they are from teeth marks.
Well, rather than most likely, we deal with reasonable degree of medical certainty. To a reasonable degree of medical certainty, can you give us an opinion regarding the cause of those marks?
Objection, Your Honor.
Thank you, Alessi.
I'll strike the comment.
Can you
Thank you,
tell us to a
Leslie.
reasonable degree of medical certainty whether these wounds were caused by teeth or claws?
Individually, no.
She's talking about a pattern. See, that's where this goes in. She's talking about a pattern. I don't think he's laid a hand on her, by the way, this time. I think in some of the prior hearings he did, but not this time. In the prior Dalberti,
Did you
may
ever
have, but not
change your
this time.
mind about the source of these abrasions?
Can you be more specific?
Did you ever claim that any of these abrasions were from upper or lower teeth?
I don't recall changing my mind.
You don't recall if you've ever said that? Let's separate these bottom wounds. Do you have an opinion to a reasonable degree of medical certainty whether these were caused by teeth or claws?
I have an opinion.
To a reasonable degree of medical certainty?
No.
Do you have an opinion to a reasonable degree of medical certainty whether these were caused by either a dog teeth or dog claws?
I have an opinion.
To a reasonable degree of medical certainty?
Individually, no.
No, he hasn't shown her the previous testimony. He just makes those snide comments making suggestions. And when she's saying that you can't take one individually
The
and
one
say
near
it's
the
a dog,
wrist, you had
but you
testified
can
yesterday.
take it collectively and
there's
show it's a
lines of
dog
what you believe
attack.
to be an arc, correct?
Yes, they have a general overall appearance of an arc.
If there's an arc and there's two linear abrasions on the outside borders, wouldn't these necessarily have to be the outside borders from canine teeth?
Not necessarily.
They're longer than the middle ones, aren't they?
The abrasions are, but doesn't mean the teeth are.
If this was an arc, like you claim,
Because there's movement
you think
in
different
the
teeth
attack
other than
by both the dog and the
the
person.
canines could have caused the outside scratches?
It's possible.
And you do note the distance between the top and bottom of those wounds compared to the distance in number 2 and the distance in number 1.
I see the difference, yes.
And you have to concede, Dr. Russell, that the same set of teeth, the same canines, could not reasonably have caused this wound, and this wound.
Disagree.
Given the distance between the inside and outside.
First of all, I'm not certain that these are all canines, as I mentioned earlier. Secondly, you have to take into account that skin is elastic.
Right.
It bends.
Exactly. It moves.
It depresses. So you could have 2 prongs, for instance, of a pitchfork, for instance, just as an example, impact the skin in different places, and the measurement
skin
between the two
moves.
can be slightly different depending on the elasticity of the skin and the underlying structures.
This is
That's
not a
why you
slight
can't
difference,
have
Dr.
forensic
Russell, is it?
odontology and have a specific
Again-
bite mark on it because the skin moves. Thank you,
So there's a
Alessi.
question of that, so I'm going to let that in.
Again, Dr. Russell, the distance here, it's not insignificant, is it?
Mr. Brennan, I already mentioned that I did not think that these were caused by 2 canine teeth.
And these, the distance between these two, have you measured them?
I approximated them, yes.
What did you come up with?
Visually, and I can see that there's a difference.
What was your measurement
Because
for
the
this one?
skin moves as
I
movement is occurring.
think about 4 centimeters, and this was a little bit more.
Did you note that in the report? Did you
No, I
actually
did
measure
not.
them, did you actually take out a ruler, measure them, and document them as you studied these wounds? Did you go through that process during your methodology?
No, because this is an image, and there's no scale in this image as to how far away different points are. So my own measurement would not be accurate because there's no scale in the picture.
Why did you go through the process of measuring them if you're now saying that it's inaccurate after I asked you if you memorialized it? Why would you even do it if you're now saying it was
Because I was
inaccurate?
interested.
It was an approximate measurement in my mind.
In your mind?
Yeah.
Okay, but you never put it on a piece of paper, or report, notes?
That's
Objection
correct.
argumentative.
Why would you
I
even
mean,
go through the
I just
process
think
if you're
this is
looking at it and
ridiculous.
your explanation is, it's only a photo, I wouldn't be able to tell? Why would you even try to?
I think probably everybody in this room has already done the same thing.
And if anybody in this room did the same thing, it would be quite obvious, doctor, that the gaps between 1, 2, and 5 are dramatically different.
It's irrelevant because the
They
skin moves.
are.
and the
However,
dog
I'm
bite.
not
You're
saying the
just
same
staying there
exact
and
teeth
letting a
caused
dog
those
hold on
marks.
to you and say,
When
oh,
you
this is fun.
testified yesterday, you used the term differential diagnosis. I want to ask you a lot of questions about differential diagnosis.
Oh,
Do you remember
boy.
using that term?
Yes.
And differential diagnosis was really just a way for you to try to get your opinion to the jury that these injuries were not consistent with a car accident. That's what
Argumentative.
a fancy way of doing it is, right?
No, it was a method I used.
Differential diagnosis, you're claiming that you can say this is not from a car accident or a car collision. That's what you're trying to say, aren't you?
That was the result of my differential diagnosis and my pattern recognition
So if you're-
methodologies.
If you're going to exclude a cause of the injury, in this case, a collision, you have to know a little bit about collisions, don't you?
No.
Yes, I don't know how to answer that.
Well, try.
Can you be more specific?
If you're going to say that these superficial abrasions could not have been caused by a car collision, you kind of have to understand a little bit about the mechanics of a car collision, don't you?
Actually, I disagree. However, I've treated thousands of victims of motor vehicle accidents and have seen the wound patterns that they come into the emergency room with. And that forms a basis for me.
Do you really think?
Did you finish that answer, Dr.?
No.
Did I cut you off?
I believe so.
Oh, I'm sorry. Please continue.
No, and the thousands of victims of motor vehicle accidents, I've looked at their wounds, I've treated their wounds, cleaned their wounds, touched their wounds, and that is what I use as a basis, part of my basis to determine that these were not caused or not consistent with a motor vehicle accident.
When you first gave that opinion that it wasn't consistent with the motor vehicle accident, it's fair to say you didn't have a lot of information at that time when you first came in and said that, correct?
Specific to this case?
Yes. Yes.
I didn't have a lot of information, that's correct.
Okay. And so in order to rule out a collision causing these wounds, let me ask you, are you an accident reconstruction expert?
Reconstruction? No.
Did you ever go to any academy for training to receive any type of degree or certificates in car collisions?
Actually, I did receive a certificate in hit and run accident investigation from the Massachusetts Criminal Justice Training Council when I was a police officer.
Do you agree that what training you did have was rudimentary?
It probably was, yes.
Well, not probably. You've used that word before. Wouldn't you say that any training you have had has been rudimentary?
In terms of
Accident-
accident
Yes.
investigation, yes.
Have you ever testified as an expert anywhere in accident reconstruction?
No.
Do you know what ACTAR is?
ACTAR?
Yes.
No.
It's a certification group for collision specialists, accident reconstructionists. Is it fair to say that you're not ACTAR qualified?
Objection, Your Honor.
I'm going to sustain the objection.
Are you ACTAR qualified?
No, and I don't know any physicians that are.
Have you ever gone to a scene of a car collision and done an investigation and written a report and reached a conclusion about the cause of the car collision and the injuries that were related to that car collision?
No, that's outside my scope.
It's beyond your expertise.
Beyond the expertise of a physician, yes.
Right. Yet, yesterday, you offered the jury your opinion that these wounds were not consistent
Because it's the
with
wound,
car
not the
collision. Did you offer that
reconstruction.
opinion yesterday?
Wounds are in my area of expertise. So yes, I am very comfortable talking about wounds from a variety of sources, including motor vehicle accidents.
I'm sorry, I didn't want the siren to interrupt you.
Okay. Yeah, wounds are definitely within my area of expertise.
When you considered your opinion to this jury that this was not caused by a car collision, do you know what type of vehicle is in question?
Yes.
Have you ever studied the vehicle to look at the make, model, the height of different things like the bumper, perhaps the taillight? Have you ever studied that in this case?
I'm aware of some of those factors,
Have you
yes.
studied that before you
Studied.
gave this opinion? Yes. Did you go and actually look at the photos, do any measurements before you came up with
Did
this
Hank get
opinion?
his hair
Bef-
dyed?
Not before I came up with the opinion, no.
Did you ever look at the damage to the rear taillight of the defendant's vehicle and see if it was in similar or the same height of Mr. O'Keefe if he was standing up? Did you ever do that?
Objection.
I have looked at
And
photographs.
when you looked at the photos, did you see that a 6'1" man like Mr. O'Keefe, if he stood, his elbow would be the exact
Objection.
height of Miss Reed's broken taillight? Did you notice that?
I noticed that there was a similar, that the height would be similar. The height of the elbow and the taillight, yes.
Did you look at photographs of Miss Reed's broken taillight and see if where the break was corresponded closely or directly to the same height as Mr. O'Keefe's elbow and forearm?
I did.
And did you see that it matched up height-wise perfectly?
Close, yes.
You have really no, respectfully, comprehension about the details of the car collision in this case, do you?
I have some understanding of the allegations of a possible collision.
Do you know how slowly or fastly Miss Reed's Lexus was traveling on January 29, 2022, at about 12:32 a.m., right around the time that you think these wounds happened?
I have some knowledge of the alleged speed at the time of the alleged collision.
Do you have any knowledge about the surroundings, the outside, whether the ground was soft or frozen?
I understand that there was snow on the ground.
How much snow do you understand was on the ground when Mr. O'Keefe's body first landed on that ground?
Several inches.
Where did you get the information that there was several inches of snow on the ground when Mr. O'Keefe landed?
You asked me when?
Where did you get that information from?
A report that I read.
Have you ever seen the videos or the reports that when Mr. O'Keefe was moved from the ground, there was grass and dirt under him?
Yes, I saw a picture.
Okay. Not 2 inches of snow. The ground, the cold, hard ground. Did you see anything that said that?
Yes, I saw an area of grass in the picture.
Have you ever looked at Mr. O'Keefe's pants to see if there was any dirt or grass stains on the back of them?
I've seen pictures.
Did you realize when you were forming your opinions about the source or the genesis or the cause of these abrasions, did you look at his pants and study whether or not he landed on snow or landed on the hard ground?
I did not see any evidence of grass on the pants.
Did you ever actually look at the pants?
I don't know if I looked at the pants.
So when you say you didn't see any evidence, are you saying you didn't look, or you looked and you didn't see anything?
I looked at pictures of the clothing that was available at the hospital.
Did you look at anything about the pants, photographs, the actual pants themselves? Did you look at them?
I looked at the pictures that were available at the hospital of his clothing that was on the floor.
Were part of the photographs that were available for your review and your conclusions of differential diagnosis, was part of that evidence photographs of the back of his pants?
I don't recall.
If you're going to make an opinion about something outside your expertise, that this was not consistent with a collision, wouldn't you want to see as much information as possible?
So let's, we'll come to Sidebar, Mr. Chairman.
Okay, finally, we get an objection here. Before I discuss that, I just want to thank Curious Law Tuber for gifting one Just to Serve TV membership. We truly appreciate that. Okay, this is now, you know what has happened here. Hank Brennan cannot shake her on the dog bite, right? He cannot shake her on the dog bite at all. I mean, and she's talking about, she's very good. She's not talking about that you can take one wound. You have to look at the whole pattern. You have to look at the whole picture. So now what he's trying to do is go back and say in a differential diagnosis, didn't you see this? Didn't you see that? Are you an accident reconstructionist? Therefore, couldn't you have, with regard to that, you didn't really do a good job because you didn't discount the other stuff. And she said, look, I've seen, I'm not an accident reconstructionist, but as a doctor, I know wounds. And remember Judge Kenney in the first trial, you couldn't talk about the wounds. You couldn't talk about the cause of death, the manner of death, unless you were a doctor. Well, you know, here she is. She is the doctor. And he really, I don't think he's shaken her. And I think that she looks very good before the jury. Juries like experts that concede facts that are irrelevant to anything, right? You know, why fight on something that's irrelevant? She had a certificate. She agreed it was rudimentary, but she had a certificate. But she's a doctor. She's seen all sorts of injuries from automobile accidents. She discounted that, especially in light that she could say within a reasonable degree of scientific certainty, the whole wound pattern on John O'Keefe's arm was indicative of dog bite. And this whole thing about you have to have, you know, where they're going. They've measured what they say, Chloe, and they're going to say, well, her bite mark doesn't match. We heard Chris Fabricant from the Innocence Project. You cannot say that things are specific. It has been proven objectively in a lot of other courts, they don't even allow a specification on even a human bite mark. Why? Because the skin moves. It moves and it shrinks. And even as you die, there may be shrinkage. So if you're imagine a dog bite. Have you ever been bitten by a dog? I have. As a kid, I was fearless. I have dog bite. I still have dog bite scars here. I have dog bite scars in my hands. I have dog bite scars everywhere, right? You're not staying still and saying, "Oh, nice puppy, keep biting me." You're moving away. The dog is moving. You're moving. People are sometimes pushing the dog off you. All right. Any of you here, raise your hands. Tell me how many of you have been bitten by a dog. All right. It's not as common, it seems now, except when you have pit bulls that you see that kill. I see it's always pitties. And I know people say, the pitties are bad. It's the owners. And that may be true. But usually when you see like a kid left alone, it's some kind of pitty that's biting. I never seen Tues, a standard poodle, being in the news for killing somebody. All right. So I think there's more control of dogs now. People have dogs on leashes and all. But, if you've been bitten by a dog, yes, I see some people have been bitten in their butt as a dog chases you. You're moving. All right. I think he looks like he can't get anything out of her. Now he's trying to push his case through her. Did you see that the 6'2" man standing next to the car? And she says yes. I mean, she could say, look, I like the fact that she's not fighting with him there, because let Alessi and let Alan Jackson, let the team deal with the fact that accident reconstructionist Welcher was an idiot in terms of his testing. And I say that because Stephen Plord, who was on our show, showed that he didn't go far enough. You just can't run up to a car and go like this. All right. You just can't run up to a car and go by this. Robert McNeil says, just picking somebody, I got bitten by a pit bull. Those are dog bites. Yeah, those look like dog bites, right? Let's see. I've been bitten in the mouth, and Melissa V, and face by a German Shepherd. I've had Shepherds before I had poodles and all. But here, Sky Scores page, last week I got an accidental bite while playing with my standard poodle. Oh my goodness. And I had scratches and bruises the same, but it was accidental, right? It was a play bite. The scratches, I mean, we all get scratches from our puppies, right? When we have a puppy, they kind of nip at you and they're playing with you. They don't do anything. Micah says, Jess Machado, Leslie is loud. He is using hand motions. He is leaning down towards Kenney as she leans down and now pointing at Brennan. So this is because this is really ridiculous. And I would have been a little bit more active, but I think what happened, he thought they made a decision. It's very hard. You have to trust a trial attorney. When you think your expert is handling the cross-examination from a bully, you may let them go. You may let them just continue because, hey, let the expert handle it until you have to start intervening because it gets to be too much. All right. Now, again, you see what's happened here. He educated her by doing the Dalbert hearing. And when she's giving her opinion, she's very good within a reasonable degree of medical certainty. He says, what is that? And she says, what it is. She says, doctors are never 100% certain. Even when you do DNA, there's not 100% certainty. And she's saying based on her opinion, and that's why you have experts, they're allowed to give an opinion, what she's seen over her many years being both a police officer, an emergency room person who had an interest in dog bites. She's written articles. This is her opinion. So now Brendan's trying to go at her with regard to the accident reconstruction. Let's come back and let's see how he picks up, and we'll be able to tell what happened at Sidebar by virtue of how Hank Brennan picks up. I don't trust Judge Kenney on anything regarding being fair to the defense at this point. I did at the beginning, but I don't now.
Dr. Russell, before you gave your opinion to this jury, suggesting that Mr. O'Keefe's wounds on his arm were not caused by an impact with the motor vehicle, did you go to the scene of 34 Fairview and look around in the corner of the yard?
I did not need to.
Did you?
No.
Did you look at photographs to see if you could identify the land, the dirt, whether it was flat and smooth or whether it was bumpy, whether there was rocks or debris in that area?
Yes.
And you went there and looked at it?
No. You asked me if I looked at photographs.
When you looked at photographs, did they show whether that ground had any bumps or divots or rocks?
It showed that there was a little bit of a hill in that area.
Could you tell from the photos, were they close enough so that you could see what the makeup of the ground was?
No, most of the ground was covered with snow.
Did you know that there were bushes right near the area where Mr. O'Keefe was found? Bushes with branches. Did you know that?
Not very close, no.
Did you see the bushes in the photographs near where Mr. O'Keefe lay?
Right where he laid, no.
How about next to him on the left? Did you see those bushes?
Bushes.
There was some other stuff there in the photograph, but the photographs I looked at were not of excellent quality.
Do you have any understanding or information you can share with us the angle of Mr. O'Keefe's body at the time of any impact with a motor vehicle?
I
Neither
don't
do
see
you,
any
Hank.
medical evidence that there was impact with the vehicle.
Yes, there
Do
you
know
go.
Mr. O'Keefe had
Boom.
other injuries other than just the superficial abrasions on his arm?
Yes, but no significant injuries below the neck.
How about on the head? Was there a significant injury?
Oh, yes.
When
No
you
significant
considered
injuries below the neck.
excluding car collision as a source of those wounds, did you consider in your history that you've seen, or have you seen, let me strike that, have you seen in your history multiple victims of a car collision where
Many.
they were
Sorry.
hit by the same car?
Probably, but I can't recall a specific case.
Would you agree with me if a car ran into a group of people and caused a number of injuries, those injuries to different people could vary wildly from one to another?
Yes.
Even if the car was going at the same
So
speed
what?
and ran into a group of people, those injuries could be totally dissimilar from one another, couldn't they?
Yes.
Some person, unfortunately, could be killed if the car was going fast enough and hit them the right way. Yes?
Yes.
Another person could have a less severe injury, maybe a broken bone.
But there's no, it's not
Yes.
like 10
Another
people
person in
outside
the
being
same
hit by a
exact
car in this
collision
case.
could have scratches.
Yes.
In fact, there are cases, I'm sure you've studied, where people have been hit by cars, thrown airborne, and had no wounds on them at all. Have you seen that?
Could you repeat that?
Are
No,
there
because I
instances
treat
that you
people who
have
have
considered
wounds.
where a person is hit by an automobile, actually thrown, removed from the ground, thrown in the air, and gets up unscathed with no injury at all?
No significant injuries. Correct.
So a car collision can cause wildly different injuries depending on many, many unpredictable factors. Isn't that fair to say?
Yes.
When a car, a vehicle's involved, have you ever been involved in treating patients that receive injuries from broken plastic or broken glass in a car?
Yes, many times.
And when you've seen them, have those injuries differed on a person as far as cuts and abrasions from glass or broken plastic?
Yes.
When you were considering excluding car impact or collision as a source of Mr. O'Keefe's injuries, did you consider whether or not Mr. O'Keefe could have been struck on the side of the car in a clip-type event rather than being run over?
Yes, I considered multiple scenarios.
Had you, or do you agree that injuries from a side swipe or from a clip could be much, much different than a full rear or front impact being run over?
They could be.
Did you do any study in this case when you were thinking about excluding the car collision or impact as the source of Mr. O'Keefe's abrasions about what his body posture was, how he may have hit a motor vehicle? Did you consider that?
I considered several scenarios,
And when you con-
several different positions.
And when you considered that, what did you conclude as far as Mr. O'Keefe's body movement at the time of any potential impact?
Than a dog
First of
biting.
all, I didn't see any medical evidence that there was an impact. There were no significant injuries from the neck down, no fractures, no bruise, no internal injuries, no lacerated organs, no collections of fluid in the lung cavities, the abdominal cavity. No significant injuries from the neck down, and so yes, I used that and tried to put that in a scenario of his various positions. What could he have been? Standing, kneeling, sitting, lying down on the ground. I did all that.
You were a police officer before you went to medical school, weren't you?
Yes.
You had arrived at scenes of many, many car collisions, hadn't you?
Yes.
What is oftentimes left behind after a car collides with an object?
Debris.
Objection.
Debris field, yes? Did you look at the debris field in this case?
No.
In the cases that you went to wherever you saw car collisions, some of the debris that you would find could be broken glass or broken plastic. Isn't that fair to say?
Yes.
And when you went to those scenes, you would often find broken glass or broken plastic in a debris field near where the victim was found or laying. Isn't that fair to say?
The debris field would be usually near the collision, if there was a collision impact.
And when you were considering excluding car impact or collision in this case, did you take a look at the entire debris field to determine how close or far it was from Mr. O'Keefe's
There wasn't
body?
any photos of the debris
I couldn't
field.
tell on
Did you
the
ask
photographs.
question? I'm sorry, please finish.
I couldn't tell from the photographs.
And before you came to your conclusions, did you ask anybody for any more information so that you could make a fair assessment of that information?
The injuries here were so characteristic that, and they were so parallel to one another that I couldn't even imagine pieces of glass or plastic or even metal lining up to cause those injuries, lining up in a certain fashion to cause those regular striations.
Rather than imagining, did you make any effort to actually seek information so you could identify and evaluate the debris field around Mr. O'Keefe's body that morning?
I did not.
Have you ever, as a police officer looking into car collisions, ever hear the term knocked out of one's shoes?
Not as a police officer.
Have you ever heard of that as a medical expert?
I've heard of it as a civilian, yes. Not as a medical expert.
Can I have Exhibit 74B, please? In your study, before you gave an opinion excluding an impact or a collision as the cause of Mr. O'Keefe's abrasions on his arm, were you aware of this photograph where Mr. O'Keefe's sneaker was found on the side of the road?
I am aware that that there was one shoe off, correct.
Were you aware that it was wedged right up against the curb? Were you aware of that?
I'm aware, I have been aware of that, yes.
And when you came to your conclusion that you offered that the injuries are not consistent with a impact or car collision, was this photograph part of your consideration?
No.
Could I have Exhibit 99D, please? In your study to give an ultimate opinion, where you suggest that a car collision or impact was not the source of Mr. O'Keefe's arm injuries, were you aware of this photograph of Mr. O'Keefe's hat found at the bottom of the snow in the corner of that yard?
No.
Do you see underneath that hat there was not 2 inches of snow? It looks like dirt and grass.
Yes.
When you gave the opinion that he was on 2 inches of snow, would it be important to know whether or not he fell directly on the hard ground or on snow?
It could be important. However, it could be. If the ground was frozen, if it wasn't frozen, it could matter a little bit.
Exhibit 73, please. When you were reaching your conclusions, you said you considered some of the debris field. Did you see this photograph of a piece of taillight that matches the defendant's taillight of her SUV? Did you consider this piece of evidence that was found in the debris field?
Not specifically.
76A, please. Same question. Did you consider this piece of the debris field when you were coming to your conclusions that you offered us yesterday?
I considered that there would be several pieces of metal, plastic, or glass at the scene.
Did you consider this picture of plastic from the defendant's rear taillight found at that scene? Did you consider that before you gave your opinion to the jury?
No.
You can take that down, please. Would there be any significance in your study, in the foundation of your opinion, that a collision or impact did not cause Mr. O'Keefe's wounds on his arm? Was it important for you to determine whether or not the taillight to the defendant's Lexus was broken early that morning?
I think there needs to be more to the question.
Okay. When you were considering potential causes of injuries, did you know that the defendant's Lexus rear right taillight was broken in missing pieces?
Yes.
Was it important to time when that taillight was broken?
What do you mean by time?
You understand that Mr. O'Keefe was found on January 29th, 2022, yes?
Yes.
Early morning hours.
Yes.
When you were making your differential diagnosis, was it important for you to learn whether around that time the defendant's taillight was broken?
It was important to know. I still don't understand the question. I'm having trouble understanding the question.
It's my fault. I'll try to ask it a different way. You were considering as much facts and information as you could to give a solid opinion in front of this jury, weren't you?
Yes.
And you ultimately have offered an opinion that the wounds to Mr. O'Keefe's arm are not consistent with an impact or a collision with a vehicle, yes?
That's correct.
You know the vehicle in question in this case is the defendant's vehicle, her Lexus.
Yes.
And you learned that her right rear taillight was broken and missing pieces, yes?
Yes.
Did you want to know if there was any evidence depicting when that taillight was broken, in considering this conclusion?
Yes.
Did you know that there was video from 5:07 a.m. showing that the defendant's taillight was missing pieces?
Objection, Your Honor.
I'm going to allow that.
Of course.
Not at the time, but I expected that if there were a collision, that there would be pieces of the car, involved. So it didn't really make any difference.
When you were trying to rule out a collision between Mr. O'Keefe and Ms. Reed's vehicle did not cause these injuries, did you want to seek that information about the broken taillight and date and time it?
A broken taillight in and of itself could not cause those injuries. There would have to be multiple projections from the vehicle that were lined up in certain pattern to give those parallel marks all in the same direction. So, that's why a broken taillight could not have done that.
So in your investigation, you did not want to know when that taillight was broken?
Oh, I did, but for information only.
Did you review the ring video from 5:07 a.m. at Meadows Ave?
Later on, later on in the, not initially when I had the initial records, but later on I did.
Did you have that information before or after you arrived at your opinion?
Oh, after.
So you had already arrived at your opinion, then you received new information, which was that ring video, correct?
And it confirms, yeah.
And then you received more information. Did you receive photographs from a dash cam during a wellness check showing the defendant's Lexus missing pieces of her right rear taillight at about 8:03 a.m. that morning?
Would that be? I'm not sure which video that is.
Well, it's not a video. If we could put up Exhibit 10. It actually was from a video. Did you look at this picture during your differential diagnosis?
I think I've seen that picture before.
And
The
could we
car,
have
the vehicle parked, yes.
Exhibit 11, please. Did you consider this picture in your differential diagnosis?
I don't know that I ever saw this picture.
Seeing this picture, do you see that the right rear tail light is missing pieces?
I can't even see that. Oh, yes, I do see that. But again, these pieces would have to be lined up in a certain configuration in order to cause those wounds.
So seeing this photograph now for the first time, it doesn't in any way shape or change your opinion, does it?
No.
You had, as a police officer, when you're excluding the source, and in this case you're saying the cause of Mr. O'Keefe's scratches on his arm could not have been from a collision, do you listen to witness testimony or do you review witness statements?
Objection, Your Honor.
I'm going to allow that. Just, do you do
Oh,
that?
of course she is.
As a police officer, in investigating a car accident, is that what you're asking me?
Yes.
Did I listen? Did I take witness statements?
Yes.
Yes.
And do you value the statements as part of your analysis?
I give varying values depending on what I believe to be the veracity of the witness.
Have you listened to the statements of the defendant herself in this case regarding potential impact?
No. What do you mean?
Well, have you seen any statements made by the defendant to any media about potential impact
No,
or
because we
collision
do
in this
science
case?
based on what we see. We
Oh,
don't
are
need
you
to see what the
referring
defendant
to what you've asked me previously about? Did I hit him or something of that? What do you mean specifically?
Have you seen any of the media statements by the defendant, 2020, Nightline, docuseries? Have you seen any of these statements in your analysis of whether or not there was a impact, a collision between the defendant and her Lexus and Mr. O'Keefe? Have you seen any of those?
I did see some statements, but that was after I rendered my opinion.
And some of those statements, after you rendered your opinion, did some of those statements come from the defendant herself?
Yes.
And when you listen to those statements, did you hear any of them talk about the idea or issue of collision or impact?
Yes.
And when you listen to those statements after you formed your opinions, did in any way change the analysis of your opinion?
Absolutely not. And I'll tell you why.
Please do.
Because the defendant had undergone a very stressful event, finding her loved one in the snow. And so after a stressful event, many people suffer from what's called an acute grief reaction. It's very common. And they do things that seem to be irrational. They ramble. They act bizarrely. They make statements that are irrational, that don't make sense, and they oftentimes tend to blame themselves for whatever has happened. I've seen this many, many, many times in the emergency department.
Does this happen moments after a stressful event?
Oh, yes.
Does it happen months later when you go on 2020 or Nightline?
I've never seen that situation.
No. Does it happen a year later when you go and speak to documentarians and be interviewed? Is that the same kind of condition you see a year later, a year and a half later?
A grief reaction can last years. It usually is very brief, but it can last years.
Now, when you looked at the clothes in this case, Mr. O'Keefe's clothes, you are aware that those clothes were swabbed for DNA traces, aren't you?
Yes, I'm aware that some of the clothes were swabbed for DNA.
Right. Could we have Exhibit 147B, please? On the right arm, there were a number of different tears in that fabric that you looked at, weren't there?
Yes, there were a number of small round holes in that
You're
fabric.
aware, aren't you, that those holes were swabbed for traces of dog DNA.
Objection, Your Honor. I'd like to approach, please.
Okay, come on up.
Okay, we discussed this last night on the show. This is irrelevant, okay, whether they're swapped for dog DNA, because they don't swap all the areas. Plus, the clothes were in the snow. Plus, you know, we know that Karen Reed and we know that Kerry Roberts was on top of those clothes with John O'Keefe, and their DNA didn't show up on the swabs as they should have. Plus, we do know that there was some pig DNA on the swabs, and I think, if I recall, Tubi's been barking at me because I took away his pork liver, you know, his pig ears and all that type of stuff. So if a dog had been chewing on that, you're going to get some transfer in there that may be shown. And there was pig DNA that was unexplained. So all of that is irrelevant. So here's what's happened. Hank Brennan couldn't shake her from her opinion. He couldn't do what he was trying to do in the Dahlberg hearing, because she was now educated and all. And she didn't trust him from yesterday. So she wants to see all the transcripts and knows how he didn't give them all to her. And even when he did, she said, okay, well, but here's what I said up here, and makes sense. And so now what he's doing is he's trying to argue his case with her, using her experience as a police officer, that there was a debris field, all sorts of stuff and all. But we know that the debris field may not have been there at a certain time. And she's going to hold tight. She says, I've seen all sorts of injuries from car accidents. I've been in an emergency room. I've seen vehicle impacts. There is no medical evidence that there was ever an impact. Then he said, well, did you consider clipping? She said, yes, I considered that. There was no medical evidence that there was an impact. And she got to say that 3 more times to him, or what, you know, in this cross-examination. So now he's going with a DNA area, which is really outside the scope of anything that she had with her direct. Now, is the judge going to allow it? Probably, because she allows everything. You know, she allows Hank Brennan to have fully throated cross-examinations. But when it comes to the defense having any cross-examination or sustaining any objections, we see what's going on in that courtroom. But, excuse me, I think she's holding her own. I think that she has been a great witness. I think she's been much better witness than she was in trial 1, much better witness than the Dahlberg hearing. She is holding on, and she's going to say it's all irrelevant. The reason we do, and I've heard my husband talk about this, the reason we do autopsies in science is because people say and see things. You know, you've heard about eyewitness testimony. That is not true. And so you look at the science to see what is valid and what is not. So people can say, I think I shot him. And it turns, there's no bullet wound in the case, right? You know, by the way, if you see a bullet wound, do you need to really exclude everything else? If you see a bullet wound that causes death, that actually causes the death of somebody, because you see hemorrhage? No. If you see somebody that may have hit marks and bite marks, do you want to do the testing for drugs? Sure, you may want to do that, because that doesn't exclude something. But I agree with you. I believe that right now, Dr. Russell is by Hank Brennan. She's getting into stuff she wouldn't be able to get in on direct examination. She got in that she actually considered a clipping, and there's no evidence of a clipping. There's no medical evidence, and you wouldn't have these wound patterns on this arm, but the front and the part of the posterior of the arm, you know, because of the curvature arm, from that tail light. All right, period. You know, so this is where, by the way, yes, I don't know where Hank Brennan is going on the bushes. You know, that's the first time I've heard bushes mentioning. But this is just an amazing defense. Anika A said, I just had Dr. Russell explain away Karen's reactions after finding John. That seems like a big mistake. Also, Karen Reed never confessed to media, or whatever he's implying. Absolutely right. And you know how long grief lasts. But, you know, grief can last a long, long time. I still know people in grief like 50 years after a parent died. All right. Grief, everyone has an individual reaction to grief, and they can say and do things that, you know, you can laugh and then it's considered inappropriate, but it's a reaction to grief. You know, grief is really love, right? There's no other way around it. Love is grief. Grief is love. It doesn't necessarily, if you didn't like somebody, you wouldn't care what you did to them, right? All right. Riz asked a question. Didn't the judge limit Leslie from asking about the motor vehicle accident yesterday? Yeah, she did. But Hank Brennan can go right into it, and she's allowed that extra cross-examination. And the Leslie has objected. I think he let her go on because she was holding her own. She was doing a great job, but now he's doing some objections, and they're rightly placed. Although Hank Brennan doesn't really know when to stop. He got rammed with regard to the taillight couldn't cause the injuries on John O'Keefe's arm, period. She's the medical doctor. All right. And remember, at the first trial, she wasn't allowing accident reconstructions to say anything. We're going to see whether she gives ACA the same ability she gave Dr. Judd Welcher at accident reconstructionist when we get there. And then we'll really know whether or not there's some bias in that courtroom. Right. To make it count, Linda, has your husband been tasked with a hard cross such as this? My husband's had, after 50 years, every single type of cross you can imagine. All right. My husband can handle any type of cross. You may not like his opinion, and that's what we normally say. See, if people don't like his opinion, then they you didn't do a good job. But Michael can handle any cross. I have no issue with regard to that. I am the one that can get upset if I see a cross. I generally don't watch his cross examinations. He's been doing this a lot longer than I have. I have cross-examined medical experts. I've cross-examined forensic pathologists. They don't usually like the way I cross-examine because I make them speak plain English. But the problem with cross-examining my husband is he speaks like Dr. Russell, plain English. And, the best expert will concede issues, that is beyond their pale. So, let's see. Dizzy, let me just answer that. It was a great answer, Yvette. They swabbed different areas but didn't document and only use one swab. Absolutely. And that is totally ridiculous protocol to use one swab on different areas. Plus, they didn't really swab all sorts of areas, okay, on the clothes. And then the clothes were outside in the snow. So anything, a lot of DNA, if it's just minor, could have come off. And there may not have been that much saliva either.
While you're sitting here, so we're going to continue what we're doing, but we will give you the morning recess. So that's about a half an hour.
They're going to continue and then give the morning break, or they're taking the morning break? I kind of missed it because I was yammering. I'm sorry, guys. I guess they're going to take the morning break, and they're going to give Hank more time on the break to try to hone his question. But let's go through. And by the way, actually, before I go through this, I want to have some breaking news that's being played. Breaking news, okay? All right. Let's see if we can get the breaking news. Can we get the breaking news? There we're going to go. The breaking news. I don't know. Are we able to get the breaking news? Michael Bryant worked so hard on that breaking news sound. Well, okay, I can tell you about it. All right. And wait, there we go. We're going to talk about it instead of telling you about it. Yes, we have breaking news. Michael Bryant spent all last week investigating the Madeleine McCann. You can put it up. That's fine. That's great, Dizzy. That's great. The Madeleine McCann case in Praia de Luz, Portugal, right where she was from. He took us right in front of the building. He talked to Scotland Yard. He called the authorities. And guess what? After some pretty probing questions by Michael Bryant. Oops, what's going on here? Sorry, guys. I just want to tell you, Portuguese and German police renew their search for Madeleine McCann. We'll talk more about it. Michael Bryant, you are a star for Justice Served TV here.
Thank you, Your Honor.
Okay, let's listen to Mr. Alessi.
Attorney Brennan, just with regard to Dr. Russell, in open court in front of the jury, used the concept of DNA in this case. He has introduced it and brought it in for the very first time in front of the jury. He has done so intentionally. He intentionally brought up DNA. Based upon that intentional mention, the defense moves strongly, vigorously for a mistrial with prejudice. A mistrial with prejudice. There has been no mention in this trial of DNA with regard to the topic, with regard to what Mr. Brennan has raised. There has been none. Specifically, the prosecution had, in the first trial, had a witness, Terry Kuhn, with regard to DNA. For whatever reason, The prosecution has chosen not to bring that witness in who would testify perhaps to DNA. As a result of that strategic decision that the prosecution made, there's been no mention. I want to be very clear. The defense has been incredibly assiduous and meticulous about not mentioning DNA in any fashion, directly or indirectly. With regard to the hoodie shirt and the hole, the only thing that was adduced in direct examination was a mechanical function simply of Dr. Russell testifying that a dog tooth went in and came out and caused a certain mechanical effect on the yarn. Nothing even close to the mention of DNA. With regard to representations that Attorney Brennan has made that somehow there was a hearing that we were on notice, it is completely incorrect. Show me the hearing, show me the transcript where that has been discussed. The prosecution has also said, we're going to, or we always intended to bring on rebuttal Dr. Crosby, who would talk about the supposed absence of DNA, the alleged absence of it. The problem with that of trying to rescue the mistrial that the prosecution has caused with prejudice is that Dr. Crosby could never testify about such a topic, because I would object and object because there would be no foundation, because the prosecution strategically chose not to bring in the foundation whatsoever in this trial. The fact that they did it in another trial, or perhaps did it, is irrelevant to this trial, as Your Honor has admonished several times. What happened this is a new trial, and whatever happens in the first trial is the first trial.
He is
so
loud.
In conclusion, Your Honor,
he woke up.
Because of the conduct of the prosecution, and specifically the intentional mention of DNA, the prosecution has put in the jury's mind that topic that is irremediable. That cannot be reversed. That cannot be cured. That cannot be ameliorated with a jury instruction. That cannot be dislodged. The prosecution has to suffer the consequences of its own intentional actions of bringing up that topic. Ms. Reed is entitled under the Constitution, under the Massachusetts Declaration of Rights, to a fair trial. And what has just happened is antithetical, abhorrent to a fair trial. The only remedy is a mistrial with prejudice.
Whoa.
Thank you.
Oh, okay, thank you. She's so dismissive. She's so dismissive.
Inquiring of Dr. Russell about the absence of dog DNA is not only proper and permissible, it's essential, and the Commonwealth is entitled on cross-examination to explore theories and facades that the defense creates if there is actual evidence that undermines or contradicts the representations that they are trying to portray to this jury. Let's be clear. The defense is on notice that there is no dog DNA in the sweater of John O'Keefe. Let's be clear. The defense is on notice that we were not going to try to disprove all of their varying theories in our case in chief, but if they were going to propose theories that we thought were unsubstantiated, we would do so in rebuttal. It is clear these witnesses are on the witness list. More so, the conversation and examination of Dr. Russell is replete in the historical record of this case. Dr. Russell herself testified on December 12, 2024, that she did consider the absence of DNA in her opinion. She disregarded it She discounted it. She created false theories about the potential destruction of it, but she did testify this was part of her consideration for her opinions. Again, on January 7th, 2025, Dr. Russell again discussed the absence of dog DNA in John O'Keefe's sweater. Now, it may be inconvenient, it might be hurtful for the defendant's theories, for the creation they portrayed
talk about DNA. They have no
for this
witness
jury
expert on their list
yesterday.
to
But
talk
it is
about it at
not
this point.
improper, it's not unconstitutional, it's not irrelevant, it's very relevant. It is powerful evidence that the Commonwealth has to undermine this idea that the linear superficial abrasions on John O'Keefe's arm were somehow caused by a dog. They, on their case in chief, tried to create impressions about the cause of the abrasions to Mr. O'Keefe. The defense does not get to pick and choose what words the Commonwealth can or cannot use. They do not get to pick and choose what parts of Dr. Russell's opinions are important and not important. Because they chose not to emphasize, highlight, or discuss the absence of dog DNA on direct does not mean it's beyond the scope of direct examination. It means they did not want to talk about it because it was not helpful to them. There have been countless cross-examinations in this case where questions are asked beyond the scope of direct. This is not beyond it. It goes to the heart of her opinion. If I cannot cross-examine her, as proposed by the defense, about the heart of her opinion, she shouldn't give it. She shouldn't have an opinion, because you can't come in and just take the favorable factions to yourself and leave out reality. I intend on asking Dr. Russell about her opinions
all the issues
about
with regard to
the
the
role
testing
that
on
the
that
absence of
sweatshirt.
DNA played.
Now you bring
Also,
it
I
in, and
expect
Dr.
to
Russell is
ask
not a
her
DNA
about her
expert.
attempt to diminish or demean the DNA evidence because it shows her inherent bias in all of her opinions, where she acts as an advocate, not as a scientist or a doctor. It is admissible evidence. We intend on using it. And when she returns to the stand, these are the very questions I'm going to ask her.
Your Honor, may I have a brief 1 minute?
Sure, go right ahead.
Thank
Mr.
you, Your Honor.
Wilson.
Your Honor, a key misstatement of fact that Attorney Brennan just made. He said that Dr. Russell talked in prior proceedings and hearings about dog DNA. The record is abundantly clear. She only did so in response to a question from Mr. Brennan. I have the transcripts right with me. She never raised it affirmatively. She gave her opinion that these wounds were to a reasonable degree of medical certainty from a dog. Mr. Brennan on cross said, did you consider, and this is in a prior proceeding, did you consider DNA? She gave her answer. She didn't raise it. I heard it. I was there. Your Honor was there. So this impression that Mr. Brennan is trying to give, that somehow the defense brought this topic up before, is incorrect. The second point, Mr. Brennan needs to have a good faith basis to ask the question. To have a good faith basis, he has to have some admissible evidence that he's got for it. He has no admissible evidence on dog DNA with regard to the arm. He knows he doesn't. He strategically chose not to bring that evidence in this case. Now he's saying he wants to use it. That would be improper in this trial for that reason. The other 2 points quickly. Mr. Brennan alleges an absence of dog DNA with regard to these wounds in the right arm. There was no swabbing of the wounds of the right arm of Mr. O'Keefe. That is a major, major investigative flaw in this case. That should not be befallen upon the defendant. Secondly, there are, with regard to the hoodie that was one, I believe, swab taken, and we don't know much about it, but what we do know about it is there are horrible, tremendous chain of custody and care with regard to the hoodie, conceded, virtually left on the floor of the ambulance, left on the floor of the hospital, carried around by Mr. Proctor for weeks, maybe even months, not submitted for testing for months. There are huge issues that prevent a fair determination about whether there was even proper determination of whether there was DNA or not. So in conclusion, Your Honor, the defense has never brought up DNA or alleged absence with regard to the right arm of the hoodie. It's always been the prosecution. We were meticulous and assiduous in not doing it here. The prosecution needs to live with the consequence of its action. This is remediable, and I respectfully submit warrants only one ruling respectfully, and that is this trial must be declared a mistrial with prejudice.
I have 30 seconds.
Sure.
The defense can pound their fists and yell as loudly as they want, but they can't change truth and reality. Whatever the motivation is for wanting a mistrial can't be based on a claim that the prosecution raised DNA for the first time with Dr. Russell at the Lanigan hearing. If we actually look at facts and reality, rather than making false claims about everybody in the courtroom and everybody else who comes in here, what we'll see in the transcript, and this is the December 22nd, December 12, 2024 transcript, I direct the court to the direct examination of the attorney who just accused the government of raising it for the first time. Despite his words, we have page 83, line 21. We have page 122, line 14. We have page 124, line 14. These are the words of Attorney Alisi on direct examination. And there are more. There are more. But that is enough for the court to understand that the representations are wholly mistaken by Attorney Alisi. Wholly.
All right, thank you. We'll give everybody a half an hour.
All right.
Okay, she's giving everybody a half an hour. The reason why, by the way, I talk over sometimes is because I need you to understand what the legal argument is that they're putting it into context, because I see a lot of people don't understand. But if somebody is objecting to that, I'll try to be more careful, but I have to tell you what is going on, because or else you won't understand why Alessi did it just then. All right. So let's go. What happened here? Just grab a sip of my running on Duncan, because we have a lot to talk about here, and the breaking news and everything else, and motions that are filed, by the way. All right. So I believe that what was happening is Hank Brennan was hitting a roadblock with Dr. Russell, right? He couldn't get her, shake her off. This is the whole pattern. It shows you dog bites or dog scratches. Sometimes you can't tell the difference. And there's one area that shows an upper and a lower bite, end all. And you don't measure things because the skin is movable when there is a dog attack, right? The skin is movable. And this is not a dog attack of a police dog that is trained to grab on and just, hold. Okay. This is a house dog that has bitten people in the past. Chloe had 2 bites that she put people in the hospital with. So this is not out of the blue that the defense is bringing this up. Okay. So he then started going on about the tail light and this and that. And she held her own because she said, look, yeah, I've seen accidents. I discounted. I looked at everything. I had alternative possibilities, and I discounted them given my experience and my training and what I see as a doctor in the emergency room. No, I'm not an accident reconstructionist, but it's the wounds that count. The wounds that are very important with regard to a strike, right? The wounds are extremely important. And I see no evidence of a car strike. And that's what Dr. Scorti Bello, who is also the medical expert, seen. Well, the prosecution can't live with that because they can't win this case with that. So they've been trying to go around it. So here now, he's trying to now, as we got to almost what we thought was going to be the end of the cross-examination, because he had nowhere else to go, brought up, well, did you know that there was no DNA found in the clothing of in the skin or whatever? I think he said skin, in the wounds of the skin. He may have said clothing, but Alessi said he said the skin of John O'Keefe's clothing. And this is, see, I think that it didn't Doesn't help the prosecution. I think there's ways to explain it. But what Alessi says, and quite clearly, and sometimes we miss the first trial from the second trial. In the first trial, I think they had certain DNA people come in to talk about this. This is where we learned about the pig DNA. But here, the prosecution made a determination not to bring that DNA testing up in their case in chief. Not to bring that DNA testing up in their case in chief. And technically, at the end of that case, that's where it is. You can't save stuff and say, well, we know the defense is going to go that this is a dog bite and then we're going to save affirmative evidence for rebuttal. What Alessi's saying is you made a strategic decision not to bring it up. Then you bring it up with Dr. Russell before we've had a chance even to attack the underpinnings and whether or not it's even admissible. And that's because the chain of custody of the clothes was such a mess. We know that Michael Proctor may have been walking around with him for 2 weeks. He may have had him in his office for 2 weeks before they were logged in. We don't know what the chain of custody was. We know that they're on the floor. And by the way, the socks, we've never even talked about the apparently missing socks that went to the ME's office but don't appear to be logged in into the chain of custody here. So the defense was going to argue and put on the record if they did the DNA that it shouldn't be brought in because the chain of custody on the clothes is so bad. You know, you have them lying in the snow. DNA, if it's very little, can go into somebody else's, can be wiped off, washed off, whatever, you know, by the snow, by packaging them incorrectly, whatever. And that would explain that maybe there was a minor swab of pig DNA. But the wounds themselves were never swabbed. The wounds were never swabbed. So what we're talking about is the clothing that has a problem. The sweater, or as Hank Brennan calls it, or sweatshirt, hoodie, as we have been calling it, they used one tip to swab like different areas. We're not even sure where. They didn't swab everywhere. And DNA depends on where you swab if you're going to get any DNA. And albeit, I rest my case when I say they don't find Kerry Roberts or Karen Reed's DNA on his hoodie, and we know that they were all over his hoodie. So the absence of dog DNA is irrelevant. And so the prosecution decided now to make it relevant, to say with the cross-examination at the very end when they can't get anywhere, did you factor in that there's no DNA on John O'Keefe's wounds, all right? Well, the wounds, number one, were not swabbed. The hoodie, there's problems with the chain of custody, whether it should be admitted. And you can't then save everything to rebuttal. And then what? We're going to bring the DNA expert in with their stupid dog expert. I'm going to call him stupid dog expert because Garrett Wing is going to actually be it's going to be an interesting discussion when we get to that. And so there we are. So the defense says, look, strategically, you brought this in. This has to be a mistrial with prejudice because, ladies and gentlemen, Judge Kenney, this is misconduct under the statute. This is basically misconduct under all the constitutional law provisions that you brought something in. The jury has no basis for hearing. They don't know what the problems with it. They don't know whether it even should be considered. And now you brought it in. And we're in the position that we now have to what? Wait until the Commonwealth's case? We can't remedy this. There is no way for us to remedy this. We can't ask Dr. Russell whether she knows about the problems in the DNA. We can't ask Dr. Russell about the chain of custody. We can't ask Dr. Russell about the swabbing of the different areas that aren't done. We can't ask Dr. Russell about that. That's not what she is an expert in. That's what I was trying to explain to you. I'm sorry if some of you got upset that I talked over Hank Brennan, but you needed to hear what the issue was, that why Alessi is making this, because he just made the motion for mistrial, but you don't understand the basis of it. So I'm trying to give you all now the basis of what went on. Okay, Anthony Benny says, if Hank didn't use this evidence and it wasn't used during direct, how can Hank even bring it up to argue this? That's the whole point. That's what the mistrial is about. You have no scientific foundation for this. This is a big deal. And what we heard, though, is you heard how dismissive, by the way, how dismissive the judge was, right? Very dismissive. Okay, I'll hear you. Okay, I'll hear you. Okay, I'll hear you. So she's going to go in a half an hour. She's going to look up. She's going to get some kind of case, and she's going to deny the motion. She's going to say something that will deny the motion. No, and the problem is that now the burden is now placed on the defense, right? Now the burden is now placed on the defense. all right, they now have a burden to discount the DNA, and it shouldn't be their burden. They should be able to discount it through cross-examination, not have an affirmative burden. And that's something that Alessi didn't mention, that by doing this, the Commonwealth has switched the burden of proof here, which is unconstitutional. I wish he had gone there, because that's the end result of why we're talking about this. All right. And sometimes in the heat of moving for a mistrial, you don't see it. But he should go back, and he should then come back and say, we want to add to our argument, Your Honor, this switches the burden. It puts the burden on us, the defense, to show why the DNA testing was wrong, and we shouldn't have that burden in our case. And we can't count on the Commonwealth bringing somebody in to ask them that. And it doesn't matter anyhow, because you look at the burden at the end of the time the case rests, at the Commonwealth's case. You can't then switch it and make the defense have this burden. All right. And he didn't argue that. Alessi, anyone out there talking to Alessi, tell him, because really that's exactly what's going on here. That's actually the better argument. It's the argument that puts, and I don't say better and I'm a better lawyer. I'm not a better lawyer. I just had time to think about it. It puts the idea of the mistrial in context, that it has switched the burden of proof here for the defense to now disprove the validity of this testing, or the how important it is of this testing. Okay, Nosy Rosie, Linda, can you pause the video when you need to guide us? We can't hear through your great knowledge. We'll try to do that. I'll try to hold off. It's just that this was so important. I was hoping that I could get in there, especially, oh, by the way, Linda does not have the ability to pause the video. All right, especially when this is such an important motion. That Judge Kenney is going to dismiss it, okay? Not dismiss the case. She's going to dismiss the motion. But unless he really should supplement the argument, he can come in and say, we want to supplement our mistrial argument, Your Honor, with a burden of proof issue, that what you have done is you have caused a burden switching here, switch the burden of proof on us to now disprove this DNA, all right? So that's what needs to be done here, and I really hope, I can't even tweet it. If somebody, Diz, do you think you can tweet it, that Linda says that what the real issue on this mistrial motion is that the Commonwealth has caused the burden switching and has put the onus on the defense to disprove the validity of the DNA testing, okay? All right, you have too many plates spinning. I know, so do I. All right, I can try to do it later, but I think it may be a little bit too late. Okay, so that's Dizzy she's one person, but she's a great person. I think actually Dizzy is a clone. I think Dizzy can clone herself, because she does 47 different things at the same time. She is so absolutely great. All right, that we tend to think that she can do more than she can do. Yeah, you know, I need an assistant right now to go to my Twitter account. But I'm telling you, because you're here watching this, you can all tweet it out. What I'm saying is, what this does, and unless he needs to take this argument one step further, what this does is to switch the burden of proof on the defense to now disprove the validity of the DNA testing, to show there isn't a good chain of custody, and to attack it. And that this whole idea of Hank Brennan introducing it has caused this burden shifting. So you can all go to your X account. You can all tag Bob Alessi, okay? Tag Karen Reed. That's the argument, y'all. That's why you're all here, all right? Now, is the judge going to ignore it? Yes. But I think it's very important that it gets on the record. It gets on the record. Skyhopper. Hi, Skyhopper. Skyhopper, as you know, is our 16-year-old supporter who's actually given her allowance here to Justice Serve TV because she likes to see Michel Bryant going to Dedham, and he will be there for our 1 o'clock, and we have so much to discuss. Okay, so this was a big deal. They are, yes, Charlotte Lynn, you've got it right. I mean, you've probably been to law school. They're burden shifting, denying Karen's right to confrontation. Okay, all right. It's absolutely right. It's and Hank Brennan with that, you know, I don't even think Hank Brennan, quite frankly, thought about what he was doing. I think he was so annoyed. I think he was so annoyed that he couldn't get to Dr. Russell that he just started going into all sorts of different areas. All right, that he started going to all sorts of different areas. Let me take a swig of my Dunkin'. And then he then said, okay, well, let me talk about the DNA with her. Now, we know that the DNA has issues because even if it is valid, DNA. The clothing issue, it shouldn't probably come in, but even if it did come in, they didn't swab his arm, and they only swabbed they used one swab on the sweatshirt, and it was in the snow, and the clothes were in a jumble. And I like the fact that actually they did find pig DNA, because I think it supports, quite frankly, the issue that a dog transferred it from one of their chewies onto them. Even in the little testing that they did do, that did stay on. Much of the pig DNA from that fighting down on the chewies. You know, you have dogs that chew on pig's ear, and I have a 2B that chews on pork liver. All right, and even last night when I held that, remember I held that, I smelled, oh, my hands smelled of so much pork liver. I had to go wash them afterwards. It just wasn't coming off. Okay. So that's where we are with that. Let me just now stop for a second. Let me go to the breaking news that we did talk about, and I'll come back to it. And the breaking news had to do with our own Michael Bryant and Madeleine McCann. Michael Bryant spent a whole week in Praia da Luz, right? He spent the whole week in Praia da Luz investigating the Madeleine McCann disappearance. He showed us actually the condo where she went missing from. He called Scotland Yard. He called the Portuguese police there. The breaking news has to do, and you can actually Google it, that now there has been they're going to reinvestigate her disappearance. This is a big deal, that the Portuguese and German police renew their search for Madeleine McCann. They're going to use radar equipment to scan beneath the ground as they look for evidence that could implicate. They're still going to consider Bruckner a prime suspect, even though he was just acquitted on his rape charge, because apparently he's still in jail. But I'm not sure. They need to find her. If they find her remains, that will lead to whoever maybe the suspect is. But amazing that Michael Bryant, who went there and dug and dug and called and called and called, just after he left yesterday, they announced the reopening of this investigation to search for Madeleine McCann. There she is when she was taken. She'd be 22 years old now. If she were alive, I don't think people think she's alive, but it was such a screwed up investigation from the beginning. While parents are always suspect, they just went wholeheartedly blaming those parents. It was terrible. It was absolutely terrible. They needed to look for everybody that worked in that restaurant. They needed to look for everybody the McCanns had contact for. They needed to look at everybody who may have been renting, because those condos can be big. Airbnb wasn't big back then, but rentals for people that come into the area, or workers that are in the area. How many times have we seen workers in the area that watch and follow somebody, or somebody in the restaurant who may have worked there, who saw that the parents were coming in and then decided, oh, this is a good time to take Madeleine McCann, because they targeted her. They targeted her, the young girl. And that, as we know, is not good. And I'm sure the parents live with that during their whole lives. Okay. But everybody screwed up this investigation. The Portugal police, I'm sorry, you were a mess. England, everybody. Okay. Michael Bryant has pointed out that, what is it, 13, what did he say? There was $13 million spent on this case. It was more than that. 13 million pounds he spent on this case. It's now going to be 17 million. And when he called them to ask what the new, he called England, the Scotland Yard, to ask what the new money was for, and they told him to fund the investigators that are being put on the case, and there were 4 of them from England. And we know now, and I want to let you go read this article in full, but the breaking news is that right after Michael Bryant went there, investigated, put the pressure on the Portuguese police, put the pressure on Scotland Yard, now we reopen this investigation, right? We reopen this investigation. All right, let me see. I'm going to read to you one little section here. A statement from her parents, Kate and Jerry McCann, and the family said, the years appear to be passing more quickly, and whilst we have no significant news to share, our determination to leave no stone unturned is unwavering. We will do our utmost to achieve this. Thank you, Kate and Jerry McCann. What a great statement from the parents. What a great statement from the parents. As we can see in April, the UK obviously added more to the investigation. But boy, what a time for Justice Serve TV and our investigations of this appearance to apparently put some pressure on the authorities. Thank you, Michel Bryant. We will see him, by the way, at lunch. He is on his way up to Dedham right now. So that was big breaking news. Now, let me tell you about motions that have been filed here since while we're waiting for the judge to come back. And I assume find a reason to deny the mistrial, somehow blaming the defense, okay, on it, as she normally does, all right? The motions that were filed, we finally have the defendant's motion that came up to reconsider the court's March 31st order excluding the testimony of defense expert Easter, okay? Let's see why they talk about it, they give an opinion, but the defense respectfully requests that this court reconsider its decision in light of the fact that the Commonwealth only called 2 police witnesses responsible for investigating O'Keefe's death in this case in chief. That is Canton Police Department Lieutenant Gallagher and Massachusetts State Police Sergeant Buchanan, both of whom refused to concede investigative failures. The defense should not be forced to adopt the self-serving opinions of these particular law enforcement officers regarding the reliability and the adequacy of their investigation. Recall, they talked about that their investigation was adequate. And it's important, says the defense, because expert testimony may be introduced to support a Baden defense where the subject matter lies beyond the common knowledge. Recall that the court initially said, well, the jury can see what the investigative failures. The jury can't see what the investigative failures are. And I'm going to go to the conclusion of this motion that they submitted. Trooper Buchanan and Lieutenant Gallagher's testimony revealed significant investigative deficiencies, yet these law enforcement officers have asserted that their investigation was not only adequate, but was conducted with honesty and integrity. The defense must be allowed to present expert testimony to place that conduct in context, explain its implications, and allow the jury to determine whether the deviations are material to assessing reasonable doubt, okay? For the above reasons, Ms. Reed respectfully requests this honorable court to reconsider its argument, its order excluding Michael Easter's testimony. I think they're absolutely right. I think that exactly what happened here was that those people said, those investigators said what they did was appropriate. And the judge is saying, well, no, the jury can use their common sense. No, they can't. They don't know how you have to separate witnesses. They don't know how you have to separate chain of custody. They don't know all sorts of stuff. They don't know how you lock down the scene. Remember, we had Stephen Plord even talk about accident reconstruction, how you're supposed to lock down the scene, not let anybody near it. They don't know any of that, okay? And to allow the court to say it's within the ken of the jury, why? Because maybe they watch CSI, is ridiculous. This motion should have been granted first. It should have been granted second. But again, I have no hope that the court will reconsider their testimony, because as we can see, if it's helpful to the defense, it ain't happening. And then she'll poo-poo the Baden defense, and she's going to poo-poo the third-party culprit defense, basically. Okay, so then there was a motion redacted for missing witness, okay? And it appears that the missing witnesses that the defense is talking about are 3, okay? It appears from my quick read of this that the missing witnesses they're talking about would be, because the initial point of the brief is foundational, would be Proctor, Higgins, and Albert, okay? As a matter of fact, in point A of their brief there, which is in bold, they say, A, Michael Proctor, Brian Albert, and Brian Higgins are all available and friendly to the Commonwealth. All available and friendly to the Commonwealth. Basic to the inference of the existence of the evidence of physical availability of the witness and the likelihood that he can be produced or summoned or otherwise. Michael Proctor, Brian Albert, and Brian Higgins were all listed on the witness list presented to this court by the Commonwealth. There has been no showing of physical unavailability for any of these witnesses. Additionally, the defense is informed that Brian Albert and Brian Higgins were both under subpoena by the Commonwealth. We're both under subpoena by the Commonwealth. And they continue to go on to say they were called in the first trial. Now, I expect her to deny this. Now, why is this important? This is important because if you get, this is to go to a jury charge of, hey, ladies and gentlemen of the jury, you're allowed to consider that the Commonwealth did not call 3 witnesses, Proctor, Albert, and Brian Higgins, and you're to infer that their testimony, basically it says you're to infer that their testimony would not be valuable, would not be good, would not be beneficial to the Commonwealth. That's in shorthand what the inference says on the jury charge. You can't get that unless you have the court find that there is the unavailability of the witnesses. Now, the good stuff has been redacted in this motion. This is a redacted motion. If we go down to page 5, you see redactions. There's all black lines, and it has to do, it starts with regard to the Massachusetts State Police conducted in this case prior admissions by Brian Albert and Brian Higgins that they left the rest of the group at 34 Fairview Road for a period of time in the early morning hours of January 29, 2022 to look at photographs of some other part of the house. And then it has the redactions. This is their case, obviously, and they don't want their case out there. And the question is, what other area of the house? Was it the garage? Okay, that's the question of what other area of the house they went to look at and why they went to look at these other areas of the house. But it's important on the prior admissions that Brian Albert and Brian Higgins left the rest of the group, because these are the third-party culprits that the defense is relying upon, that the judge says it's a close call. She'll see what evidence develops. So the defense wants a jury charge here that because there's these prior admissions, they would not be good for the defense. Now, what I expect her to say, mark my words, is that you too, defense, can put these under, you can subpoena these witnesses, and therefore, since they're equally available to you and equally available to the Commonwealth, you can call them and get that information. The problem with that is these are friendly witnesses to the prosecution. So then Hank Brennan gets up and he puts his whole case in through that, and that the defense can't really cross-examine them. They just have to ask them straight questions. And then it really then ends up hurting the defense, because in the defense's view, they're going to lie to protect the Commonwealth's case. So the defense wants that instruction there. So they want the judge to rule on having this instruction. Well, does this mean that the defense has decided not to call them? It could very well mean that the defense has decided not to call them. That's why they're asking for a motion here and an instruction, which the judge may say, I don't need to reach that yet because we're not at that stage, okay? So that is one instruction that came up. The other thing that was filed yesterday was Karen Reed's actual proposed jury instructions in this matter. I'm not going to read those. That's like 36 pages, okay? We'll have to go and compare these jury instructions to the standard instructions that are given in Massachusetts to see if there's any specified instructions very specific to this case. And that I have not had time to do. I will try to do that this afternoon when Michel Bryant takes over the show after lunch, when he is in Dedham, to see what the comparisons are to it. But yeah, I think I'm just taking a quick gander at it right now, because I hadn't seen it until it was filed, and I've been on the air with you this morning, is that there may be some specific instructions related to this case that are not in the normal code that is given, that the court usually adopts to give to a jury in Massachusetts. Now, recall, by the way, also in Massachusetts, just I'm going to remind you that the judge picks the foreperson, of the jury. And, you know, my view of it is the judge always picks the foreperson that I believe not only is attentive, but that she believes is pro-prosecution. And we believe that in the Aaron Hernandez case, and we actually made an objection to the statute that allows this to be done, suggesting that it was unconstitutional, because when you go to pick a jury as a head juror, as a judge, the foreperson, you're not then considering It's not really that you're considering everybody equal. I'm not talking about DEI. You have to consider everybody equal, right? And that it leads to the fact that maybe you have some biases. What if the bias is you don't believe the black person is smart? Now, I'm not saying that that's the case, but in the past, judges in the history of the United States have knocked off somebody that they believe whose ethnicity is not good for a case. I'm not saying that with regard to Judge Kenney. I'm just giving you that as an example. I believe that statute is simply unconstitutional, that there has to be a better way. If you say it's number one in the box all the time, fine. Then you're not using any judgment. You're not using any implicit bias to pick a jury for a person. Or if you do it by wheel, then again, you're not using any bias to pick an implicit person. But Massachusetts, I think, is one of 3 states that allows, if I recall, it was 3 states at the time I tried the Aaron Hernandez case, that allows the judge could pick a jury. Now, Michelle asked a really interesting question, just came through my feed here. Could the judge come back and say mistrial without prejudice? She could give what she could do is she can give we've seen this in the past, the defense a choice. You think there's a mistrial? If you want to take a mistrial without prejudice, I will give that to you. Defense is not looking to try this case again. They don't want a mistrial without prejudice. They want a mistrial with prejudice based on the misconduct by the special prosecutor, Hank Brennan here. And the court knows that. But could the court offer them that opportunity? Sure, the court can offer them that opportunity, at which point the defense is going to have to think about it if they think that has been done. I really think they have to go back and add to this argument, because it's not only that he introduced it, because she could say, well, I'm not going to allow anything to come of it in the rebuttal case unless he lays a foundation. But that's not where the prosecution is supposed to prove their case. The defense then has the burden shifting. Absolutely, this is burden shifted to the defense, okay, to show why that DNA finding that he has now mentioned interjected into the trial is not good. She could also say, well, Dr. Russell handled it and said it's not relevant. All right. Yeah. But hello. Yes, that was offered, Shy Gal, in the YSL. You're absolutely right. That was offered in the YSL. And it was not agreed to. It was not taken. Right. That was the issue that Doug Weinstein had. He wasn't going to take it. He wanted with prejudice, or he wanted a verdict, and he tried and got his verdict of not guilty. This would be interesting to see if we can get Doug Weinstein on to discuss this. This is a real interesting point here. Michel Bryant, if you are stationary, could you text Doug Weinstein, okay, to have him maybe come on tonight to discuss this? This is the exact issue. So let's see what happens. But the issue of mistrial and a verdict in the middle of a trial, this is Doug's area. Oh my gosh, I would love to have him on with regard to this. So let's see if we could. Let me while you're here. While you're all listening to me. He's probably still. He should be there, or he's probably just driving. Michel Bryant, can you please call Doug Weinstein to see if he can come on our show tonight? There is a big issue regarding a mistrial in this case, and it's a huge issue. I believe it involves more than a mistrial. It involves burden shifting, but it involves DNA. All right, I have to go back now. All right, let's go back into court and let's listen. She's got a lot of papers here this time. Let's listen.
All right, so the motion for a mistrial is denied. Your rights are saved. And Mr. Brennan, you can continue with this line of questioning.
Surprise. Not even the reasons.
Sidebar, the other issue that's under court's consideration regarding Dr. Walsh's opinion.
Yeah. I don't see it without a foundation. So if you can build a foundation, I'll consider it. I do not believe that foundation has been laid yet.
I would expect that foundation would need to be substantial, specifically whether or not it was relied upon by the witness.
Yes.
Could we do that outside the presence of the jury so that I don't ask the questions to come to the jury?
Yes, but not right now. They're on their way. All right. Do you have enough?
I'll work around it.
Okay.
Work around it.
Your Honor, I would object to being done outside the jury, that it should be done like I've had to do with several witnesses in front of the jury.
Okay. If that's what the defense wants, are you sure, Mr. Alessi?
Oh, wait, I'm sorry, let me confer with my... Yeah, okay. I am going to, yes, Your Honor, we are going to...
Oh, dear.
Thank you, Your Honor.
Okay.
You're on the way, Your Honor.
Thank you.
I'll be done very quickly, so I'll have to make that decision.
Is the lunch? Are the lunches here? Probably not. Okay. Are they still over there? How long they are?
Did you start yet, or can you turn?
I just, if they're downstairs on their way up, I don't want to stop them.
I can do it in 2 questions.
Yeah, please.
Oh. Excuse me?
They're still over this way.
Great. Okay, they're going to stay.
Your Honor, if it might help, obviously, I'll be subject to whatever, Your Honor, because based upon if Mr. Brennan only has 2 questions, I may have 30 minutes that I could, most 35, to finish up whatever redirect that I have, if that affects Your Honor's scheduling for the jury.
I just didn't want to stop them if they were on their way. They haven't yet gone downstairs.
All right. There was no surprise on
we'll
that
do this
ruling,
now.
right? So now
Okay.
she's going to let Hank Brennan ask the witness questions about Welcher while the jury's coming up or
Dr.
downstairs.
Russell,
as they-
during your review of the case, did the defense offer you the report of John C. Walsh, MD, Deputy Medical Examiner?
I didn't hear the whole
I'm sorry.
question.
During your review, the defense provided you materials. Did they provide you the report of John C. Walsh, MD, Deputy Medical Examiner?
I don't recall.
May I approach?
May I-
Yes. Can we turn the fan off over here, Tony, please? Or- Thank you.
Dr. Russell, did you ever review or receive that document from the defense?
Oh, yes.
And regarding Dr. Walsh's opinion, did you consider that when you formed your ultimate basis that the wounds on Mr. O'Keefe's arm were consistent with the dog bite?
Yes.
Did you disregard it or agree with it?
I disregard, I disagree with his assessment.
Thank you. Sorry, I'd like to inquire.
Your Honor, I would object. This is the same exact issue I had to deal with because the witnesses disregarded it, and I was not allowed to pursue questioning. So I do not believe, under the standards that's been set in this trial, that a proper foundation has been set.
What do you say about that, Mr. Brennan? How is this any different?
Pardon me?
I'm talking to Mr. Brennan. How is this different with this witness's analysis?
Because they specifically opened the door when they had her vouch for her own credibility, extolling her uniqueness and ability to determine that these were dog bite wounds. And so when they opened their own door to vouch for their own credibility and suggested that they're the only person or a limited person in the entire country that could do this, they should be confronted that they are not alone. There are other experts. And so this isn't affirmatively bringing it in. This is when the defense continually opens the door and creates these issues.
What do you say, Mr. Alessi?
Thank you, Your Honor. My response is this. I'll give 2 quick examples. Dr. Welcher, Trooper Ball, Dr. Scordy-Bello. They talked and opened the door under Mr. Brennan's theory of opening the door widely. They even had, as part of their direct examination, documents in Dr. Welcher's slide that mentioned Dr. Scordy-Bello. You'll recall that slide. They even had material from the CARS team with a file named Trooper Ball.
I'm not letting it in.
Thank you.
All right, I'm not letting it in under that, Mr. Brennan. So you can mark the report if you want, but for that reason, I'm not. For the reasons
Finally.
stated by the Commonwealth, I'm not letting it in.
I don't need to mark it.
Okay. All right, thank you, Hunter.
Finally, a ruling that's equal to the defense, and that's because Alessi Had the judge by the sneakers in the prior ruling that she wouldn't allow Judge Welcher to be cross-examined, even when he used Trooper Paul, Dr. Scorty Bellows' information in his report and cherry-picked part of it, okay? So now there was I was like, Walsh, who the heck is Walsh, a deputy medical examiner? She didn't rely on it. We haven't even...
Objection. Where are we? Is it in evidence now?
It's not yet, it will be.
Okay. The DNA. It's not, right?
It is not.
Okay.
Is there any question?
Yes, it's open. I denied the motion and allowed the line of inquiry.
All right. So, by the way, lunch is here for those of you that like to know. Lunch is definitely here, and that's what she asked. Let's see. Pebbles, if she denies it, will the defense put in a motion to a higher court for dismissal? Will that be an option? They won't do that. They'll just preserve their rights here because a higher court will not intervene at this point. They'll wait and see exactly whether or not Karen Reed got convicted or not. But I do believe this was absolute burden shifting that she should not have allowed. And she came in and denied it without even reasons. Just denying the motion. You can continue your inquiry. And then he wants to go on, Hank Brennan, to another area by talking about another expert that we haven't even discussed and never even mentioned this trial, to question her. And it looked like she was going to allow it in to, unless he pointed out, hey, I have two examples, Trooper Paul and Dr. Scorty Bella with Welcher, and she had to deny that. She was caught. All right, so let's go into court and let's listen, because this is about to start, and I'm sure it's going to be extremely heated. And unless he better keep up and keep awake here on this and do what he's been doing recently, which is great.
Back in session, you may be seated.
Jurors, I appreciate your patience. All right, Mr. Brennan.
Thank you. Good afternoon, Dr. Russell.
Good afternoon.
Dr. Russell, we were talking about your differential diagnosis and your opinion that Mr. O'Keefe's abrasions on his arm were not consistent with impact or collision with a car. I was asking you specifically about some of the things you may or may not have reviewed before you formed your opinion. You looked on direct examination at a photograph in Dr. Welcher's presentation, and it had a photograph of a person who had been hit and died as a result of a collision. Do you remember that photograph you looked at?
The photograph of which one specifically?
There was a gentleman
I've
lying
seen.
on the ground. His face was redacted, and there was
Oh,
some
that one.
You
Yes.
remember that one?
Yes.
And when you discussed that, what was the reason? What was your point in discussing that?
I was answering questions.
Do you know what the point was? What you were trying to deduce or
No, I was
suggest?
just answering questions.
Okay. You have stated before that one of the reasons you do not believe that the injuries were the result of a collision or impact with the car is because there were no lower body injury breaks. Do you remember that?
That's one of the reasons, yes.
You would agree that a side swipe or a clipping collision is different than a front or a back immediate impact, like being run over. There's a difference, right?
In general, yes.
When you talk about the absence of lower body brakes, do you have any studies about the frequency or the likelihood of lower body brakes in a clipping impact as opposed to being directly run over?
No.
When you looked at that photograph that was shown to you on direct examination, did you look at the actual injuries that were listed for that gentleman and see that there were no lower body brakes?
I looked at all the injuries, yes.
And did you recognize in that photograph and slide that there were no lower body brakes?
Yes, I did. There were major internal injuries, however.
When you considered the information in this case, did you have an opportunity beyond that photograph to look at Dr. Welcher's videos about impacting a vehicle driving backwards? Did you watch those videos?
I saw an image. I saw an image.
Did you see a video when Dr. Welcher put blue paint on his arm and showed the height and the location when it touched Alexis? Did you see that?
Objection, Your Honor.
I'm going to allow that.
Yes, I saw that image.
Did you consider what's called the text stream data? Do you know what text stream data is?
What?
Text stream, the black box that shows the operation of a car, how fast, how slow, acceleration. Did you look at any of that information before you formed your opinion?
I looked at it, but I honestly did not understand it.
Did you ask anybody to help you interpret that data before you drew an opinion that the injuries were not consistent with the collision?
Well, first of all, my opinion came long before that report ever came out. So the answer to that is no.
When you have an opinion, if there's new evidence that is contradictory or different or maybe undermines your theory, do you have an open mind to reconsider your theory?
Yes, I do.
Did you want to understand that information about the text stream data and the information that was available regarding this allegation? Did you want to understand that before you came back and offered the same opinion you had before that information was available?
I didn't understand it, and I didn't know that if any of the attorneys understood it, actually.
Did you know anything about Mr. O'Keefe's cell phone data when you were drawing these conclusions about when his last movements were? Did you learn anything about that?
No.
Did you know about any type of DNA testing on the defendant's rear taillight area?
Yes.
And did you know about any hair found on the car?
Yes.
Did you consider those things when you excluded the collision or impact as the cause of those wounds?
Well, I considered that. However, he had, my understanding is he had been in and out of that car, on many occasions, and so therefore there would be reason for either skin cells or DNA or possibly other, hair, fabric to be on that car.
So when you consider testing your conclusions, do you look at it as an advocate or do you look at it as a scientist or a doctor and try to value how little or how strong that evidence is?
I'm looking at it as a neutral party, a doctor, a scientist.
So you're not looking at it as an advocate to try to discourage the strength or weakness of evidence?
Excuse me?
You're not looking at it as an advocate? You're looking at it as an independent professional?
I'm not an advocate at all.
When you talked about John O'Keefe's sweatshirt, can we put that up, Ms. Gilman, please? You identified or discussed some of the tears to the right sleeve of Mr. O'Keefe's sweatshirt, didn't you?
We discussed one puncture to the right sleeve, yes.
Having an interest in dogs and dog bites, certainly you're aware in your experience, when a dog bites, it creates quite a bit of saliva, doesn't it?
It can.
It can actually, a dog can froth, is what they call it. Excessive saliva when it's in the moment.
Some dogs, yes.
And some dogs, they can shed hair, especially when they're interacting with other objects, don't they?
They could.
Hair is considered trace evidence, isn't it?
Yes.
And saliva contains important items sometimes like DNA, correct?
Yes,
And that's considered oftentimes very important trace evidence.
yes,
And Dr. Russell, are you aware that one of the criminologists took swabs of holes on the left sleeve of the sweatshirt?
Objection, Your Honor.
No, are you aware of that?
yes,
You've heard of UC Davis, haven't you?
yes. And in reference to that previous question, however, the swabbing was done many weeks after the death, and there were images of clothing on the emergency room floor. So, yes, I am aware that there was some swabs taken at some point.
Is that gratuitous answer part of your advocacy or part of your medical objective opinion? And so you're
Asshole,
aware
excuse me.
that these holes were swabbed to send a sample to UC Davis, aren't you?
Yes,
UC Davis, do you understand they specialize in dog DNA?
animal DNA, I believe.
And you also know, and giving it before you gave your opinion, that when they were tested, there was no dog DNA found in any of the samples. You knew that, right?
Yes,
In fact, what was found was pig DNA,
that's correct.
and there's no identification where the pig DNA came from, is there?
I don't think so.
So when you saw the information, after you claimed there is a dog, prove it, John O'Keefe, when you saw the information that they were swabs done of those holes and the results were no dog DNA, did you consider that before giving your ultimate opinion?
Yes,
And in fact, you've tried to discount the significance of that evidence in the past, haven't you?
yes,
In fact, you have made claims about that evidence candidly with no foundation whatsoever, haven't you?
I explained why there could be no dog DNA found.
You were claiming that it was inconsequential because a number of speculative reasons, didn't you?
Objection, Your Honor.
So the objection sustained. Can I ask it differently?
When you were discussing the absence of dog DNA on Mr. O'Keefe's sweatshirt in the past, were you trying to make suggestions that perhaps the samples could have been tarnished or compromised in some way?
That's one possibility, yes.
As a independent, objective expert, should you deal in possibilities, or is it a better practice, best practice, to deal with objective criteria in the form of actual opinions to a reasonable degree of certainty?
It would be best to go through a process to determine, or at least come up with a list of reasons as to why dog DNA was not found. There are a number of reasons. You know, if you have a test in medicine, you expect it to be positive, and it's not positive. You go through a process of trying to figure out why the case is that way. There are many reasons why there could have been no dog DNA found.
When you first gave your opinion, you didn't even know about that DNA testing, did you?
Not initially, correct.
But then once learning about it, you were not willing to reconsider and change your opinion about the source of these scratches. You maintained the same opinion you had before, correct?
I reconsidered, however, my opinion did not change.
What you suggested is there's possibilities, is the word you would use, possibilities why there were errors with the DNA, yes?
Yes.
You can't tell us anything based in fact. Wait,
No.
I'm sorry.
Oh, sorry.
You can't tell us anything based in fact to support the claim that something was wrong with the testing of this DNA, can you?
Not in fact, but again, you have to go through a process. If you expect a certain diagnosis or a certain finding on a lab test and it doesn't materialize, then you wonder why, and you want to know, was the test done correctly? You know, was the specimen handled correctly, et cetera, et cetera. There's a process.
And in that process, you found no evidence whatsoever, none, zero, to support any claim of compromise of that DNA process, did you?
Well, ideally, the swabbing should have happened immediately or very soon after the incident. So there was a delay in processing or swabbing to begin with. And then, of course, I don't know about the transportation or the chain of custody.
You were a medical examiner, weren't you?
Yes.
When you were a medical examiner, when you examined a person or their body, you did everything you thought was reasonably necessary based on the information you had, correct?
Yes.
Did you know at the time Dr. Scotabello did the autopsy, there was no claim whatsoever that a dog caused these wounds?
Yes.
Did you know that claim didn't come about until over a year later?
No.
And did you know that in response to that claim, that's why this was done at a later time? Did you know that?
Still, for a complete investigation, this should have been considered by investigators early on.
Even where there was absolutely no claim or evidence whatsoever that a dog caused these wounds?
Well, again, a complete investigation.
You can't tell us one step that went wrong with that DNA process, can you?
The process, no.
In fact, you have admittedly very little experience with DNA.
I have little personal experience with DNA.
And yet, although you're not an advocate, you are willing to advocate trying to undermine the strength of that evidence, aren't you?
No, I am a scientist, and I'm trying to understand why it could have been negative.
I would have objected based on that question being argumentative, but good answer.
As a scientist and providing a medical opinion, do you try to exclude in your differential diagnosis all other reasonable causes of a wound?
Generally, yes.
And did you do that in this case?
Yes.
Now, when a dog bites a sweater, would you expect that it would leave DNA?
Yes.
When a dog bites a sweater, you would not expect it would leave little fragments of taillight shards in clothes, would you?
Correct.
And so in this case, when you were developing your theory and differential diagnosis and excluding causes, did you consider that when Mr. O'Keefe's clothes were scraped, his pants and his shirts and his sweatshirt, what was discovered were minute, small fragments of broken taillight that came from the defendant's motor vehicle?
Objection, Your Honor.
I'm going to allow that.
Did you consider that?
I didn't know that at the time.
Could we have 201D, please?
Of course she's going to allow it.
Dr. Russell, this is a photograph.
Okay.
Okay, so now the same thing happens. He's going to talk to her about other things, that whether she considered it to try to redo his case. And really, the issue, that's not the issue. The issue is, was there a dog bite? Because there could be other causes for, first of all, he's misrepresenting about shards of glass. Okay, let's start with that. But there could be other causes about that. What's important is what caused the wounds here, and they're not from a car accident. I think she's showing a remarkable, she's a remarkable witness. She doesn't go beyond her bounds. She's answering things as a scientist. And she said, yes, we know we get a negative test. We want to know why. Now, we all know what the problems with the DNA, and that's why this mistrial was so important, because now the burden is now shifted to the defense to show in their case why the DNA swabbing was wrong, why the whole issue of DNA was wrong. And I hope at least that Alessi knows that, you know, if you have a pig DNA, it could come from a minute transfer where it was swabbed, where the dog could have been in a dog chew and then transfer the dog chew DNA over to the sweatshirt. But the arms, the wounds themselves weren't swabbed. That's really what's most important, you know. But here we go. We're back. Obviously, the defense was dismissed again.
Dr. Russell, were you aware that very small fragments, shards of plastic that match the broken taillight of the defendant's Lexus were found when criminologists scraped Mr. O'Keefe's shirt and sweatshirt?
Yes, I became aware of that.
Did you become aware of that before or after you came to your opinion and conclusion that Mr. O'Keefe's arm abrasions were not caused by a collision or an impact?
After.
And when you learned that, did you get a chance to see this photograph to see how small many of those pieces were?
Yes.
And would you agree that broken plastic, like broken glass, can tear fabric?
Yes.
Would you agree that broken plastic, like broken glass, can rub up against a person's skin, and if enough friction is caused, it can cause abrasions?
Yes.
Would you agree that if fragments like this were randomly in the sweatshirt, that it could cause cuts or abrasions to Mr. O'Keefe's arm?
We just heard the Commonwealth's
I don't
theory.
believe that fragments that are randomly in the sweatshirt or clothing would cause the parallel abrasions, the pattern of the parallel abrasions that we saw in the arm.
Do you know how Mr. O'Keefe fell to the ground and what movements his body and arm made as he fell to the ground?
Not definitely.
You don't know?
How? No.
Do you know how much distance or little distance he moved when he was on the ground?
Yes, approximately, I think it was 20 feet. I initially heard 60, but around 20 feet, I believe.
You think, do you know where his body was found on the side of the road?
Yes.
Do you know if his body, before it rested, moved or slid on the ground?
Yes, it did.
And it's your opinion that fragments like this could not have caused the superficial abrasions to John O'Keefe's arm?
You know, in reference to that last question, actually, that I don't know that there was a collision, but I know that it's alleged that there was movement of the body after the collision.
I wasn't asking about the collision, I was asking about his body. Are you telling us to a reasonable degree of medical certainty that these type of fragments that were found in his clothes could not have caused the superficial abrasions on John O'Keefe's right arm?
They can cause superficial abrasions, but not in that pattern that we saw on the arm.
I'm going to ask you the question again. Are you saying
Objection.
to a reasonable degree of medical
She answered it.
certainty that these fragments did not cause the superficial abrasions to John O'Keefe's right arm?
Correct.
I have no further questions.
Okay. Mr. Alessi?
Thank you, Your Honor.
Remind me to talk to you about this 20 versus 60 feet, please.
Okay.
Because she just kind of admitted when she said she doesn't know there's a collision, but if there was, it was 20 to 60 feet. So now we're going to have a drag. I think that the only part that Dr. Russell just fell down on with that, because I don't understand that. If she's saying there was no collision, she understands that he was moved 20 or 60 feet. Well, that's a possibility, I guess, if you're also brought in and dragged to a spot or brought in and pushed to a spot. But she said no collision, and I agree with her. Now we know for the first time the prosecution's theory is that the wounds on the arm are now caused by the small particles of glass that were somehow embedded, that they say in the shirt, okay, at the time of the collision, as opposed to the fact that they were all in the bag. I don't have my demonstrative exhibit here right now. Yes, I do, actually. Hold on a second. Let me see if I can get it. Well, we'll talk about it after Alessi finishes.
May I, Your Honor?
Yes.
Thank you. Your Honor, I would like to have published what is in evidence is 201A, and then I'm going to proceed after that with 201E.
Okay.
Dr. Russell, I have up this exhibit, and with regard to the questions of Attorney Brennan that he just asked about these alleged shards, can you tell the size of them from this depiction?
I don't even see any shards in that depiction.
Can you read that slide and see the handwriting that is there?
Yeah, it looks like clear app plastic collected from 7/18/18. There's another date over to the left side, and then it says AMV 6/29/23.
Right, and if Mr. Wolk, you could go back. Can you determine at all from this whether the shards are microscopic or not?
I cannot see any shards.
All right, let's go to 201E. With regard to this depiction, do you recognize what is in this depiction?
It looks like irregular, red-colored pieces of debris.
Thank you. And do you recognize the ruler above those pieces?
I'm not sure if this is the same ruler as in the previous image, but there does appear to be a ruler.
If we could go back to the previous slide, does that at all assist you in determining whether or not it's the same ruler?
Not exactly, but there are similarities.
So let's go back to, flip back to the next slide. Does the, what is up in black help you reach any conclusion about whether those pieces are microscopic in size or not?
Well, so those are, again, I'd like to go back, but I think those might be 16th or 32nd of an inch if we're using the same edge of the ruler. Those pieces that are depicted are not microscopic because we can see them with our eyes, but they're extremely small.
All right, so they're extremely small. You've asked, you want to go look back at the ruler. Does that further assist you in your analysis as to the size of these pieces?
16. So those looks like they're maybe a 16th of an inch or less.
Okay, so let's go back, Mr. Wolf, one more time. So these pieces are a 16th of an inch or less, correct?
Yes, if we're using the same ruler.
Right. So with regard to, and if we could, Mr. Wolk, now go to Exhibit 1. Attorney Brennan asked you several questions with regard to whether those 16th of an inch or less pieces could cause these types of abrasions. You have addressed this issue, but I would like you to answer whether those pieces, a 16th inch or less, could cause, now knowing the size, whether they could cause these abrasions, including with regard to this pattern.
I don't believe so.
And with regard to that answer, how do you come to that conclusion? What is your thought process?
Okay, again, there are multiple parallel abrasions. So these pieces would need to be lined up in a certain configuration to cause those abrasions, and they'd have to be oriented in nearly the same direction because many of these groupings of wounds, and if I may use the pointer, are oriented in this direction a little bit. well, anatomically, a little inferior to superior, ever so slightly this way. So they're oriented in the same way. So not only would they, those abrasions are rather large for those tiny pieces of plastic or glass, but they'd have to be oriented in a certain way to cause those wounds.
As an emergency department physician, as a forensic pathologist, what is the likelihood, if any, that those shards could cause those wounds?
You have to ask it differently, Mr. Wilson.
Dr. Russell, please state your evaluation and conclusion and the basis for it as to whether those shards of glass, or excuse me, shards of plastic, 1/16 of an inch and less, can cause those abrasions on and wounds on the right arm of Mr. O'Keefe.
I do not believe that they could have caused those wounds.
Is that a close call for you to come to that conclusion?
Not at all.
You were asked several questions by, please keep that depiction up, Mr. Wolf. You were asked numerous questions by Attorney Brennan where he wanted you to go section by section by section and evaluate each. He grouped these, I think, 5 or 6. Do you recall that questioning?
Yes.
Is that a scientifically proper way to evaluate this wound to determine whether or not it is from a dog? Is that a proper methodology to look at each individual section only?
No.
How, at a scale, is it improper to evaluate them that way under your methodology?
Sustained.
Dr. Russell, what is the proper way to evaluate the wounds on the right arm to determine whether or not they're caused from a dog?
To look at patterns, because individual wounds can vary, but the pattern is what is significant.
And on your direct examination, did you go through this method that you just described, a pattern and pattern recognition? Did you go through that in some detail and discuss that?
Yes.
Now, you were asked questions by Attorney Brennan, and in his questions, it was asserted that you don't have a standard, a published standard. Do you recall that questioning?
I'm going to allow it.
Do you recall the question asking whether you had a standard to reference for your methodology? You recall that questioning?
In reference to dog bite wounds, yes.
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 And with regard to the question and assertion in the question with regard to a methodology, you referenced studies and as part of your answer. Do you recall that discussion with Mr. Brennan?
Yes.
Do those, are those studies peer reviewed?
Yes.
And give the name, please, again, that we had gone over on direct, but give the name of the lead authors of each of those studies.
Yes. So one of them was by Dr. D. Munich, and the other one was Dr. Pollock. And by peer review, that means that it's the article was reviewed by other physicians in those respective specialties of the authors.
I'm sorry to interrupt you, Dr. Russell.
I'm sorry.
Finished?
The specialties of the authors, yes.
If we could take that down for a moment. Your Honor, may I approach, please?
Okay.
If I could have, Your Honor, for Madam Court Reporter, exhibits marked for identification P, 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 and Q, Q, Q. And I'll start with P, P, P if I could, please. Thank you, Madam Court Reporter. May I present PPP to it? Thank you, Your Honor. Dr. Russell, you have before you PPP. Is that the study with the lead author, Dr. Demunich?
Yes.
Do you recall Attorney Brennan in his questioning asserting that you had no basis and there was no support for your methodology of pattern recognition? Do you recall that discussion?
Objection.
Sustained in that form.
Do you recall questioning on the cross-examination by Attorney Brennan as to your basis for a methodology in terms of pattern recognition with regard to dog wounds? Do you recall that?
Yes.
Can you please take a look at exhibit PPP for identification and identify whether there's any section in that study that talks about and documents the methodology that you used in that study?
Yes. So this is an article that was published in the International Journal of Legal Medicine, and it is entitled Forensic Approach of Fatal Dog Attacks, a Case Report and a Literature Review. And so it's several pages long, talks about a specific case, and then on page 298, there are some significant passages that I would like to read, actually. So it says here, dogs have some very specific dental and maxillofacial features. They have 42 teeth, 20 in the upper jaw, 22 in the lower. Usually the mandibular dental arch is narrower and shorter than the maxilla, and that means upper, lower and upper. Maxilla is the upper. Maxilla, and the shape of the dental arches varies among the different breeds. There are natural gaps between the teeth that are attenuated or accentuated depending on the breed. The canine masseter pterygoid complex is short and strong, and its insertion on the mandible provides powerful mechanical advantage. So that's talking about the muscles, how powerful they are. And then goes on to measure the forces.
If you could find the location, if there's any in there with regard to pattern, is there any discussion about attributes and patterns in that study?
Yes, this next paragraph. The above features attribute to the characteristics of dog bites. The maxillary teeth distal to the mandibular teeth allow the so-called scissor bite in which the dog can lock onto his prey. The tremendous force of the bite muscle complex can develop, allows the dog to twist and tear, and cause great damage. The injuries caused involve a combination of biting, crushing, tearing that results in characteristic patterns of punctures, lacerations, avulsions of the skin and soft tissue. Forensic pathologists noted the multiple torn wounds with adjacent puncture wounds, the so-called hole and tear combination. That's in this case. The puncture wound, a round hole, is made by the canine tooth of either the upper or lower jaw on one side that serves as an anchorage, while the other teeth cut into the flesh, causing stretching lacerations in the process of biting, shaking, and tearing. This should be considered pathognomonic for dog bites, especially when accompanied by tissue defects and claw marks, the latter being narrow, superficial, linear abrasions arranged parallel to one another, 4 or 5 in number, and usually found in the vicinity of the bite. This pattern allows differential diagnosis, with bites of other animals, which are not accompanied by pulling and shaking, nor by the usage of prominent canine, and with stab wounds caused by sharp instruments.
Does that study support or not support in the literature a pattern recognition methodology?
That's sustained.
What do you conclude from the language you just read in that study with regard to methodology of discerning dog bite wounds?
That pattern recognition is very important.
Now what I would like, if I could approach Your Honor.
Okay?
Sure.
298.
If I could return this to Madam Court Reporter and please request Exhibit QQQ for identification. Thank you, Madam Court Reporter. May I hand it to the witness?
Yes.
Thank you, Your Honor. I've now handed you what is marked for identification as Exhibit QQQ. I would ask, please, that you, is that the Pollock study that you referenced in your direct and in your cross-examination?
Yes.
Could you please, as you did with the Munich study, can you please articulate the relevant, just the relevant sections with regard to your reliance upon that study?
Yes. So this is an article from the Institute of Forensic Medicine at the University of Vienna.
Is that a peer-reviewed study?
Yes.
Please continue.
Excuse me?
Please continue.
Okay. The title of the article is Fatal Dog Bite Injuries. And there's a summary. It says the dog's front teeth. So let me preface this. This was talking about a deceased child. And they describe the features. It says the dog's front teeth left marks of individual circular or scratch-like abrasions, as well as slit-like skin severances. Slit-like skin severances of the skin, arranged in curved lines. The pattern of the skin lesions largely corresponded to the anatomy of the dog's set of teeth. No tissue defects could be detected.
And is there any other section of that study that references pattern and pattern recognition methodology? Any other
Yes.
words, any other section? And if so, could you please read them?
Yes. So on page 491, there's a section called the Morphology of Dog Bite Injuries.
What does morphology mean?
It means the shape. And so it goes on to say the anatomy of a dog's teeth is the key to interpreting injury findings. The particularly long, cone-shaped, pointed canine teeth often create sharp-edged wound slits that can be mistaken for stab wounds. The bite mark on the skin is ideally a complete and congruent imprint of the front dental arch. Sometimes only the protruding canine teeth are imprinted. If the shorter incisors leave an impression, smaller skin lesions, parentheses, round pressure marks or streaky glide marks, can be found between the impact points of the canines. In practice, it is hardly expected that all 6 incisors will act uniformly.
I'm sorry, I didn't hear that sentence. Could you repeat that?
In practice, it is hardly expected that all 6 incisors of a jaw will act uniformly.
Is that sentence relevant at all to what you've referenced as an incomplete bite?
Yes.
How is it relevant?
Because if not all the teeth impact, then you get a partial bite. You know, you get irregular appearances. There's another sentence that's important here. A gap in the injury pattern can have several causes. Oblique biting, so what that means is not dead center on, but off to the side a little bit. Oblique biting. Curvature of the body surface, which we could have in this case around the arm, the edges of the arm.
Mr. Wu, could you please put Exhibit 1 back on the case? And Dr. Russell, would be helpful as you're discussing these items, if you could determine whether or not what's discussed in that study is at all depicted in this exhibit.
Okay, so so we discussed oblique biting, which is off at an angle. Curvature of the body surface. So here we have a body surface that's actually quite irregular. There's curvature down here. There's definitely curvature around the elbow. And so there's curvature around the bones. So curvature of the body surface can change the appearance of the wounds. Interposition of textiles, so that would be clothing.
Is there an example of interposition of textiles in this case?
I don't think so.
Well, was the decedent in this case wearing any, is textiles mean clothing?
Yes, and I thought
Was
you
the
meant in this
decedent-
article. But yes, there was textiles in this case. Mr. O'Keefe was wearing that hoodie sweatshirt
Please
or
continue.
what sweater shirt. So interposition of textiles, and then it goes on to mention some other things which I don't think apply in this case, such as different tooth lengths, tooth loss, abnormal teeth.
And is there any other aspects of that study that are relevant to your analysis and methodology with regard to evaluating the wounds in Exhibit 1?
You know, a lot of this article is relevant, and I don't know if you want to keep.
I don't want to
keep on
keep
reading.
reading it, but if there is a section, because then I'm going to have a few more questions once you're done identifying the most relevant sections of the article.
Yeah, this. And then there's one section that said.
Thank you.
Oh, yes, thank you. Then it does mention that in some victims, parallel scratch marks originating from clawed paws are found accompanying the injuries.
And is there any other section that you believe supports your evaluation of the wounds on Exhibit 1?
No, I think that's it.
All right, so, thank you, Your Honor. May I approach?
Yes.
Thank you, Dr. Russell. Madam Court Reporter. So do those studies, the Demunic and the Pollock that you just referenced, do they support the methodology of pattern recognition that you applied in evaluating Exhibit 1?
Absolutely.
And do they directly or indirectly support that methodology?
Directly.
And is that medical literature peer-reviewed support or not for your pattern recognition methodology?
So as to the form, Mr. Larson.
Do those studies, each of them, those peer-reviewed studies, support your pattern recognition methodology that you applied with regard to Exhibit 1?
Yes.
Did those studies look solely at individual wounds, or did those studies' methodology look at the overall pattern to evaluate and discuss wounds from dogs?
Ask it differently.
How did those studies evaluate wounds with respect to individual wounds and overall wounds? How did the study evaluate those?
They described some individual wounds. There were numerous wounds. Described some individuals, but they looked at the overall pattern to make recommendations.
Was the pattern, overall pattern in those studies important or unimportant in the analyses and conclusions that those authors reached?
Important.
Now let's switch topics. Attorney Brennan asked you about various considerations you made with regard to differential diagnosis. Do you recall those?
Yes.
Let's just start with your differential diagnosis methodology. You describe whether or not you took into consideration additional information that was presented to you in determining whether your initial hypothesis was correct or not. Describe just generally that process and whether or not you took new information and retested your hypotheses. Describe that process that you undertook just generally.
So in general, when a physician is presented with a set of circumstances or wounds or symptoms or whatever, they come up with a possible diagnosis, but have to consider other diagnoses as well. That's what a good physician does. They consider what they think is the most likely, and then they go through a process of eliminating the or including and the other possibilities. Would you like to give an example, like chest pain or
Well, I'd like to
pain?
give you an example of what you used here in this case as the application of that.
Well, okay, so I'm just describing the overall process, because if you came to a diagnosis and narrowed in on it and never considered any other information, sometimes your diagnosis is going to be wrong, and so you have to allow for other information. And so I did that in this case. I examined the circumstances, examined the wounds photographically, and came up with my impression, but I also considered other possibilities. What else could cause those scratches or those abrasions?
And did you honestly and scientifically consider those other possibilities as you continue to review the information, old and new information in this matter?
Yes.
And did that process allow you to avoid confirmation bias?
Yeah. Yes.
So in terms of that process, now let's go through some of the items that Attorney Brennan discussed with you. He asked you several questions, one of which, did you evaluate news clips and audio clips? You remember that questioning?
I remember a question about some news clips.
And did you recall your discussion with Attorney Brennan about acute grief reaction? You remember that discussion?
Yes.
Now, in terms of acute grief reaction, you talked about it, and do you recall discussing that sometimes people who have a traumatic event, that acute grief reaction occurs? You recall that discussion with Attorney Brennan?
Yes.
Now, do you recall also mentioning that sometimes these patients engage in self-blame?
Yes.
And my question, among others, is when they go to self-blame, from your experience as emergency room physician, seeing patients with this, as you discussed with Mr. Brennan, are there instances when patients blame themselves for something when they're not to blame?
Sustained.
Can you discuss what you meant by self-blame in acute grief reaction?
Sustained.
Your Honor, may we approach?
Okay.
This is, again, she sustains all the objection. Hank Brennan went into all this out of the blue. He then asked an open-ended, what do you mean by self-blame? And now we have an objection. Again, it shows the unfairness in this courtroom where Brennan can go wherever he wants, including bringing in DNA that he never brought in, that didn't have a basis to bring in, causing the burden shifting. I have said publicly now on my Twitter account that the defense needs to file a written motion on the motion for mistrial, adding the fact that this causes a burden shifting because now they have to introduce the problems with the DNA, which they were just going to leave it at that because there had been no testimony on the DNA regarding the swabbing, and and we all know the problems. And then, of course, we have the whole issue, by the way, and I don't know if I can get through this by the time they come back, of the alleged microscopic shards. Yes, you saw me. These are the bags we bought. Remember, the gray sweatshirt was separated in one bag, and then it's with the orange T-shirt. There were two different bags, and of course, if you put the one and you take out one that may have something with shards in it, what do you get? This is a piece, and you pull it out of a bag, you get anything that may be contaminated in that bag here. Here was my contamination. Just pull it out, and you get. Remember this? I don't know if I could show it to you. Let me see if I can pull down my thing. I pull down my screen. Okay, we're going this way. We're not doing so well here, are we, with the screen? Anyhow, we have the shards of glass. Remember, we have the shards that this represents of glass. Really, you can't see it from, boy, my demonstration is really epic fail with the shards of glass here today. But when you pull it out, you get the idea. From one bag to another, you're going to then contaminate the gray sweatshirt. You're going to take out everything, and you're going to contaminate things. And you don't even know where those came from to begin with. All right. So you can't rely on that whole contaminate. And that's what we're talking about. I'm sure the defense doesn't really want to go there now because that really hasn't been introduced. It's all that's been introduced is they've seen all the stuff being packaged together. And they're probably going to argue contamination afterwards. But then Hank Brennan takes that to say, didn't these shards cause those wounds? And not only don't you know where the shards really were, if they really were embedded, okay, that's another issue. But you don't know if they got cross-contaminated, and you don't know where they were found. And in any case, those shards couldn't cause those pattern of injuries when it comes to the dog bite. All right, so what are we doing here? All right, and now Alessi's trying to very calmly go through very slowly without doing any bullshit, without trying to, I'm probably going to get censored here on YouTube for that. You won't find it in the transcript. And to show that she considered everything, that she absolutely did everything properly. She considered new hypotheses, and she still, with the pattern, you can't get around that those wounds are considered by a dog bite. Now, if you're the prosecution, all you're trying to do is find a basis for those wounds, and you really can't find one. The blowing out taillight, we didn't see Judge what was it, Wexler do his reconstruction, blowing out a taillight. Why? He said, well, it costs too much. $400. You charge $430,000. You spend another $1,200. You buy 4 taillights, and you see what happens when you impact. Now, I'm also sure that Alessi has to get to the 20 versus the 40 feet. She assumed for the moment that she saw documents that indicated that John O'Keefe went 20 to 60 feet, I guess it was, but there was no collision. So how can you have a collision? How can you go 20 or 60 feet or 20 feet if there was no collision? And I think Alessi has to clean that up. All right. But because she said there's no evidence of a collision, and she considered all sorts of impacts and all. Now we've got the bushes. Okay. Now we've got the bushes. All right. What are we? Thank you for reminding me, legal-minded friends from Karen Cole. Thank you for feeding into us also today. So that's the 20 to 60 feet. Alessi has to clean that up because she was just answering Hank Brennan's questions, not knowing that he's nefarious and how he's going to use that. Okay. Simi Sharp says, I'm curious about the chain of custody violations regarding the evidence. Shouldn't have been that excluded. I agree. I think that when you have all this stuff, that should be excluded. But the judge will say, even with the DNA, it goes to the weight, right? It goes to the weight. Again, this is our friend, legal-minded friends, Karen Cole, who has portaled her show into ours, and we thank you very much for that. Blessed in Texas. Natalie, Joanne, Dizzy, sorry, doctor called me. I went back and checked. Lally passed Hank a post-it and then took it back. Now I've got to catch up to the current. All right. Imagine we all didn't like Lally and he's directing Hank. PTSD healer, wasn't the sweatshirt and taillight in the same bag. There you go. There you go. You knew what I was doing when I was, the sweatshirt. Yes, they were all in the same bag. They were in fourth bag, 438. Okay. I marked it when Alan Jackson did it. When we saw him when we were looking at the retrial. Initially, the gray sweatshirt was separated by itself, then they were all put, they were 438, 437, and 438. That leads to contamination. Linda, wouldn't Wing be best as an ex-witness? I think they don't have him. There may be scheduling issues with regard to him. They have, they have the snowplow driver in, they have the cop who didn't see the tail light broken, and there's somebody else I read they have in the building that's been waiting. But Hank Brennan likes to take all day with witnesses because when he can't get what he wants to get, he's going to go back at it and all. Now, that's the style of a defense attorney. That's what defense attorneys do. But he's a defense attorney, now he's a special prosecutor, and he's using that defense attorney style. Okay, let me see what we else. Natalie Joni. What are the criteria to report a lawyer for prosecutorial misconduct? That he violated one of the ethics rules in violation. So, if the defense thinks that he's done that, they will obviously do it. But, he's been protected by the judge. The judge really has found, she just comes in on a major mistrial motion. And make no mistake about it, there's a major mistrial motion, which has to now be reduced to writing. It has to include that what he did caused the shifting of the burden. And you have to have her have findings on it because she just comes in and denies it. Okay, take a half an hour and she comes in and denies it. All right. I'm trying to get to your last question. Texas Rose, why is he allowed to ask these questions when this is beyond the scope of his? Because the judge allows him. And we've seen that's what's called, everyone believes, the unfairness of this trial. All right, let's go back into court. Let's listen to what happened, obviously, at the sidebar. We'll get an idea by Alessi.
May I have a moment, Your Honor?
Yes.
Thank you.
Sounds like that she won't let Alessi continue because you hear his papers moving and he's moving on and he needs a minute now to look at his papers to see what he's going.
Dr. Russell, do you recall questioning by Attorney Brennan with regard to some alleged clip with regard to a motor vehicle, the Lexus and the pedestrian in this
Hank
case?
Brennan won that
discussion.
Hank Brennan won that
and
objection.
Have you reviewed and Attorney Brennan asked you about the slide presentation that what Dr. Welcher did with regard to this supposed accident reconstruction? You remember those questions?
Yes.
Mr. Woke, if you could please publish the slide from Dr. Welcher's presentation with the arm out in the glass in the back, not that one, the one in this case of the Lexus and Dr. Welcher dressed up as Mr. O'Keefe and with the clothing in the back, but with his that would be toward the back of that slide presentation, probably around 130-ish, 120. That's it, yes. And what slide number is that? 109. So, Dr. Russell, can you see what is depicted on that slide?
Yes.
Is that impact that is depicted on this slide, is that a clip or is that a direct impact to the arm?
I believe that that's a rather direct impact.
Okay, so this is a direct impact. And now, from your experience, and you were asked about this on cross-examination, a direct impact to the arm, assume, as was discussed, a motor vehicle, 6,000-pound Lexus going 24 miles an hour in reverse with a direct impact on the arm. From your experience as an emergency medicine physician, what type of injuries would you expect to this arm?
So I would expect at least significant bruising, at least. But I would also expect fracture, possible dislocation of portions of the arm.
What portions of the arm would you expect fractures and dislocations?
Well, from this image, if it impacted that section of the arm, and let me use my pointer, right here, a very good possibility that there would be a radius and ulnar fracture of the forearm or an elbow fracture.
Could you please stand up and with your Honor's permission, show where the radius and where the ulnar bones are of the arm? The lights on, please. Thank you. You can keep the lights on.
So the radius and ulnar are the two long bones in the forearm right underneath the skin. And then they join with the humerus bone here in the upper arm at the elbow. And those, of course, these bones are they're susceptible to fracture with a significant impact. And also the elbow would be susceptible to fracture.
How about the hand?
The hand could be injured. It depends on where the hand was in relation. And also, if there was a fall, there are other mechanisms that could contribute to a fracture from the actual fall onto the ground. So there could be a wrist fracture, digital fractures. It depends on the circumstances.
Thank you. And do you, you can be seated. Thank you very much, Dr. Russell. From a direct impact to the arm, as you said, is depicted here, what is the likelihood of there being any fracture to any bone?
Objection.
Sustained in that form.
Do you have an opinion, based upon a reasonable degree of medical certainty, as to whether there would be any fracture to any bone?
I believe that there's a very high likelihood that there would either be a significant bruise or a laceration or a fracture of the bones.
Now let's go to, as I understand it, you have reviewed the autopsy report of Mr. O'Keefe?
Yes.
And you've reviewed the file, the medical records files, correct?
Yes.
Is there any indication at all of significant bruising to the right arm of Mr. O'Keefe?
No.
With regard to the lower extremities, from what is depicted here, meaning this impact, did you evaluate the autopsy and the medical records to see what evaluation was done of the lower extremities?
Yes, a very extensive evaluation of lower extremities was done.
What very extensive evaluation was done and by whom?
By Dr. Scorbello, and it was both an external and an internal examination of the lower extremities.
Let's start with the internal examination by Dr. Scorbello. Could you please describe what type of internal examination she performed?
Well, she opened up the legs.
Sustained.
May we approach her for lunch?
All right, Jurors, I'm going to send you out for lunch, okay? We'll see you Tuesday.
What?
Yeah.
Sustained?
Come on up.
Back to the court, please.
What? She's a forensic pathologist also, remember. So we're going to come back and discuss this while the jurors are going to lunch. What? I mean, what? I mean, she's giving her opinion as to why she's ruling out the impact that Welcher, excuse me, I called him Wexler before, Welcher had done with his Blue Man tube paint, okay? I mean, come on here. This is exactly where Alessi's supposed to be going. Objection sustained that she can't talk about what Dr. Scorti-Bello documented in her autopsy report that she relied on and all. Now we're going to come back into court. Let's listen to the argument that you know how it's going to end up. I can tell you already before it happens. Now, we're going to sidebar, I gather. We're not going to do it in open court. But to not have her go into the specifics of why it's important after the cross-examination by Hank Brennan, I think it was great that Alessi brings up that stupid slide and said, what is that? That's not a clip. That's a direct impact that Welcher's showing. And you'd expect significant bruising, most likely a fracture, certainly possibly the elbow or I'm sure the jurors are all sitting there underneath, feeling their radius and their ulna and their elbows. And, a real clever doctor would say, if a juror just looks, they can feel their ulna. Everyone who's fallen knows about wrist fractures. It has somebody in the family or a friend who's fallen on their hands, right? And there's that wrist fracture with those little tiny bones that's in your wrist that takes the weight of the fall, right? When you're falling, and not to have her, when she actually relied on the findings of Dr. Scorti-Bello to show that there were no significant injuries that are consistent with an automobile strike, that becomes really important. And to have an objection and to have it sustained makes everyone know that this is not a search for the truth. All right. What am I feeling right now? I'm feeling like this is a game. All right, that Brennan can bring in, he can shift the burden of proof. He can bring in DNA that's never been brought in on the case and allowed into evidence with regard to findings of chain of custody, and cross-examined with regard to problems with it before he's allowed to use it. And yet you have Alessi, who is very well prepared, who really knows what he's doing, and tries to go through every single thing to discount what Hank Brennan did on what I call a very sleazy cross-examination here. And I say sleazy, actually not in a pejorative way. I say sleazy in the way that we all expect that really, people that represent the mob are going to cross-examine. They're going to put the government to their test. But when you're a prosecutor, you can't do that. When you're a prosecutor, when you're cross-examining, you should be searching for the truth with a witness. And so I use that to say what you do as a defense attorney and the way you cross-examine should not be the way you're cross-examining and trying to get impermissible evidence in as a prosecutor. That's my take on it. And therefore, we haven't even gotten to anyone talking about my theories about pig DNA. I wish they would get there. I really wish they would get there. And here, every time there was an objection, Alessi was overcoming it, except where we had the grief issue. Hank goes there, and then when Alessi tries to ask on redirect why about it, he can't do it. And then with regard to the pattern injury, Hank goes there that you shouldn't use patterns, and then when Alessi tries to use the fact that you have patterns that are significant and that the articles really support her, that this is not an impact from an automobile, there's an objection and it gets sustained. Although he's getting most of it in through her because she's answering questions. She's become very savvy with regard to what's happening. The only thing that we have was that 20 versus 60 feet, which still has to be cleared up because that assumes that there was an impact. Okay, if he moves 20 or 60 feet afterwards, it made it sound like she assumed that there was actually an impact. And she didn't, but that's the way it sounds like, and we still haven't cleared that up. Okay, we still haven't cleared that up. So let me say, legal-minded friends, Karen Cole, I'm so glad you say this. Brennan is acting like a defense attorney, not as a prosecutor. It's likely they have reversed roles. That's exactly what it sounds like. And there was something else I wanted to bring up. 007 in Texas. Spanky will probably, that's Hank Brennan's nickname for you all, will probably try to have Leslie sanctioned for sequestration. I agree. I think he's going to bring up something with regard to the sequestration. Now, technically, you're not supposed to say anything to your witness. You're not supposed to say anything like, you can ask for the articles. But quite frankly, she did ask for the articles yesterday. And maybe that's something that we should tell all of our experts. I'm learning from this trial, and maybe I'll tell all my experts before they start. If they say that you have something different in your deposition or your article, ask to see it, okay? Ask to see it. It may be a good trial practice for all of us who are watching this. The reason why we as trial attorneys watch other attorneys is we can pick up pointers. And if you can pick up one pointer watching a trial, that may be good. But Brennan is constantly objecting, constantly interrupting Leslie. Now they're coming back. I don't know if anything's going on the record. Let's listen.
All right, Chrissy, does that help?
All right.
All right. Somebody asked what the sanctions means. Let me talk about that. Obviously, they're going to lunch. I didn't get exactly that she's giving a full hour for lunch. Did she say 2 o'clock, which is what I would expect here now? Remember, when we finish with the lessee, we're going to have Recross by Hank Brennan. Why? Because he can't control himself. By the way, Colin, you're right. Colin, 6 hitters, said she asked for transcripts, and most of the time he never gave them to her. You are absolutely right with that. Sky Store page. What do sanctions mean exactly? Okay, she can fine him. Okay, she could pull his pro hoc, which she is not going to do. She can say, I'm finding a violation and not do anything, but don't do it again. Be aware, but next time I will find things. I will do something to you. And she can give a strong, a strong warning to the defense. Look, that was not really a sequestration violation that we most have. Like you talk to your expert. You're not allowed. What people have to understand, once a witness is on the stand, you can't talk to your lawyers who put you on the stand. You are not allowed to talk to your lawyers who put you on the stand unless you get court permission to do so. And that's why I think it was with Jen McCabe, if you recall, Alan Jackson asked her if she talked to Carrie Roberts or talk to anybody. She said, yes, I talked to Carrie Roberts. When did you talk to Carrie Roberts? This morning. What did you talk about? Well, she just called to wish me good luck, which wouldn't be a violation. Although, does any of us believe that it's just good luck? No, and all. But that's what the issue of doing some kind of a violation of sequestration, just like she did. She found the defense team in violation twice of Rule 14. The first time she didn't do anything, and the second time she didn't do anything. But she has to yell at them, and so she may yell at him in open court if Hank Brennan wants to bring it. And I think it's unfair. I think if there's going to be that, let it be at sidebar, because it should not affect the public's perception of Karen Reed or the perception that somehow there's something wrong with her lawyers. I mean, I'm sure that, coming up from court, they were driving together. I can see Dr. Russell saying something like, was it okay that I asked for the articles? And Leslie's saying, yeah, it's okay if you ask for the articles. As a matter of fact, you should ask for anything that he alludes to, considering the article, considering the autopsy report that he said in front of the jury, said something, didn't say it. Now, that could have been a sanction, right? You have represented to a witness that an autopsy report said something, and it didn't. And then Hank Brennan always says, oh, I'm sorry. Oops, I was mistaken. Okay. The judge does nothing about that. Ashley and Annelle, what is Turtle Boy's tweet saying right now? Because I'm on with you and I cannot get to Twitter really quickly. Okay. And all. By the way, Dr. Russell, I think, she got demeaned by Hank Brennan last time. And then in this time yesterday, and Defense Diaries also posted it, and I responded to it. He said something about, do you have a problem with your memory? What? because she is an older woman. There's such ageism, right? What ageism, Hank Brennan? What ageism? You know, I could say, do you have your hair dyed black? Because it certainly looks a lot different than it did at the beginning of the trial, right? Talking about ageism. But I won't do that because I'm a nice person. Okay. All right. So it is really, really ridiculous. Justice Serve TV. Let's see. Karina, I can't read. I can't see this far. Okay, let me just open up my screen. I'm sorry. Karina K., a witness for the Commonwealth last trial, will testify with lawyer present that Jennifer McCabe told her that there was a ring camera footage of John O'Keefe being hit by a car. A witness for the will testify in an attempt to convince her to turn against Karen. Interesting. Attempt to convince her to turn against Karen. Okay, let's see what happens, because I know she's in the courthouse. And that would be what they tried to say that to get people to turn against Karen when there wasn't any ring camera footage. And you know, Jennifer McCabe pops up, right? Because if you want to talk about those audios, and as I said, today is comfort day. I'm actually sitting on my couch. I have my Justice Serve TV yoga pants on. You may see my knee up here and there today as I wait for Michel Bryant to make an appearance to relieve me from being on the air. Not that I don't like being on the air with you, but everyone's wait, what? Did I hear something? I think he may be actually there, but just Jennifer McCabe, there he is. Jennifer McCabe, remember, is the one who told Karen Reed, well, that John didn't come into the house, and she started thinking that, well, maybe could I have hit him? All right, so she's all over the place. So if she tried to turn a witness against her by saying there was a ring camera footage of John being hit by the car, interesting how she's everywhere. But I see him. The star of the Madeleine McCann. We're still trying to get, I think, sound on him. No sound there, Michel Bryant. No sound yet. 1 minute. I know. No sound. All right. Michael, the star who went to Portugal to investigate the Madeleine McCann disappearance, put pressure on the authorities. And guess what? Today we announced, I think we're going to have sound now.
Any better? You got anything? Hello?
We have you.
Hey.
Hey.
What's happening there?
Hey, sup? What's going on?
Oh, just hanging out. Where am I today? I lost track.
Yeah, I know. I can't believe you stepped off the plane and went to Dedham. You were in Dedham. You may feel a little exhausted. We have had such a 2 days. I've been going through it. I'm not going to catch up with you now. Can you just hold the show down for about 5 minutes while I take, by the way, there's a question from Louise P. before I go. Linda, do you think the defense will still call Proctor? I don't think they're going to call Proctor. I've changed my mind again on that because they got the text in, and then and even if they don't get a jury charge, they can say, can you imagine a murder case? They don't call the lead investigator. Why? Because it was found that he was biased and he was fired. Michel Bryant, I need to take a short break.
Yeah, I've been here 20 minutes. They're trying to kick me out of the parking spot. I've been here. Now all of a sudden parking is a critical issue here in front of the courthouse.
Because you won
2 hours ignored by everybody, every day, every month. But now today it's a big deal because I'm parked here. Anyway,
all right. I need to take about a 5-minute break. Do you mind holding the fort down and answering questions while I go on a break for 5 minutes?
Knock yourself out.
Okay. Thanks, Michel Bryant. We'll see you in a few minutes.
All right. So I don't know how you can survive with just a 5-minute break. I'm exhausted. Anyway, good to be back in Dedham, despite law enforcement Nazis being so concerned today for some reason about somebody being parked somewhere. I barely got here, and he's pointing out that it's a 2-hour limit on the sign. And now he's going down to, I'm right next to the buffer zone, right next to where the usual folks hang out, just outside the First Amendment zone sign. And there's a very interesting interview that I did with a few of the folks because I was curious what they felt about the new First Amendment zone and the new incarnation. So we talked with some of our usual friends, Scott, Dina, and then they have their own thoughts. And you'll see it's uploading now. And by the time we get through the lunch hour, I'm sure it'll be available. But Scott was showing some of the signage that had been approved versus some of the signage that had not been approved. It is ridiculous. You have to go to, Hardman and say, sir, can I please, may I have some more, sir? Can I put this sign up? That says this. Well, yeah, that one's okay. Well, how about a sign? No, that one's no good. And the ones that are no good say Karen Reed. The others can say, you know, the Commonwealth sucks. That's actually okay. Can't say anything about the judge. Can't say anything about DA Morrissey. Can't say anything about any of the participants, pro or con. So that is based on the ruling that came down last week after Mark Randazza did an amazing job there. I was with him I always say with him like I was a co-counsel. I was in the gallery as one of the affected parties from our case, which, by the way, as of yesterday, was just declared moot, or at least attempted to be declared moot. I'm not sure we're going to have a response to that or not. But because of the ruling that suggested now the First Amendment zone is all fixed, it's all perfect now. The court's saying that, yeah, obviously certain things can be done, certain things can't be done, and actually shifting the burden from the supporters or humans to the cops. The cops have to articulate why there is a violation of the First Amendment zone. That's been the shift. That's the supposed fix, right? So because of that, there's been an action to find the other cases moot. We'll keep you posted on how that plays out or not. And that includes, you know, Mr. Delgado, who had the sticker ripped off of his shirt. I don't care what you've done to fix things. That happened. That's an assault and battery. So you can't just, you know, brush that away. So we'll keep you posted on that. No, there, Dina, what's happening?
What's going on, my friend?
You know, it's the usual craziness.
The craziness
I'm
of
just
this.
trying to hide from the sun. That's all I'm doing.
I know it's really warm down here, but that's all right. Spanky's over there went to the bagel shop as usual.
Yeah,
I brought
go
my
down there.
harmonica to play for him. Oh. I played for him this morning when he came in.
And what did you play?
Pop Goes the Weasel.
Any reaction?
Oh my God. I just think Alessi is just so amazing. Like, you got to remember when all that happened, when he got fired up, they didn't expect that to happen. And it just flowed out of his mouth. Like, he's just so brilliant and amazing to watch. I mean, the team's just amazing. And Dr. Russell is what an amazing woman to show the world of how strong she is. She ain't taking any of Brennan's shit.
She's very good. Very good.
Yeah.
And that to me is the big difference between, and look how tall Dina is. She's giant, and I'm way down here. Actually, I'm in a chair because I'm trying, again, oh, there, thank you. I'm trying to hide from the sun. I had a lot of sun over in Portugal. So what I find different between what she's doing and what others might do, if they're experts, like professional experts, is they waffle. And she's very honest. If it's something that she can't attest to, she'll just tell you. And that comes through to the jury. There's no doubt.
Oh, there's no doubt. And that's a younger jury in there, too. Have you been in yet?
No. Sadly, no.
It's a younger jury. I want to say maybe 3 are like 55 and above. 2 are probably like 65. A lot of them are younger. The youngest one's got to be about 18, 19, like the young one.
So the real question is going to be who's calling the shots, you know, who's a leader and who's a follower.
I don't know who the leader is, but usually the leader's in the very first seat, but that's the kid that they moved. So, and he's probably in his 30s. There's probably 2 people that sort of look Spanish. There's 3 African Americans on there, 2 men, 1 woman. There's one guy that looks really Irish. He's older. But they all were paying attention when I was in there other than one person, you know. And it's not that he wasn't paying attention. It was that day that they were doing all the numbers and the clicks and the data and the bytes, megabytes, whatever. And it was hard even for me to stay awake. So you sort of doze off. But pretty much the jury is totally paying attention.
Well, here's one thing that comes to my mind as I'm listening to Mr. Brennan go on and on and on about you said once that now I'm sounding like Kennedy. You said that the dog, it could be a bite, it could be a scratch, and now you're saying all that does to me, and I think to most jurors, is reinforce blah, 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 dog bite, blah, 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 dog bite, blah, 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 dog scratch, blah, blah. I think when they sense how much he is fighting to keep this information out or to somehow cut it off at the knees, they say, wow, this is pretty important stuff. I wonder why it's so important. And also the other thought I have is it's like Brennan is saying, these jury members have to be idiots. They have to be so stupid.
There goes Hanky now.
That they think.
Want to play my harmonica?
How you doing, Mr. Brennan? He's got his bicycle cop export.
Yep.
Escort or export.
I love sign bombing Michael and Linda's channel.
Yes. We know that is Scott. So the other thought I have is that he's insulting these jurors by basically saying, you are so stupid, you are so ignorant, your IQ is so low, perhaps single digit, that you think all of those injuries we've been dwelling on for so long were caused by somehow a tail light, even if cracked, even if broken. I mean, you can't, as they say, check your common sense at the door. And I don't think anybody with any shred of common sense believes what they suggest, what the Commodore suggests could have been done by the taillight, even assuming there was contact between that taillight and John O'Keefe's arm.
There is no way John got hit by the car. And, we know about Archer. Of course, the jury doesn't at this point. But, anybody that has a common sense, you don't need a degree in law to figure out, one, whether you believe Karen's guilty or not, there's reasonable doubt. There is no question about that whatsoever. I 100% believe she's innocent because I looked at everything. But, they're really paying attention, this jury. And Karen's definitely going to be found not guilty. And Hank Brennan can fight all he wants. He's making the world hate him. It's bad enough he's got the title of Whitey Bulger's lawyer. But as we watch him rip people apart on the stand, Dr. Marie Russell is just holding her own, but he looks like a complete jerk. And wait till he gets Lucky Loughran up there. He messes with Lucky. I'm going to tell you, we'll be rioting in the streets. Lucky is one of the most decent, salt of the earth, blue collar, honest people there is out there that loves his job and he has respect for the job that he does. So for Hank to try to annihilate what Lucky does or confuse him is total bullshit.
And he's very sympathetic, this guy. And if Brennan does his Brennan act on him, it's going to backfire.
It's going to totally backfire. And I already think the jury already half hates Hank anyways, the way he's acting and, degrading people inside. He's just a jerk.
I just wonder, in his twisted brain there, and that's my objective finding as a non-healthcare professional, does he think that that's helping the case? Does he think that being, kind of a hard ass is somewhat helpful? Because it just on a fundamental level, it just comes off bad.
Well, I just think he knows this is a losing case and he's just at wit's ends and he's just going all out. I think that's why they hired him. He doesn't care. He's going to do whatever it takes to get it done, other than burying people, which, who knows about that? But, they got, I heard Officer Barrows entered the courtroom too. And what did everyone think of that Boston police officer yesterday, Deva?
She was very popular.
Oh my God, what an embarrassment to the Boston police officers. If you're watching this, she's a disgrace. She's a disgrace to your uniform. She was horrible on that stand. What disgusting. And I'd like someone to audit her too, because she's got a lot of cash.
Well, that's the problem. I'm not just a financial audit, a professional audit. Because somebody that has that many memories that are planted by others, what effect does that have on other cases she's been involved in?
Not only that, is what is she going to do when she's out on the street? If you're making life or death decisions in split seconds, and that's who is representing the Boston Police Department. She's disgusting. She's a disgust to the badge. She really needs to be looked at. I want to know why she got transferred so quick and gone over to the Boston Police Department.
Well, I could be sexist and chime in on why.
Yeah,
but I shouldn't. It's never stopped me before. I think there are some obvious reasons. That's all.
Well, you need women on the law enforcement. I understand that, but there's a lot better picks than her. She told one story to the FBI and now she's changing her story. That comes with repercussions.
You would hope.
Oh my God.
Take 3.
Repercussions.
Yes, you would hope. You would think. You would hope, but I'm not counting on it.
The world is watching this, and we need to hold the people that lie on the stand and perjure themselves. They need to be held accountable, big time. Everybody makes mistakes in life, but we're talking about intentional mistakes that you made in the death of a Boston police officer, Officer John O'Keefe.
And if there were intentional mistakes, I don't call those mistakes.
No, intentional wrongdoings.
All right. What's the plan for the rest of the day?
Drink vitamin water because I'm like, it's warm out here.
It really is.
You can come into the shade with us after. And hi, everybody. Hi. Keep watching. Watch this channel. It's an awesome channel. Michael and Linda are really wonderful to let us boots on the ground. Come out. There's Linda.
Hey, Tina. I heard my name and I had to come running back.
Hold on.
Try that again.
Hi, Linda. How are you?
Throwing you kisses too, huh? Hey, is that
Wow.
Scott back there?
Yeah, Scott's back here too. And we just want to thank you and Michael for giving us a voice somewhere too. We really appreciate the channels that do this and really come in here unbiased and let boots on the ground talk to you guys. And we appreciate that.
And as a matter of fact, we have a comment on that, Dina. Legal-minded friends, Karen Cole, and she's been feeding into us, her stream. It's boots on the ground. It's great to hear what is going on from the view of being in the courtroom, but thanks for coming to amazing coverage. They want the boots on the ground. They want to hear from people like you and Scott and those of you who are truly impacted there, because when this case ends, we leave, right? And then you're there trying to still make changes. And hopefully we've had some effect making changes, at least being a plaintiff in a lawsuit to try to help you guys advance your message.
And also is everyone's got to remember when this trial ends, hopefully the changes will come, but keep us all in your minds, because a lot of us, me, Scott, I mean, there's a ton of us that put our faces out there fighting for this. And if you find us dead anywhere, please investigate fully.
Oh, we'll be there.
Yikes.
Maybe I can call up my husband if that happens.
Yeah, let's not go there. Let's not go
Let me
there.
just say something before I go. June 12th, there is a Together, Stronger Together rally at Michael Morrissey's office, where it's about just en route. Enrique Delgado Garcia, Sandra Birchmer and her unborn child, Karen Reed, Officer John O'Keefe. We are all gathering together as a movement, and we're going to protest out in front of Meatball Morrissey's office.
You got an official meeting there, do you?
Yeah, and there's gonna be speakers and everything. I've actually been asked to speak.
Yeah, what time is that?
2:00. So June 12th, 2:00.
Okay. That's coming up. That's in a week and a half. Yeah.
You better drive back up here for it.
I could be here anyway.
That'll be the 13th time that I've personally protested in front of Michael Morrissey's office. I can't wait.
You should have a parking space there. Should.
And the 13th time Michael Bryant will have been up there.
That's right.
You're on 12 now. You're on 12 now. El Diablo donated to you, Michael. You guys are amazing, standing up for justice. Thank you all. Thank you, Dina. Thank you, Scott, for joining us.
Thank you.
Appreciate it.
He'll be around. So I can't remember what I was getting into there.
Sorry about that. I had to rush off for a while. I've been holding down the fort here while you were making sure that the authorities in Portugal and in England, especially in Portugal, restarted their investigation. Good job, Michael Bryant.
I can neither confirm nor deny what I had to do with that. That's all I will say. I did get a response today. Let me see if I can find this. While I'm looking for this response, let me do a plug, which relates to what you were just saying about the locals here and the impact this case has on others. The wild video that I shot when I first got here, I posted. It may be live now, but wait till we're done and you go check that out, guys. It's this couple from Utah. They come running across the street. Justice Serve TV, we watch you all the time. Blah, blah, blah. And we had a conversation. The reason it was so important to her is her husband died in what sounds like a friendly fire cop shooting. And she was sucked into that whole world sort of as a suspect, but certainly as somebody who was kept from the truth about what happened, because the cops were not admitting. In fact, they claimed that he committed suicide. And so from her perspective, to see this play out against Karen Reed, it strikes a chord. It's a PTSD moment for her. Anyway, so that just kind of happened, kind of generically as I'm walking across the street, organically had the interview with them in front of the courthouse. And so that's going to be up there along with my interactions with Scott and Dean and others who are reacting to the new First Amendment zone. So
right. And as I just want to tell everybody, we are, as I said, we have pulled together the whole Where in the World is Stephanie. We'll give you the last name. We're going to do it. We're trying to solve a cold case back from 1969 that hasn't even been declared a homicide. The bones of a young woman found 12 miles from where she was last seen and last left off, 15 years old. But bring us all of your stuff, because we did get a report from somebody who wants to remain anonymous and sent us a lot of information that we're going to go through about the death of Karina Homer. Again, an old case out of Boston, right? You can Google it, okay? And there's a lot of podcasts on it. In the 1990, photos taken of her in 1996. She was an au pair that was only the top portion of her was found outside. And when I'm looking through all the documents that was said, I won't say it right now, but there's a name that's in this case that somehow is mentioned in her case, but we're not going to say who that is right now, because I have to go through them. And quite frankly, I haven't had time since we've been here with you guys. Also, apparently I'm going to be on Fox Nation again at 3:00 on Friday.
Good.
Channel.
Is your friend going to be on there? Is your friend going to be
I
on?
assume so. I didn't ask. I assume so.
Yeah,
I'm the
good.
only one.
Yeah,
that's
John DePepe will
really
be on
happy.
there, and that'll be very interesting. He has his
So,
hands full with
Yeah,
you.
I know you have Friday afternoon, so I already had said, yeah, I'd check with you because I had checked with you, make sure that you're okay for Friday afternoon. I'll do Friday morning and all,
Yeah.
and all. And I think tomorrow is Wednesday. Tomorrow's our regular day, right? I'm doing the morning, you're doing the afternoon, and I may be just a tad late, maybe 15 minutes for the 6:00 show, but we'll see.
Oh, no worries.
Okay.
What we'll do is, again, our production meeting live. I'll pop down here in the morning so I can get arrivals and get some chat and just, it may be just before you come on, maybe right after you come on, but either way, we'll have that.
We'll work it out.
Yeah, I may just run it live. We'll see.
You were doing things at 12:30 in the morning in Portugal. You were on the air. We were doing our show.
I didn't share this with you or with the audience. For those who watched us last Friday night, and I was from the parking lot of the building in which Madeleine McCann was abducted, I was accosted by a homeowner there. Now, remember, I had issues, and it wasn't with Starlink. I give Starlink 100% credit. But the rental car I had, a nice rental car, I won't mention the name, but a nice European rental car, the battery charger outlet timed out after about 20 minutes, and I had to reboot every time. That's why I disappeared and then popped back on. It was just the system rebooting because, it's a safety mechanism. You plug something into your charger and you leave it, and your car battery dies. Right. Didn't help me. So during one of the times that was down, this person comes over, this is private property, don't you? And I, had a conversation, and she went away eventually. But it turns out it was the same person that accosted me on the street there more than a year ago when I was over there, again, working on this Madeleine McCann case. Somebody who's very protective, not necessarily of the case per se, but they have a very large sense of their privacy being violated because for 18 years, that building has been the focus of this investigation. Now, I'm sure she must be thrilled that they are now searching in various locations in Praia de Luz and across the Algarve region, which, as I've talked about in my reports, it's that southern part of the country of Portugal. Beautiful, beautiful part of the country with this horrible stain on it, right? So anyway, forgot that had happened. Forgot to mention that. So anyway, I reached out to, in light of these new developments, I reached out to both the Scotland Yard and to the Portuguese police. This time I heard from, you might remember I reported from hearing from Alan, the Scotland Yard, right? Alan. And I read that response to my very specific 5 questions and a very generic response. So I reached out again, and this time I hear from Millie of Scotland Yard. We are aware of the searches being carried by the BKA in Portugal as part of their investigation into the disappearance of Madeleine McCann. The MPS, that is the Metro Police for London / the UK, is not present at the search, but will support our international colleagues when necessary. Now, so you might be saying, what is that BK? What is that called again? The BKA? And so I have to admit, I did not know. So I looked it up. Let me see if I can find it for you here. Because it is... I don't speak German, so let me see if I can give you my best recollection. It's Bundeskriminalamt. Bundeskriminal, it's one word. Bundeskriminalamt, which is the Federal Criminal Police Office in Germany's Central Criminal Investigation Agency. So that is the BKA. So again, the UK, then the folks at Scotland Yard acknowledging that this is a Germany operation, and that they're not involved, but they know it's happening. So here's what's interesting about that. And for those who haven't seen the most recent report that I did, it was really all about Germany because they are trying to keep Christian Bruckner. He is the man who on and off again has been the chief suspect in the disappearance of Madeleine McCann. He was convicted of one rape charge. He was acquitted on another, and his current sentence is due to run, and he could be released in September. So as I reported, they're using amazing efforts to try and do whatever they can to keep him in prison so they can continue the investigation, because the last thing they know, this guy's going to be a ghost when he's released, whenever it is. So they've been working hard to come up with something that would justify keeping him in court. I think that's specifically tied to these most recent searches beginning today in Portugal. The other thing we learned was that in this effort to do this, they have charged him with insulting, not assaulting, insulting a correctional officer. Okay, this guy has been in prison. They know
Insulting. Wait,
yes,
insulting. Like insult?
insulting. Yeah, I mean, if that were the case, how many people responding to our YouTube stuff would be criminals? Anyway, there's the law in Germany that says you can't insult a public official, and that includes correctional officers. So he was at this retraining. You know, it's almost like a rehab type meeting that you have when you're going to be released imminently, and that's where this guy stands. So it's trying to get you, socialized. In fact, I think it's called something like desocialization or something. So he's at this meeting, and at that meeting, he calls her, and I'll just give you the roughest translation I can. It was like a cheapskate or a skinflint or something, meaning, most people would just kind of brush that off. It's not even a great insult. But that in itself formed the basis for the charges, which could keep him in prison an extra 3 months, maybe 4 months to the first of the year. That, more than anything, is an indication that they're working hard to keep this guy behind bars while they continue to search for incriminating evidence. Because they really do, publicly and sometimes privately, with the folks I've talked to, think he's the guy.
Yeah, they don't have any body. They have no body.
Yeah,
okay?
yeah, right.
Yeah.
And so obviously that's what the search is for, the renewed search is for now. And they just allocated, I talked before about the 192,000 pounds that were allocated last year. Just a few weeks ago, they allocated another 108,000 pounds, bringing the total of 13.2 million pounds to solve this case.
Yeah. Oh, well, wonderful. They're wonderful. Let me just say, this is a good question, by the way, as a transition. El Diablo, do you guys worry about repercussion judges, prospectors exposing judicial misconduct? And that's a good segue, because you had the woman who accosted you as you're trying to do the report on Madeleine McCann. So I think you had to worry about whether or not she was going to call the gendarmes on you. So Michael, answer that, and then transition to this. Do we worry about being critical of Judge Kenney? Because remember, there's an ethic, there's a professional misconduct rule that we're supposed to be nice to all judges, but we're doing this we're not doing this in our legal capacity. We're doing this in our journalistic capacity.
Yeah, and I think that that's a critical distinction, right? There's a rule that you can't be disrespectful in court. You have to be appropriate, and you can be sanctioned, held in contempt as a result of not doing that. But this little thing I like to call free speech, I think overrides that in a broader sense, like what we're doing here. We're not practicing law at the moment. We're certainly not practicing in that jurisdiction. I have no fear of that. I say bring it on if you're going to do that, because they do tend to bring flimsy cases here in Dedham. But I say, if that's something you're going to hang your hat on, knock yourself out. It'll be another win for us.
Yeah. Thank you, El Diablo, for that donation. Allows us to keep coming up, all your donations to keep going to Dedham, Canton, Stoughton, where this is Michael Bryant's 12th trip in. And you can see that the local people trust him, because we'll give them a voice, we'll talk to him, and you ended up being a plaintiff in the free speech lawsuit. I mean, that was
in a very tiny way. I think that everybody banding together to say this is just not right has changed that. I still don't think. I think it's now it's 50-50. It's better, but it's still wrong to be able to snuff out opinions, voices that just support one side or the other. How do you justify that under the First Amendment? You don't. But what they've done is, and judges do this all the time, this whole Solomon-esque splitting the baby thing. They give you just enough to shut you up and make you go away. And no offense to Mark Randazza, of course, he's done an amazing job, and also John Matus, who we've had on the show, and of course Josh Grant, who's been the chief plaintiff in one of the 4 cases.
Jason Grant. Right.
Jason, sorry, thank you. They're just trying to appease and make it harder to pursue it further, because any court you take it to above the current court that has issued this broad decision is going to say, no, you've got your remedy, and there are limitations that are allowed under the First Amendment, and we think that's fine. So we got what we got, and it's better than the way it was before, but in my opinion, it's not. It ain't right. It still ain't right.
So a couple things. First of all, this has nothing to do with you, but as I was leaving, I saw somebody was commenting on my black and pink sweatshirt. I don't know that that was good comment or not, but I'm hawking merchandise. Yes,
Yes,
we're
you
not
are.
bad.
Welcome to
13
Home Shopping Network. What do we have there today on the
Crocs
showcase?
designed by the great Dizzy here. Just to Serve TV yoga pants, which are fabulous. Matter of fact, a professional yoga teacher said they're the softest pants she's ever had in yoga. That she wears them now all the time. And she's a yogi, like she's like trained in Nepal and spent 16 years there and all sorts of stuff. So I thought that was a real compliment to Diz picking out some good products for our website. But what you missed today, was this whole motion for mistrial, Michael.
Yes,
This
yeah.
was unbelievable. I know you listened to it. I think that
Made some of my notes while driving.
Oh my God.
That's cheated death a few times.
Oh
Some
my God.
rowdy people here, I'll tell you.
Yeah. Oh my God. Well, it was absolutely ridiculous that Hank Brennan couldn't get Marie Russell has been educated by Frank Brennan by we talked about this ages ago. He daubered her for 2 days, right? They really tightened her testimony. She wasn't taking any of his shit. Okay. Yesterday he lied to her. At the end of the day he lied and said something was in an autopsy report when it wasn't. And when she asked to see it, he said, "Oh, I'm sorry, I made a mistake. It wasn't there." Just like he did with the defense and the whole Rule 14 ARCA, the discovery, right? So she's gotten wise to him, and then he wants to go into areas that really aren't within her purview, and he brings in, without having any foundation, without having brought in the DNA testing that was done on O'Keefe's shirt and sweatshirt, because there's real problems with that, right? He brings that in, and then all hell breaks loose. She answered the question, but there's an objection. There's a motion for mistrial on the basis that how dare he had no right to bring that in. That was without foundation. There hadn't been the proper chain of custody. And we all know, we did our bag test, where the sweatshirt was mixed in with the glass and all. And also, with the DNA being on, the things being on the ground, and whether or not the DNA was proper, and they didn't swab his arms. He suggested that the arms are swabbed. So a major motion for mistrial. I do think the defense needs to file it written. I've said that because what they didn't argue is that switches the burden of proof here, because now the defense has to go to show how this DNA wasn't valid to begin with, even though she said she didn't consider it, because the jury now hears there's DNA, right? The jury now hears there's DNA. So you missed that. So on your way back from
I heard it all, and I heard your commentary.
On your way back.
Oh yeah, good.
Thank you very much, because he's going to need it, because he's going to be there for 2 days, by the way. He's going to be there today and tomorrow. You can think about this, but what was your reaction? Did you almost drive off the road when Hank Brennan went there? And then the judge comes back, "I need a half an hour." And she comes back.
To do what?
Let's go on.
To do nothing, to make it sound like she's actually reviewing the matter. But when you come back and make no findings of fact, no rule legal analysis, you just say denied, we know what happened, or we know what didn't happen. She just bought some time to make it look like she was reviewing it, and then and believe me, she ain't the first judge to do it. It's just in this case, it just seems to be routine. That seems to be the habit. So you're right, it has to be reduced to a motion that will require a decision, that will require findings of some sort. And because ultimately, is that going to change this trial as it wanders forward? Of course not. It will change if there's a conviction. It will be huge if there is an appeal. And the grounds for appeal in this case already are enough to fill up a Dedham dump truck. But you got to make that record.
Right. They need to do it. By the way, you've got now Coffee Fund, too.
Coffee Fund.
Minded friends, Karen Rolls, who's been feeding her show into our show, by the way.
Oh, that's great. Yeah. And is that Pound?
Pounds. That's Pounds.
Okay, great.
Coffee. We're all over the world. We're in England, and you've talked to Scotland Yard. I mean, we're talking about cases. Even the case that we're going to that someone has asked us to review to get involved with, this Karina Homer case. She was an au pair from overseas, from one of the Scandinavian countries, right? Crime is everywhere, and injustice is everywhere. It so happens that she died in Boston. Okay. Surprise, surprise. Maybe they can put Deor on the cold case squad to try to investigate it. You remember Deor from yesterday? You don't remember if you pronounce my name right, so I can't remember the answer to your question. That Deor?
Never say Deor, that one?
That
never say Deor. Of course, because I'm a guy, because I don't care if people think I'm sexist, I cannot she's kind of attractive.
Typical man.
No,
You
I
know,
think
I mean,
I think what happened is that this was a payback to move her over because she didn't say. And then when she imagine talking to them, and she said FBI 13 times, and Judge Beverly Cannoni still requires the defense attorneys apparently to say an
some
other
agency
law
or
enforcement agency.
yes,
Are
yeah.
you kidding me?
Yeah, I don't know what she was thinking. Think about this in the context of her normal job. If this Karen Reed case had not evolved and spun out of control that night, this was a nothing fill-in shift for her. It was nothing, just go in, sit at the desk, in the late night hours, and look what it's become. This woman has no future in law enforcement. How could she?
No. I read without attribution, somebody who we highly respect in law enforcement, who's one of the top players, said her career is over. Her career is over. She is fake memories and her attitude and the way she testified. Yeah, they need to send her right away to psychological counseling. In my opinion, once you say that somehow the defense implanted fake memories. Oh,
So,
come on.
Where do you think that comes from? Do you think that she just brought that was her clever idea? I know what I'll say. No, she was told by somebody, this is how we explain away this horrible testimony that or statements that are recorded by other agencies or by others involved in the case. And maybe the FBI, I don't know, just guessing. So they give her a cover story that is so ridiculous. I don't know if she knew at the time that they were submarining and sabotaging her career, right?
Yeah, and the very end, when she goes on whatever is it, I don't even remember. She says, my whole entire career depends upon my testimony in this case. She says that.
I think that answers the question, because there ain't going to be one. So, I just don't know if what was she, 25 years old, something like that?
About that,
I mean,
right.
come on, her cerebral cortex hasn't even formed. So, she's probably buying this idea that, if you just say this, it'll be fine. You'll come out the other end and your career will continue and everybody will give you an attaboy or attagirl. That's bullshit. And I think they got her to buy it to get this testimony. I don't know if those who suggested it realized how stupid it was going to sound, how ridiculous it would sound. Because I think most people have heard, the concept of repressed memory or false memory, right? In the sense of usually it's in the child abuse cases, sexual assault cases, right? Not usually in the situation in which you as a law enforcement officer are somehow bamboozled and brainwashed by defense. It's that boggles my mind.
Yeah. And this is like, it's not like there's many times that there's a dead Boston cop and another Boston cop property. Hello. You think that would be something that's pretty much implanted in your mind, what you saw and heard that night. And by the way, she didn't say it in the first trial, right? She went when the FBI investigated to her or talked to her and gave them the warnings, like, this is serious, you could go to jail if you lie to us. All of a sudden she told them, in my opinion, the truth, and then has to waggle out of it for whatever reason. Yeah, because her whole entire career with Boston depends on it. If she covers up,
Yeah. No, I just think she was, they took advantage of her and she didn't help herself.
Yeah. No. So that
I had a couple of, let me run these by you, because
Go ahead.
notes that I wrote down as I was drifting off the road. Boy, some of these notes are difficult. I mentioned before when Dina was here.
By the way, look at this. I didn't know this.
What do you got?
Sui generis, who's always so sui generis with us. Boston commissioner, that's Cox, was buddies with Berkowitz. Spoke at his retirement party. It was on the Canton TV. Holy moly. So when imagine being a 25-year-old rookie and you get called in one-on-one with the commissioner's office. By the way, a commissioner who had been bashed over the head and left for dead by his co-buddies 25 years ago. Okay. Just so you know, his cohorts. Wow, I didn't know that. Thank you. I'm sorry, Michael, to interrupt you, but I think that was
nasty history. This area has a lot of nasty history. One of the things that Mr. Brennan was talking about was, can you, with Dr. Russell, can you describe the debris field? And it's like, there's no, what debris field? You mean on the day of the incident? Are you talking about February 3rd, February 8th, February 10th, February 11th? Which debris field are you talking about? And most of the time, Dr. Russell was able to, clarify, well, I don't know what was there, and then move forward. But there were times when she just let it go and it would reinforce this concept of debris field. which is key to the prosecution because you have to believe there's a debris field and that the debris was found over these subsequent visits, right? Because it couldn't have possibly materialized over time. So I think that was something that he actually got some success with. Oh, it's time for a siren.
Okay,
not
there's
bad.
something else too that they have to clarify. She assumed, because he talked about, would you agree that there's fragments in the clothing, and then the Leslie's got to say that those fragments wouldn't have caused anything, but they've got to. The defense has to go into the contamination, okay, of the fragments, because she just assumed that, and then said something like, that John O'Keefe moved after he was struck or something. He slid to the ground and either 20 feet or 60 feet. She said, yeah, I know it was either 20 feet or 60 feet in two different reports. So that's an assumption that he was hit, even though she said there's no evidence of collision. They have to clean that up.
Yep. And I think where they're going, assuming Judge C allows them to, is they're going to have to cover that chain of custody error, multiple errors, that possibility of contamination. All of that stuff's got to be addressed, and really how far they can get into it's really going to be up to the judge, and that's not encouraging.
I can hear right now. Mr. Rossi, how much time you have?
Yeah, that was the first.
What else mind as you were driving? I know you've been away, and what else? Because we've had a lot of testimony.
I know. I'm just reacting, if I can, to here comes the first vehicle was the fire truck. I'm doing play-by-play, and now it's an ambulance. So hopefully nobody is hurt too badly, and they'll get taken care of by Dedham's finest. Anyway, so I heard the testimony about the bushes, and I thought it was an interesting move that Brennan made to do whatever is possible to explain those scratches, right?
First time we heard bushes mentioned.
Yeah, and of course, having seen the site a bazillion times, unless somebody in the last 2 years hacked the hell out of those bushes, there's no way they would have had any impact on anybody anywhere near where Officer John O'Keefe's body ended up. Now, if you're going to suggest he was hit so hard by the vehicle he bounced around in the bushes before coming to rest on the lawn, good luck with that. But I don't know how the bushes could impact any of the injuries that we've seen. But he raised the issue. Linda, sometimes it's all about just raising the issue. Let the jury, go crazy about something. Somebody in that jury room during deliberations might say, well, the bushes scratched his arm. Sometimes that's all it takes. Right.
Yeah, with the shirt and the clothes on. The other thing he raised for the first time we're hearing really what the Commonwealth is going to say in closing cause the issues is that those scraps that's in his shirt that's embedded actually caused the arm bruises. That's what they're going to say. That's the first time we're hearing that. And yet on the sweatshirt there wasn't on the arm. There wasn't any of shaking it. Those. So
on the sweater, I guess if you call it like Hank Brennan called
sweater,
it the sweater. Dude, just the raw facts. Just start getting those right. The other thing that I thought was very interesting, and this was on cross, Judge Dr. Russell, and I love the witness. She is such an amazing witness because she's a real person. I was just telling Dina that that she comes across as very real, not a hired gun, willing to say what was and wasn't in her opinion, and not make things up to get where she needed to go. That's, you want that in an expert, and you don't always see it. That's the bottom line. But they were talking about on cross, Hank was somehow talking about, did you know the people on the scene heard I hit him, and then so she had a vague reference to, and I remember reading or hearing something about that. Then she launches into this whole grief syndrome thing. Tim, how you doing, buddy? Good. How are you? Very good, sir. There's Tim. So they get in this stuff that never would have come in any way, but she's allowed on cross to basically explain away those exclamations. The one thing that got a little muddy that I think could have been clarified was he tried to make it sound like she was saying those things contemporaneously 2 years later or 3 years when she was doing the documentary, right? That's where the statements were captured. Well, no, she was in that interview talking about her state of mind at the time, back in 2022. And they didn't clarify that as much as I would have liked, but they still left with the impression, the jury's left with the impression that, well, yeah, these statements, like I think common sense suggests, would happen if you're in this traumatic scenario and a loved one is injured and you are racking your brain as to how it could have happened. Could I have this? Could I have that? But I think that was so, I don't know if she did it purposely or just her, her good nature, trying to help. I'm just trying to help. He plants that information about I did it. And she just bats it away and gets in a mental health provider's perspective. And she's not a mental health provider. So.
Yeah, right. But she gets into that, but because she said she's seen it, she's seen it in the emergency room when people come in and they're just so grief stricken. They say things, and I've heard my husband on the stand when he talks about he gets cross-examined, the eyewitness, and I usually don't watch it, but every once in a while I'll hear it. Well, the eyewitness said this. He said, well, that's why we do autopsies. That's why we have science, because we're going to see whether or not what the eyewitness says is truthful or not truthful, or mistaken or not mistaken. That's why we do the autopsy, and we know the direction of the bullet. So it didn't come from that way; it came from that way. Yep. And she has a very unique experience. She's ER. She's a forensic pathologist. She was a cop in Boston, right? And she ran a prison system where she investigated all deaths in the prison, usually having to do with fights, I guess. So,
and then he's asking about accident reconstruction, expecting a 0 there. And she, well, I did have a course where I was certified, and it wasn't the main part of her education, but I guarantee you he didn't know that or expect that to come out. That I have done some of that, by the way, jerk. So it was good.
Yeah,
that was good.
Yeah. It was really good. What else caught your fancy as you're listening? Because we're here watching, sometimes we have a visceral reaction, but when you're listening, you pick up things that you don't necessarily see.
Let's see. I think that Brennan has a problem with common sense. I think he believes that if he has a witness testify in a certain way, or he cross-examines a witness in a certain way, that people on the jury will just ignore all their common sense. I just think that your IQ has to be so low, and I'm not suggesting the jurors have low IQs, but I think for Mr. Brennan to be successful, they have to have that kind of just dense understanding of physics. I mean, I loved physics, did well with physics. You don't have to think, boy, could this, I got a taillight right here. Let me show you my taillight. There you go. Could this taillight explode outwardly and cause the injuries we see on that arm? I don't know in what world anybody can fall for that. Even if you have the most rudimentary understanding of physics and have common sense. I think he ignores that, and maybe he has to, because common sense kills the case.
Yeah. Now look at the Skyhopper. The Skyhopper's back, by the way.
Good. That's good to know.
P16 is back, by the way. All right. Thank you. She's been very active. By the way, she's talking to Anita. Correct. My mom was an ER doc with a CNS degree too. Wow, terrific. So that's great. That's why you're so interested in this case, and we appreciate your back. We know that we were following you when you had your concussion and your stitches, and we're so glad that you're back with us. So I just wanted to mention that and bring that up. The other thing that was really interesting, what was it? Oh, the Blue Man Group hit. Unless he's able, because unless he then decided that they're going right at it. They're not scared of anything. Clinical nurse specialist. Thank you, Skyhopper. They're going right at it and said, is this a side swipe or whatever it was, a clip? Or is this, what is this? This is an impact. That's an impact he was showing. And therefore you'd expect to find at least a bruise if a car is hitting you 20 miles an hour with that impact, or a fractured ulna or radius, or a fracture up here, or if you fall from it, fractured wrist. Michael, your thoughts?
Yep. I agree. I think it's kind of an interesting argument. It's an alternative argument, obviously. The prosecution is saying, well, maybe it wasn't a more direct impact, it was a clip. But I think if they believe it's a clip, how does that get them to the exploded taillight? I think it kills that argument, because a less direct impact is going to make it even less likely to do the damage to the taillight that they're suggesting. So it may get them to a collision of some sort, but it doesn't get them past that to the broken taillight. It just makes no sense to me. It's so desperate just to prove some sort of collision. Anything, give me anything, but it doesn't answer the question about the taillight. It just doesn't do it.
I'm on mute. The reason I'm reminded, I'm hearing something now. The Museum of Modern Art, which my office is over, right, is having their annual gigantic fundraiser where every single celebrity rapper and everything in the world comes tonight. So it's going to be real loud. So I'm going to have to try to find a place. I may be hiding in a bathroom to do the show tonight, just so you know, Michael Bryant.
How loud could that be? They're not gonna. It's not gonna pick up on your microphone, is it?
Oh yeah,
Really?
the first time I was here and that happened, I actually almost called the police because it was so I can't imagine if you had a small child or baby, or my dog was actually at that point petrified. The noise is so, because we're right there, we're right over the sculpture.
Yes,
garden.
that's it's hard to go over and knock on the door of your neighbor when it's the MoMA museum,
And the big event, but so you may find me streaming tonight, literally from a bathroom. I don't know where I'm going to find
some undisclosed location.
Yeah, it's certainly not going to be in my office here because it won't happen. So if you're hearing all of this right now, if you're hearing all this noise, there's testing going on, there's sawing going on, there's all sorts of stuff going on.
Yeah, I can hear a little something, but I got a little teeny speaker in my ear. It's not all that. It's not like true fidelity, So
Yeah.
we'll see. We've struggled through worse, right? So
Yeah, that's true. That's true. All right. So what else were your thoughts? Because we really have, from Deor yesterday, which was, I think that she was the best witness the defense could ever have, and the worst witness. She was even worse, in my opinion, than Shannon with one end. Burgess
Wow.
with prosecution.
She was a different kind of worse because I think substantively she was less damaging, but just in terms of putting on a body to support your Commonwealth case, she was devastating. She's horrible. But the things she was talking about and falsely remembering were probably less substantive than all of the things that Shannon 1N was suggesting happened. And this jury has to decide whether or not he was cuckoo or not. And I think when the ARCA experts get in there following up on Dr. Russell, it will help cement for the jury, those that are waffling, what did and didn't happen that night in the terms of a collision of contact. I think that those ARCA experts, as I recall their testimony, they're very good at just kind of focusing on straightforward common sense. Like we're looking at the alleged effect. And the cause and effect here, they suggest, is hitting somebody's arm caused this damage to the arm like that, an explosion of the light like this. I don't think you have to get deep into the theories. I think you dwell on the common sense that people have. People have real life experiences, right? Not that they've been hit by cars, but they just have a sense of the mechanics of life. And I don't think anybody would believe, and ARCA can help them get there if necessary, that bumping into somebody's arm at 2 miles an hour, at 20 miles an hour, is going to cause the damage either to the car or to the arm that we see in this case. So I can't wait for that.
Yeah, look at you have your wonderful dog Domino, right? Okay. I have my wonderful dog Tubi. When they jump up on you, sometimes they can leave a bruise, and that's
okay, show
not
you.
a car.
We didn't work this out. See that, right?
Oh, whoa! What is it? What is that?
Well, I don't know. Is it a tooth or is it a claw? What is it? I'm trying to get it in the right spot.
Or is it an SUV? Were you hit by an SUV?
Yeah, I got hit with the taillight. It was horrible. No, when we brought Domino home after the trip, that was just this morning. We're playing, and dogs are interesting. They know how they can play with a given person, like who will let them play rough and who they can't, right? And so I'm roughhousing a little bit with him, and I don't know if that was from a tooth or a claw. I have no idea. But that
We have a new Domino Tubi emoji while you're talking.
Oh yes, yeah, they are yin and yang or something like
Bring
that.
in there.
Yeah.
So
So
you
when I'm
know
hearing that testimony, I'm like, you're right. I have no idea whether this was a tooth or a claw. I just think that a whole line of testimony is so ridiculous. It just reinforces for the jury that there's a legitimate causation suggestion that it was an animal that did that. You can go back and forth. Didn't you say you weren't sure, and now you're saying you're sure it was a tooth, not a nail? I don't care. I don't think the jury cares. They hear blah 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 dog bite, blah 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 dog scratch, blah 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 dog attack. All of his back and forth to me reinforces that this is a legitimate potential cause of those injuries. So on the subliminally, I think it's like, why is this dude fighting so hard to distinguish these little differences if they don't even believe a dog bite happened, right? I think it reinforces the possibility and Brennan's fear that it come in reinforces that maybe it's more likely that it did. And if so, Commonwealth, you got some splaining to do.
Okay, so we heard Yuri Berkenik talking a little bit about the unnamed dog that went to Vermont without an age, without an identification, that he went up to take teeth samples from, which are irrelevant because when there is a dog bite, your skin, as we know, your skin moves, your skin is pliable.
Do you need a water?
No, I'm good, but thank you.
Good? All right, I'm going down to get a water.
Can you give me a martini?
I don't know if we can do that.
Never mind.
If we had red Solo cups, we could do that.
That's true. Next time. Anyway.
Yeah, so you Chris Fabricant, we ran that replay of him with the Innocence Project the other night. Talking about that. You can't match. You can't match.
It's so ridiculous.
It's so ridiculous. But wait till the jury hears, and they really don't understand. I don't think that whole there's a dog in Vermont. They don't understand. Now, how do they get in the fact that Chloe bit 2 other people and was rehomed? How do they get that in?
That's very interesting. I think they're going to have to prove, like they would with any prior bad acts. We're talking about prior bad dog acts, right? I think they have to prove some sort of pattern evidence, that it was a stranger to the home, that it was somebody that Chloe was unfamiliar with, and then connect John O'Keefe to that same category of person. Now, again, we're talking hypothetically here, like we have an unbiased judge. So I think the short answer in this case is not a chance in hell they'll get to. But in the real world, if they can establish that this dog has very similar patterns of biting strangers, then you got a shot at bringing it in. Most jurisdictions have the 1 bite rule, and we're just talking about civil liability now. A homeowner has a dog. Once that dog bites anybody, then you're screwed. Everything after that is strict liability. You don't have a chance to prove what happened. Maybe the dog was being pestered and was fighting. It doesn't matter. Once your dog bites somebody one time, it's branded, and for civil liability, you're done. Right. Not the same for criminal, of course, but it just gives you a sense of how the law looks at dog bites.
Right. You're absolutely right with regard to that. But there's a lot more that has to come in now. In the building, apparently, is Lucky. The snowplow driver is Barrows, the Dighton police officer. I see the fan. And also, the woman is going to say that it was Jennifer McCabe that told her that there was by a car, which is why he's not against people. All right, Michael Bryant, you're apparently taking over the afternoon.
I'm going to have to, of course, I have to move so the cops don't come after me.
Do you need me to stay with you first while you move the car? Let me stay.
What's your schedule?
Mr. Alessi, whenever you're ready.
Thank you, Your Honor.
We'll work it out.
Dr. Russell, we left off talking on the topic of differential diagnosis, and more specifically, we were talking about the lower extremity, the leg, and you were mentioning we reoriented to Attorney Brennan's questioning in the area. Could you please describe for the jury your basis of differential diagnosis with regard to the lower extremities and the leg, and specifically with regard to the autopsy's analysis of that area?
Well, the autopsy doctor did a very thorough evaluation of lower extremities, and to include, the external examination, which is very important, as well as an internal examination of the extremities, the tissues beneath the skin in both legs.
And just briefly, how did she perform that internal examination beneath the skin to look at what was beneath the skin?
Well, to directly visualize those tissues, she had to open up the skin. So she opened up the skin in the legs from the buttocks right down to the bottom of the legs near the ankle, and then reflected or folded back the skin to examine if there were any injuries to the tissues underneath.
Were there any injuries to the tissues underneath from that examination?
There were no injuries that she mentioned, nor no injuries that I saw on the pictures.
And no injuries, did that include analyzing whether there was any inflammation?
No, you can't tell about inflammation, but I specifically looked at the area adjacent to a very punctate little abrasion on the knee. And I looked underneath of that area very carefully on the photograph, and there was nothing, no injury underneath, no bruising, no hemorrhage underneath that abrasion.
With regard to that, how did you describe that punctate? I want to make sure I got it accurate. By the right knee?
Abrasion.
Abrasion. Could you determine from that even the age of that abrasion?
I could not.
And no further questions at this time, Your Honor.
Oh, okay. Brennan?
Well, Leslie won that motion to be able to discuss the leg being dissected at autopsy, by the way. Now we're back to Brennan. Oh, we're going to sidebar. All right. Now we're back to Brennan, and he's got a sidebar. So now he wants to go into some area that wasn't mentioned. Okay. So that's where we are right now. Wow. So I don't know. Well, Michel Bryant is back because I understand. Let's see. Yes. You have 30 minutes before cops return, right?
That was my note. Yeah, I'm putting them on because the guy basically looked at the license plate and whatever, checked his watch. So I figure he's going to circle back and ticket, tow me. I don't know what he's going to do. So I've got 30 minutes maybe in this spot, and then I'll have to try and relocate. So if that's the case, and you have to go do stuff, and I get it, you got to do stuff. We both have.
But I don't want to leave our viewers without somebody. You want? Let me see. Let me text you when you're ready to go. Let me see where I am. Let me see if I can come back on. It depends on where I am. Okay.
Yeah, I think I'm very confident in our audience that they could survive without us for 20 minutes or so while there's activity taking place in the courtroom. Just the thought.
Okay. Okay. We'll see where we are. All right. I'm going to leave you in the best hands with Michel Bryant. I know you have all missed him tremendously because you had nothing but me for the last 10 days. And we've got this. Yes, I know you've got this. All right. Love you all too. Stay with Michel. See you soon, whether it's 6 o'clock or earlier than that. Bye.
All right, then. So that's the plan. I'm going to bug out here in probably a half an hour or less. And if we're in the midst of testimony, perfect. Obviously, this witness is winding down. Marie Russell is she's done an amazing job, and I know Linda talked about it earlier. That's what happens when you appear in one trial and then you appear again in a 2+ day voir dire hearing to test your scientific methodology, which of course Mr. Brennan says, isn't it true there is no methodology? Isn't it? So I think sometimes attorneys get hung up on terms that regular folk couldn't give a rip about. And all this jury hears is what this opinion is about the cause of those marks, right? Do they care whether there's technically a methodology versus whether you have a witness who has treated thousands of injuries to the point that now she pretty much knows the cause of most injuries? That's what sinks in. That's what's believable. Can I label that methodology because there aren't 3 eggheads who have done articles that have been reviewed by other eggheads? I couldn't give a rip myself. And I don't think jury members care either. What they want to know is, does this person know what the hell they're talking about? Do I believe what she has to say? And does what she says make sense in the context of this case, the injuries caused? And in her experience, what's her opinion? No doubt about it that she wins those discussions. So I know Mr. Brennan, he has a job to do. God bless him. Do it. Knock yourself out. But you got to be realistic. I'm not a Brennan fan. I'm not a Brennan hater. I'm just an observer giving you my honest opinion about when he fails and when he succeeds. We've tilted up. We've tilted up now to the fan. That means one of two things. Either it's more extended sidebar or the jury is coming back in. But I think because they had turned over the witness to Recross, that the jury has been in there. They didn't come and go. So this is some sort of pseudo extended break to hammer out whatever Mr. Brennan has a problem with this particular time. So let me look again at some of my quasi notes as I was riding along the roadways of Connecticut and then Massachusetts. By the way, a very simple, quick drive that I've taken many, many times now. Not a big deal. Haven't gotten one ticket or anything. Nothing too exciting. Well, the car broke down that one time. That was one time. So who do you think's going to be next? Who's the next witness? I guess the theory is that it could be Lucky, the snowplow driver. Could be another fact witness, not an expert, that would somehow support the upcoming expert witness testimony from the ARCA representatives, which we think really will be, I think, near the end of the defense case. I think they want to leave this jury with some pretty powerful, heavy-hitting investigation and opinions from experts that were totally independent in trial one, not totally independent now. And it's going to be interesting to see how that cuts, because now we know they're retained by the defense, even though originally retained by the feds, right? Here we go, Mr. Brennan.
May I?
Yes.
Dr. Russell, I asked you questions about your past testimony regarding methodology. And when I asked you those questions and showed you some of your transcripts, would you agree with me that you have testified that there is no recognized methodology on diagnosing dog bite wounds?
No, I believe I said that there was no standard methodology or no standard guidelines as to how to diagnose dog bite wounds.
There is no accepted practice directing you on what is appropriate and what is not appropriate to identify a wound as a dog bite, is there?
There are no accepted standards.
When Attorney Lisi had you look at a couple of case files from the Journal of Legal Medicine, let me ask you about that. You're not suggesting that those articles substitute for the absence of standards in identifying dog bites from photographs, are you?
Before standards are created, there are usually articles that have recommendations upon which the standards are subsequently based.
That wasn't my question. So we're going to listen to the question, please.
Okay.
Those articles, whatever their value you think they are, they do not create a standard to apply for diagnosing or looking at a photograph and coming to a conclusion whether the abrasions are dog bites, do they?
Correct.
And so when he had you read pieces of these articles, had Attorney Alisi gone over these articles with you before?
Yes, we discussed them several months ago.
Did he point out parts of them he would like you to read?
I pointed out parts that I thought were significant.
In this article that was marked for identification, parts of it are highlighted. Who highlighted those parts?
Mr. Alessi highlighted those based on my recommendations.
So Attorney Alisi highlighted the parts he wanted you to read to the jury?
Yes, and I believe they were the same parts that I read last time.
Can we have Exhibit 1, please? Now, regarding the Munich article, that was a case study on the unfortunate death of a young girl, yes?
Yes.
Who was attacked by or bitten by up to 3 different dogs.
Yes.
And it was a neck wound from which she bled.
Yes.
Very, very unlike what you're looking at here.
Yes, but that's very typical of an article, scientific article. They will present a case study and then present the research behind what they have seen in other articles and make recommendations.
I'm not asking you to defend that it's different. I'm asking you if it is different.
Oh, it is different.
Very different, isn't it?
Yes, that neck wound, yes.
Extraordinarily different.
Yes.
And so when you read this, let me ask you a couple questions. In this article, it talks about the characteristics of dog bites, doesn't it?
Yes.
And it talks about the maxillary teeth distal to the mandibular teeth allow the so-called scissor bite.
Yes.
So when the dog clamps down, the teeth kind of go to the side to tear the skin.
I didn't interpret it that way, no.
Okay. A scissor bite is when a dog bites down, yes?
Yes, I believe that what they were describing was the dog bites down.
And when it bites down, it anchors. That means teeth on the bottom, penetrate, puncture, yes?
They can, but they don't always puncture.
And then the top is a puncture. If you're going to scissor, it requires a puncture, doesn't it?
It's a mechanism. It's a movement. What they're describing is a move. The way I read it, the way they described it is a movement like a scissor, where it's open and it's closed. It doesn't mean anything about how deep they penetrate.
There are no scissor bites on that wound, are there?
I don't know. I see one or two things that shown up what I think might be upper and lower. So it could be.
Would you define any of those abrasions as scissor bites, Dr. Russell?
We talked earlier about how these marks here may be lower. I'm not going to define it. No, I can't say for sure that there's a scissor bite, but I see things that appear to be characteristics of upper and lower teeth.
I'm asking you about scissor bites. Please listen to my question. There is nothing on that wound that is consistent with scissor bites, is there?
I don't know.
Well, you're the expert. So when you look at that, can you point whether there's any wounds that are consistent with scissor bites?
According to their definition, and that's not an accepted definition, but according to what they were describing, and I believe what they meant was an open and closing of the jaw as the scissor activity. I believe that there's possibly two areas where I see that.
You're now saying this article that you relied on redirect examination is not an accepted authority?
I'm not saying it's not an accepted authority. It is a peer review article.
The injuries caused involve a combination of biting, crushing, and tearing. Do you see any crushing or tearing in those abrasions?
There's no crushing or tearing here, but does not mean that there has to be crushing or tearing.
I'm reading your article. I'm just reading verbatim, and I'm asking you about it.
Yes, and I'm trying to explain so that nobody gets nobody misunderstands this.
Crushing and tearing that result in characteristic pattern of punctures. A puncture is when a tooth penetrates the skin and there's some depth to it, correct?
Yes.
Show me one puncture, anyone, on that wound.
Okay, there are no punctures on this arm that I see. However, again, the wounds don't have to have every single characteristic. It is it depends on the force of the bite, how the wounds are going to appear.
The injuries caused involve a combination of biting, crushing, and tearing that results in a characteristic pattern of punctures, lacerations, and avulsions. There is no punctures whatsoever in that wound. Would you agree with me?
I agree.
There are no lacerations in that wound. Would you agree with me?
I agree.
There are no avulsions in that wound. Would you agree with me?
I agree. However,
I'm just asking you the question, Dr. Russell.
So you can maybe ask her.
Specifically, this study says the injuries cause a combination biting, crushing, and tearing that result in characteristic pattern of punctures, lacerations, and avulsions. They name 3 things that are characteristic traits of a dog bite, and you would agree not one of those 3 traits is present on the arm of Mr. O'Keefe. Would you agree with me?
I agree. However, in that case, those were dog bites that killed the victim. In this case, we do not believe that these dog bites killed the victim.
When they were discussing this article on the victim who was killed, do you realize when they were giving background, this background has nothing to do with the case study? This is general background I just read. Do you realize that?
They were investigating fatal dog bites.
Do you realize that is not qualified in this article? You realize that?
I realize that they were commenting on fatal dog bites. This is not a case of a fatal dog bite.
This article, I'm going to show it to you. May I approach?
Yes.
In the highlighted paragraphs that Attorney Alisi had you read, that is describing the background of dog bites, not this fatal attack. Would you agree with me?
The title of the, no, I don't agree.
I move to introduce this as an exhibit, please.
Mr. Leslie?
Is it 210?
In the other article that you read from, that was highlighted as well. Who highlighted the portions you were to read?
Mr. Leslie.
It describes that teeth from a canine create a stab wound-like skin laceration. They can do that, right?
They can do
Do you
that.
see any stab-like wound lacerations to Mr. O'Keefe's arm?
No.
It talks about punctures. And again, we've discussed this. There is 0 punctures on Mr. O'Keefe's arm, correct?
Correct.
You said that when somebody is in a collision, that they can suffer injuries such as bruising or breaks.
Yes.
We've also discussed when a person is impacted by a vehicle, it can result in a variety of different injuries or no injury at all.
Correct.
There's a number of dynamic factors involved that are very difficult to assess and predict, correct?
Correct.
And in this case, you did not do any accident reconstruction to try to identify the details of the mechanism of injury to John O'Keefe, did you?
I did not do accident reconstruction.
And so, having not done accident reconstruction, would you agree it's fair to say that you are not in an informed position to give an opinion as to how the injuries could or would have happened in this case?
I disagree.
Specifically, you were asked questions about the impact or collision in this case. How fast was the defendant's Lexus traveling when there may have been an impact in this case?
I understand possibly 24 miles an hour.
Who picked that number?
I have no idea.
Well, you heard it from somewhere and you've just given an opinion on it. Where is that number committed to or derived from?
I don't know.
Well, if you're going to give an opinion based on what you're portraying as facts to this jury, you should have some certainty about the source of your material, shouldn't you?
You know, I'm an ER doctor. So in the ER, I've treated thousands of motor vehicle accident cases. And most of the time, I do not know what speed the vehicles were going at. I've never done accident reconstruction. I don't know any ER doctor that does accident construction or is trained in accident construction. It's not part of the job.
I totally agree, but you're having opinions you're giving on behalf of Mr. Alisi, and that's why I'm pressing you on these issues. Do you know, you don't know the movement of John O'Keefe before any potential strike or collision, do you?
I don't know the movement of most of the patients I've seen in my life before or immediately after the impact.
Of course, you wouldn't know the body angle because you weren't there.
Right.
So when you're asked to give an opinion whether this was a clip or a direct strike, you're really not in a position, having not been an accident reconstructionist and not having been there, to give that type of information, are you?
I wasn't asked to give an opinion about whether this was a clip or a direct strike. I was asked to give an opinion about these wounds caused by a motor vehicle collision.
So you would agree with me, you are not in a position, based on your opportunity to view evidence and your experience, to give an opinion about what injuries would have occurred in this event?
No, I disagree.
And so you think you can give an opinion about the extent of injuries, even though you are agreeing, not only you're not an accident reconstruction expert, you have no idea about the details of the collision in this case, Dr. Russell.
Mr.
Is
Brennan,
that true?
I have no details about the collision?
About what happened during the collision. You have no details about the body movement, the placement, the speed. You don't have any details that you know of other than what was told to you, correct?
Sustained.
There are dozens, hundreds, thousands of motor vehicle accidents in which there are no lower body brakes. Fair to say?
Probably, yes.
You mentioned bruising. What do you do to treat for a bruise? If someone's has some type of pressing and the bruise before it really forms, what's the best way to treat it?
Well, it depends on the bruise. It depends on the location. It depends on whether or not there's continued bleeding in the soft tissues. It depends on whether there's compression of the blood vessels and or the nerves underneath. And then, and of course, you want to examine adjacent structures for fractures and other injuries. And then after all that, if you've ruled out major, other injuries, you treat the patient for pain.
You ever prescribe ice?
Oh, yes.
So if a person was lying prone in the cold winter on the front yard on the dirt and was being covered by snow, sub 32 degrees, and the body temperature were to drop from 96.8 to about 80 degrees, would that have a similar effect to ice on the area that may bruise?
Not exactly. You want me to explain?
I do.
Okay, yes. So as the snowflakes fall, yes, there will be a gradual lowering of the body temperature and gradual effect on the body. Now, if as opposed to in the ER or in a medical setting, if I or another practitioner, and by the way, nurses and nurse practitioners and PAs also treat dog bite wounds. But if another practitioner, a practitioner gives the person an ice pack, they get immediate coldness and immediate significant change in temperature to that area.
Assume the weather is so cold that the cell phone battery on someone's iPhone begins to plummet regularly in degrees.
I have no idea.
Objection, Your Honor. The objection sustained.
Thank you.
When you came to your conclusion, considering what you see in this picture, and Attorney Alisi was asking you about fragments from a broken taillight, did you know or consider that Mr. O'Keefe, sometime around when he incurred these wounds, had a piece of glass stuck in his nose?
Objection, Your Honor.
Sustained.
Finally, Dr. Russell, you said during your differential diagnosis, you consider information, you either weigh it, accept it, or you distinguish it and you disregard it, correct?
Yes, generally.
During your differential diagnosis, you've referred to a number of different people studies, things that you haven't done yourself, but you've looked at other people's efforts. One of the things you looked at was the deputy medical examiner from the Forensic Pathology Investigations Division of the Armed Forces, a person by the name of John C. Walsh, correct?
Objection, Your Honor.
I'm going to allow that.
Would you like me to ask that again, Dr. Russell?
No, you don't have to ask it. I read that report, yes.
And John C. Walsh is a doctor, correct?
Yes, that's what it says.
And do you have any understanding that he works with the Forensic Pathology Investigations Division of the Armed Forces?
Yes, and therefore his practice may be limited in scope.
Well, you are trying to qualify what he doesn't do. Do you know if his practice is limited in scope?
Typically, the medical examiners that work for the armed forces often have a specific practice that is limited in scope.
Do you know anything about Mr. Walsh and his practice?
No.
Why do you find the need to try to undermine the extent of his authority before you know anything? Why is that important?
Objection.
Sustained.
You don't know what his scope and practice is, do you?
No, but I always look at where the person works that writes the report in terms of physicians and what their possible experiences are. You know, they work in a medical examiner's office in Alaska or, you know, Hawaii or a big city or a little town. I look at those things.
When you considered his opinions after his review of these materials, did you consider when he offered in his report that multiple abrasions ranging in size from 2 to 3 millimeters up to 7 centimeters were documented on the decedent's right arm?
Yes.
These injuries do not photographically appear to be, nor are described as puncture, bite wounds, and thus are highly unlikely to be the result of an animal bite attack. The abrasions are non-specific. Abrasions occur as the body moves over a blunt or rough surface such as a skinned knee. Did you read his report and consider it?
I did. However, I don't know if he's ever had any experience with dog bites examinations. So I had to consider that and weigh it.
I have no further questions. Thank you.
Yes.
Dr. Russell, there were questions with regard to highlighting of articles. Did I determine which parts were to be highlighted, or did I merely perform the function of highlighting the parts you wanted me to highlight because you didn't have a highlighting function with you traveling from California?
That is correct. It's the second one.
With regard to these articles, you mentioned a methodology in connection with them and a pattern recognition methodology. Was it the purpose of citing this article to say that they're just like this situation, or was the purpose to say that there is a methodology in the literature to determine how to determine whether a wound is from a dog?
Objection.
Sustained is to the form.
Dr. Russell, what is the purpose? Let's just start with the Demunic article that was talked about, because these articles were discussed. What was the purpose of you citing to those articles?
The purpose was to identify that pattern recognition is an important component in identifying wounds, and particularly in dog bite wounds. It did not mean that the victim had to have every single characteristic that was listed. And it just was focusing on things to look for and the patterns. It was not just that there's one individual wound that's going to be diagnostic, but that there are patterns for the physician to look for.
In terms of Attorney Brennan asked you, and so now with regard to the Pollock article, in terms of the Pollock article, is there any discussion in this article about whether the spectrum of injuries to which you can apply the mechanism and the methodology, is there anything in there about whether the pattern of injuries can be diverse or whether they're all the same? Does Pollock speak to that?
He does.
And what does Pollock say about whether or not the spectrum of possible injury forms when you apply this methodology can be diverse? What does he say?
Well, he mentions about the actual surface of the body that is impacted, if there's any curvature to that surface, if there's any structures underneath that would affect the bite. So yeah, those are, and if there was material or textiles or fabric that were in between the bite and the skin. And there were other factors too.
Okay, thank you. Now, lastly, what I'd like to cover is Attorney Brennan discussed the Dr. Walsh. May I approach, Your Honor?
Okay. Did you show Mr. Brennan?
He's the one who gave me it.
Okay. I didn't know what you had.
Yes, thank you. So may I hand to the witness?
Yes.
May I stand here, Your Honor?
Yes,
Thank you.
just step back a little bit.
Yep. Step back a second.
Dr. Russell, what I would like to do is to give the jury a fair
Objection.
I'll withdraw that.
Commentary, I'd like to be heard.
Why don't you bring the reports over?
Sorry, I was doing my John Walsh research. This is the guy who was hired in the federal investigation, and I think he was talked about in Voir dire. That's why the name sounded semi-familiar. Anyway, he gave an opinion that the wounds to John O'Keefe's arm did not appear to be animal wounds because none of them were puncture wounds. Well, we've heard Dr. Russell talk over and over again about these wounds could be puncture wounds, as an animal would sink its teeth, as they say, into the arm. Don't have to be, though, and not every wound is going to have every single characteristic that might be described as the perfect evidence of a dog bite wound. So that's why I think it's come up. It was brought up prior in not in the first trial, I don't think, but it definitely, I think, came up in that voir dire, and it was just basically used to suggest that the doctor here's an expert, another expert that she definitely was not impressed with as a doctor with the armed forces, and I think it sounded a little like she was giving him less credit than maybe he deserves. Maybe she just doesn't agree with his opinion, therefore she's discrediting his background. I don't know. I think it's a nothing. It's as they say, a nothing burger. I don't think it's a big deal. I think she clearly explained that these wounds, these specific wounds to Officer John O'Keefe's arm, didn't have to be clean, perfect puncture wounds to be, in her opinion, caused by a dog. I don't know. Maybe a jury will look at it and go, oh, boy, that Dr. Walsh, the whole minute and a half we talked about that has changed my entire opinion of the causes of those wounds to John O'Keefe's arm. I doubt it, but it's something. And I think she swatted it away as best she could. And the overriding impression, which Mr. Alessi is reinforcing, of course, which, of course, now has resulted in a sidebar, but is that, this is your thing, not dog bites in particular, but as part of everything you do when rendering emergency medical attention. And so your overwhelming experience, and as it relates to this case, your opinion that those injuries were from a dog bite and or dog scratches should overwhelm whatever this Dr. Walsh is. And if I'm on the jury, I'm thinking, oh, goody, I guess we're going to hear from Dr. Walsh, who's going to come in and rebut the things that Dr. Russell has said. I don't think you're going to see that. If you would see that, if it did happen, I think it would give more credibility to the prosecution's attempt to discredit Dr. Russell. But no, I don't think you're going to see that. So let me see if I can pick up a couple of notes from this last part of the cross-examination and the recross and the redirect. One of the things, get back here to another page, stand by. They got right to, we were talking about this just before they reconvened, the whole methodology story that Mr. Brennan was pounding away. And there, you have to admit, Doctor, there is no methodology when it comes to your analysis of these dog bites, correct? I don't care. I don't care. I care that she has the experience. I care that she can explain why she gets to the opinion that she gets to. And I just don't give a rip if all these other experts or presumed experts write an article. You know how many articles are written by morons? A lot of them. And you know how many articles written by morons are then peer-reviewed by other morons? A lot of them. So in the absence of being able to cross-examine each of these individual morons about their belief in another moron, I just don't care. I care about the witness on the stand now. I care about that expertise. I care about whether or not what she has to say helps me get to some sort of understanding about what may or may not have happened in this case. And remember, I'm on the jury. I don't need to be convinced beyond a reasonable doubt that it was a dog bite. I don't. That's not my job. What you do have to be wondering is, as you sit there, okay, Commonwealth says it's not dog bite, then what the hell caused it. And now you're right back to the exploding magic taillight theory. So yeah, there could be a juror or two that believe in the exploding magic taillight theory, having caused all of the injuries to Officer John O'Keefe's arm. There's nothing you can do about that. If they're going to take what little evidence the Commonwealth has provided and come to that conclusion, there's nothing you can do about it. So keep it in perspective here, folks. This ain't for us to worry about. What's the jury doing with this? Let's see if there's any redirect following that little sidebar.
Can I proceed here?
Yes.
Thank you. Dr. Russell, I am re-handing you this letter from Dr. Walsh. And what I am going to do, and you just tell me if I do it correctly, I'm just going to read 2 paragraphs, okay? And you just tell me if I'm reading it correctly. In totality, the injuries documented in the autopsy report and photographs are non-specific and may be the result of a variety of different mechanisms. No additional information was provided regarding the possible circumstances or events surrounding the death. The absence of additional information prohibits the attribution of injuries and contribution of findings to a specific underlying cause of death. Did I read that correctly?
Yes.
No further questions, Your Honor. Thank you, Dr. Russell.
All right, Dr. Russell, you are all set.
Thank you.
I'm going to have this marked for identification.
Thank you.
Thank you.
Yep. Of course, you're going to have it marked for identification because then it can be submitted to and the jury can review it again and again. And that's the Commonwealth's case, depending on how much effort they want to put into it and how much they believe. You heard the very last few questions made it clear. Mr.
And
Les,
the next witness is who?
this Dr.
Who's the next witness?
Wolf.
Yes, just tell me the name because I need to know whether we need to go to sidebar first. Okay, thank you.
Okay, so as we thought, it might be another officer, and I didn't catch the name because damn you, Mr. Jackson, you talk off mic so often, it drives me crazy. But obviously, what drives me crazy is not your concern. So let me just finish my thought on Dr. Walsh. I don't know why I said Dr. Wolf. Dr. Walsh, because there are 2 Dr. Wolfs in this case. That he has said himself in that article that there are way too many other factors involved to really definitively determine the nature of those wounds. So let's go back. New witness. Here we go.
All right, Mr. Jackson, you are all set.
Thank you, Your Honor. Good afternoon, sir. How are you?
Good afternoon, sir.
Could you please state your full name, spell your last name for the jurors, please?
Nicholas Barrows, Barros.
And where do you currently work?
The town of Dighton, Dighton Police Department.
How long have you worked for the Dighton Police Department, sir?
Since 2011.
And what's your position there currently?
Currently, I am a sergeant.
What's your duty assignment as a sergeant? What do you do?
I supervise the 4 to midnight shift.
We'll get to that in a little bit more detail in just a second. A couple of more foundational questions. How long have you been a police officer altogether?
Since 2011, so going 14 years.
And what education and training and background do you have that qualifies you to do your duties as a sergeant, a supervisor at the Dighton Police Department?
I completed the police academy. I hold a bachelor's degree in criminal justice. I've been to many trainings as a police officer and as a supervisor.
When did you get your bachelor's degree?
2012.
Is the Dighton Police Department an autonomous police department for the city? In other words, is it a branch of, say, for instance, Massachusetts State Police, or is it an autonomous department?
It's on its own.
Okay. It's not in any way connected to the Canton Police Department, I presume?
Correct.
Is it in any way connected to the Massachusetts State Police
It
Department?
is not.
As a supervisor, are part of your duties to oversee subordinate officers in their daily fare, whatever that may be?
Yes.
Does that include anything having to do with crime scene investigation?
To an extent.
Witness interviews?
No, that would be the detective bureau.
What about working and coordinating with detectives?
To an extent.
collection of evidence or working with detectives as they collect evidence?
They would collect evidence.
Maintaining crime scene protocols, things of that nature.
Correct.
All right. As a sergeant with the Dighton Police Department, are you a trained observer?
I am.
Would you consider all of your subordinates, the patrol officers, day-to-day officers, are they also trained observers?
They are.
Is that part of policing?
It is.
Describe that a little bit for the jurors so we understand.
We are in the police academy. We're told to watch everything. It's our heads on a swivel. We are always looking because we don't know what the unknown is.
When you say you don't know, is it true that you don't necessarily know what might become relevant later that may be needed in court?
Correct.
I want to draw your attention to January of 2022, a few years ago. January 29th, 2022, did you have any, you personally, officer, did you have any personal relationship with the Canton Police Department?
I did not.
Did you have any personal relationship with a trooper from the Massachusetts State Police named Michael Proctor?
I did not.
Do you have any relationship with a person by the name of Brian Higgins, an ATF agent?
I did not.
Do you have any relationship with a Boston police officer known as Brian Albert?
I did not.
Did you know any of the witnesses or individuals involved in an ongoing investigation related to the death of Boston police officer John O'Keefe?
I did not.
On January 29th, 2022, did you receive some sort of a call to respond to a particular location? I don't want the address of the location. We'll get to that in a second. Did you receive some sort of a call in the afternoon?
I did.
Describe that for the jurors, please.
Around 2:30 in the afternoon, I received a call from the troopers assigned to the Norfolk District County DA's office in regards to a vehicle that was at a residence in the town of Dighton.
What were you asked to do? Why did you get that call?
The troopers said that they were coming into my jurisdiction, and as a courtesy, they wanted me to respond with them.
Is that sort of normal protocol? If you go into somebody else's jurisdiction, you let them know?
Yes.
So that was not necessarily unusual.
No.
About what time did you receive that first call?
The first call was around 2:30 in the afternoon.
Was there are logs kept of those kinds of things? If you get a call, you respond to location?
Yes.
At some point after you received that first call, did you receive any other call specifying a time of arrival for the MSP troopers, anything like that?
I did.
Describe that for us.
I got a second call around 3 p.m. From Trooper Michael Proctor stating that he was about 10 minutes away from the address in Dighton.
At the point that you spoke with Michael Proctor, had you ever spoken to him in your professional or personal capacity ever before?
Never.
Did you know the name? Did you know who he was?
I did not.
Complete stranger.
Complete stranger.
What time did you actually arrive at the residence?
I arrived at the residence, I believe it was 3:27 p.m.
Sergeant Barrows, did you, I don't want the address, cameras are rolling. Did you respond specifically to a residence in the city of Dighton?
Yes.
Did you at that time know who lived at that residence, who resided there?
I did.
How did you know that?
Early in the shift, when I came on at 8 a.m., the midnight shift, the outgoing shift, had told me that a resident of Dighton at that address had called looking for a ride to Brockton Hospital.
Who did you know at that time, or who did you believe at that time to live at the address that you are now responding to?
William Reed.
That was Reed, R-E-A-D?
Correct.
Okay. Did you know anything about his daughter at that time, or did you just know the name William Reed?
I just knew William Reed, the name.
At the time that Michael Proctor called you, did he say anything about what his intentions were once he arrived at the location?
Yes, his intention was to retrieve a vehicle that he said was involved in a homicide.
Did he specifically say to you at 3 o'clock-ish in the afternoon, he intended to seize the vehicle?
I believe the first phone call, that was his intention.
Meaning all the way back to 2:30?
2:30 is when he first called me and said that they were coming to Dighton to retrieve a vehicle that happened that occurred in a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle.
Seize.
Thank you. What was your role once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Do you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry, my fault. Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever?
None.
Same with Trooper Proctor?
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes. Once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun, badge, the whole works?
The whole works.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there. And I also went in to ask how we're going to get the tow truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between, longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance?
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that description is?
There was, it was damaged. The taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear tail light.
Of what?
The Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the tail light the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear tail light, please?
Okay.
Do you see the condition of that tail light as it's depicted in this photo?
I do.
Sergeant Barrows, is this the condition of the right rear tail light when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's different about this photo, sir?
That tail light is completely smashed out.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence?
Objection.
Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically, other than the fact that it's different, describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer. If you can, there's two displays, one monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the jurors. Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
May I approach?
Yes.
If the entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
Sustained.
Do you believe you would remember if the taillight, well, let me ask it a different way. The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle than is depicted in this photo.
Sustained.
We can take this down. As you sit here and recall back to that, your observations, and you observed this for over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously,
I have.
about a year ago.
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately, was the black Lexus SUV towed and cleared from the scene?
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen? Like, for instance, the SUV is taken away?
When I cleared from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.?
No.
I'd like to show you another exhibit, if I could. This is exhibit 105. Do you recognize this scene generally?
I do.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Do you see some vehicles in that still shot of the video?
I do.
Describe what you see.
That tow truck is Diamond Towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
If we could, with the court's permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay.
Can we play this video?
Yes.
Thank you, Your Honor. Can you see what's depicted in the still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13. Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The area that I'm circling here, do you see any red lens in that area?
No.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
Absolutely not.
Thank you.
Lights, please. Thank you. Mr. Brennan.
Thank you. Good afternoon, sir.
Good afternoon.
Have we met before?
We have not.
Do you still work in Dighton?
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed
Nope.
or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene
Yes.
because it's your jurisdiction.
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it.
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you, you introduced yourself to them, they went into the Reed house?
Yes.
And then they came out?
They came out much later.
And that vehicle was towed?
Correct.
At no time from when you got there until you left, did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
When the vehicle was towed, do you know how long it took to take the vehicle from Dighton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
I could have.
In fact, there was no limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at the moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but
Did you at the time?
at the time, correct.
Yeah. And so it's sometimes difficult to remember the details of all events, and you use the report to refresh your memory.
Correct.
When you wrote your report, and you could have put as much detail as you wanted, is it fair to say you only wrote one single line about the damage to the car?
Correct.
The vehicle had damage to the right rear taillight.
That's what I wrote.
Fair to say you didn't document that it was the size of a dollar bill. You didn't say that, did you?
No.
Or that it was 3 to 6 inches. You didn't mention that, did you?
No.
You didn't mention the placement of where the damage was.
To an extent, I did the right rear tail light.
Right rear taillight. You didn't indicate if it was on the side or on the back.
I did not.
You didn't provide any other details of your description when your memory was probably at its best. True?
True.
And would you agree that your memory that day was probably much more accurate than it is today?
I would not.
When you wrote the report, did you ever have an opportunity to write a supplement report if you wanted to give more detail?
I guess I could.
You didn't.
I did.
Inevitably, you were a witness at trial. I'm sorry, you were a witness at a prior proceeding in this case, weren't you?
Correct.
You came in and you swore under oath regarding your memory.
Correct.
And that was probably a year to a year and a half after you first made the observations which you reduced in writing in the police report.
Correct.
And when you made those observations, that was on January 29, 2022?
Correct.
When you came into court and you testified, that was on June 10, 2024.
If that was the date.
You were asked questions to use your best memory to describe the damage to that taillight last time you swore under oath to tell the truth, weren't you?
I don't think I was asked that.
What were you asked about to describe the best you could the damage to that right rear taillight last time you were in court on June 10, 2024?
I don't think I was told to describe it in depth.
Were you asked questions about the damage to that rear taillight last time you were in court?
I was.
And when you described the damage, did you do your best of your ability to give as much detail as possible?
I did.
Did you qualify your memory at that time, saying to the best of my ability and recollection?
I did.
And when you qualify as a police officer with the best ability and recollection, that is recognizing that time had passed.
Time has passed, yep.
That you had a report, that you could refresh your memory.
Correct.
And did you refresh your memory with that report before you testified last time?
I did.
And when you qualified that it was to the best of your ability and recollection, that account for the fact that when you looked at the report, there was no detail other than your commentary in your report that the vehicle had damage to the right rear taillight.
Correct.
And so when you qualified, you were considering human factors like time had passed.
Correct.
That your report was respectfully scant.
Correct.
But you had heard a lot about this case since that point, hadn't you?
Correct.
And so considering your memory in June of 2024, when you qualified your answer, was it considering all of those different factors that had passed in between that time?
Can you rephrase that?
Yes. When you decided to qualify your answer and you said to the best ability and recollection, and then you went on to describe what you remember from the break of the taillight, is the reason why you used that qualification to the best ability and recollection, is it because of those human factors that had passed?
I would suppose so.
And sir, since the time you came into court on June 10, 2024, have you spoken to anybody from the defense about this case?
Yes.
How many times have you spoken to somebody from the defense about this case after you gave your testimony on June 10, 2024?
Once.
Where did you speak? Who did you speak to?
Attorney Jackson.
Did you speak to him in person or on the phone?
In person.
Okay, okay. You're not hesitating, are you?
No.
Where did you speak to him in person?
At his hotel.
How did you know where Attorney Jackson was staying?
He told me.
Did you find it odd to go visit an attorney at their hotel and talk about a case?
It was in their conference room.
Find it odd. Go to somebody's hotel and speak to them about a case.
No.
Without saying the name of the hotel, where was the hotel located?
Boston.
And where were you located?
I don't feel comfortable telling you.
I'm sorry. Did you have to drive?
I did.
So you took the effort to go to see Mr. Jackson at his request. Did you know who Mr. Jackson was?
I did.
Did you see him on TV?
I did.
When you went there to the hotel in the conference room, who else was there?
Attorney Little.
Okay. Who else?
I'm not sure of the other gentleman's name.
It was one of the gentlemen right here on the end.
The
The good-looking one down there on the right.
No, it was not.
Somebody else?
Somebody else.
Okay. Was there anybody else there?
No.
When you were in that conference room, were you shown your police report?
No.
Were you shown your testimony from the last time you came to the court?
No.
The photograph of the vehicle in the Sally Port, the vehicle with the missing glass, were you shown that?
No.
Had you ever seen that photo before?
Of course.
And you saw it at the last event you testified at, right?
Correct.
And when you were shown that photo during your prior testimony, you never, ever suggested that that was in any way different than what you had seen in Dyke.
Nobody asked me that.
When you were asked to describe the damage, and you were shown that photograph, you never, ever suggested that there was a difference in the damage as you see it in that photo compared to what you remember, did you?
I don't think anybody asked me to describe that.
Did you ever make a note or say anything that is dissimilar to what you remember at the last event that you testified at?
I testified that that was not the taillight the day that I saw it.
That's what you testified at the last event?
Did.
Yes?
Yes.
You said that photo does not depict what you saw?
Correct.
Yes?
Yes.
And when you testified to that at the last event, who was asking you that question?
District Attorney Lally.
Okay. And you remember making that comment under oath?
I do.
Do you remember that as well as your memory about what the taillight looked like back in Dighton?
I do.
When you were asked questions about that taillight, you had described the taillight as not completely damaged. It was cracked, and there was a piece missing, but not completely damaged. Remember that testimony?
I do.
And is that accurate testimony?
It's accurate.
So in your memory, in June 10, 2024, was that vehicle's rear tail light had a piece missing, correct?
Correct.
You said that your memory about the damage to the taillight, as you recall it when you were in Dighton back on January 29, 2022, you said your memory is as good as your memory that you said in court there was a difference between that photo and the damage, right?
Right.
Have you ever read your testimony from your last proceeding?
Never.
But you have a specific memory of discussing that specific photograph? Yes?
Yes.
Any approach?
Yes.
I'm going to show you your transcript of sworn testimony on June 10, 2024. And when you reflect on your memory, understanding some time has passed, you've testified that your memory of distinguishing that photo is reflected in your testimony, right?
Yes.
So ask the question differently.
Okay. Your memory is that you discussed the distinction between that photo and what you saw at the last time you testified.
Objection.
I'm going to allow that.
And as you take a look at there, could you show me anywhere in your testimony, anywhere, where you made any statement about that photo being inconsistent with what you saw in Dighton on January 29, 2022?
You can tell this testimony is killing Hank Brennan, and he is scraping and clawing to get anything positive from this witness, suggesting maybe his memory is faulty, that he doesn't remember it as well this time as he did a year ago at that trial. Oops, I mean at that prior proceeding. I don't think he's shaking this witness.
Can I approach?
Yes.
I can put it back on. Thank you. So respectfully, sir, your memory about distinguishing that photo is not as you thought it was and claimed it was in this transcript, correct?
Correct.
And that's not a matter of you trying to fool anybody or lying, is it?
No.
No, it's a matter of time passes and memory fades. Yes?
Yes.
And that's one real example why at the academy, they teach you when you write reports to be as detailed as you can. To accommodate the fact that memories can fade. Right?
Correct.
Memories can change.
I know what I saw, and that wasn't it.
Well, that's not what I'm asking you, because you just testified that under oath, you had looked at that photo and distinguished it. But that's not accurate, is it?
No.
And so it's not a matter of you perjuring yourself or lying, it's a matter of difficulties with memory, wouldn't you say?
Yeah,
And
correct.
you share those same difficulties with memory as many other witnesses. Objection.
Sustained.
You have, as is human nature, difficulties with memory at times, correct?
Correct.
And so that very certain memory you had about your testimony last year, fair to say that never happened.
Correct.
You were simply mistaken, weren't you? Or something more, please tell me.
Correct.
When you met with the attorneys in Boston, what'd you talk about?
It was just a way for them to meet with me and see me face to face, and then ask me how I would be subpoenaed, who would they need to send a court summons to, what my schedule was like coming up in the next month, months.
Those things all could have been accomplished by phone, correct?
Could have.
So the face-to-face meeting, what did you talk about?
Objection.
I'm going to allow it.
Over here. What did you talk about?
Excuse me.
So that, okay.
Over here.
All right. You know, it's you can tell from Hank Brennan's body language. He basically expects any objection made by the defense to be overruled. I'll allow it. You could just tell he's not normally when you're in the midst of a question and you hear an objection as the opposing attorney, you pause. You're like, okay, let me hear the not Brennan. He knows. I'll allow it. I'll allow it. The worst thing he might ever get is, can you ask it a different way? I mean, it is just so obvious. It's an embarrassment. Anyway, so if Mr. Brennan thinks he's going to make some points with this guy, suggesting that somehow his memory is more clear back when he testified before, which was also damaging, he's going nowhere. The only thing he has done with this cross-examination is the suggestion that, hey, you met with defense counsel. You know, why would you travel from wherever you live? And that's appropriate not to dox this guy. But, you know, to drive up to Boston, to the hotel, a conference room that is being used by the defense. Why would you do that? You know, it does plant at least some seed with the jury that there was some, you know, some what should I say, some lobbying going on by the defense. And, you know, is that legit? Maybe, maybe not. Couldn't you have done all that on the phone? Couldn't you just said what day works for you? You know, you're going to be subpoenaed. Are you okay with all that? Yeah. So why do you want to meet in person? So I think that's a point. I don't know if it's a winner or not, but it's a
told
point.
us there was some background about being subpoenaed and time. Substantively, what did you talk about with the attorneys when you met them at their hotel conference room?
Other than that, they didn't go over my testimony. We just spoke about that. I said that the taillight was not completely damaged.
Okay. Did you get into any detail about the conversation about your testimony today?
No.
When did you meet with them?
I don't have the date.
Last year or this year?
I don't have the date. I don't recall the date.
I'm not looking for a date, just the general year frame. Last year, this year?
Probably June, early in this year.
Are you having some difficulty with memory about that as well?
On a certain date, yes.
Not a certain date. Was it this year probably, or do you think you met them this year?
This year.
You know what month you met them this year?
I wouldn't know the month.
Certainly you talked about this issue with the taillight, didn't you?
Yes.
When you talk about the issue with the taillight, did anybody from the defense offer you any opinions or information?
No.
Did they ask you questions about it?
No.
So you went to a meeting in a Boston hotel in a conference room, and nobody talked about the taillight? Objection.
I'm going to allow it.
Sir, I'll ask you another question instead. Have you had an opportunity to see other evidence of that taillight being damaged that morning before you saw it?
On the 29th of January? No.
The video that was shown to you with the tow truck, had you seen that before today?
Yes.
Who showed it to you?
From seeing it on TV. And
was it shown to you during your conference room meeting at the hotel?
It was not.
So you looked and studied and watched this case a little bit?
with all due respect, sir, I don't live under a rock. It's all over social media and the news. You can't avoid it.
I'm not criticizing you or discounting you. I'm just asking you. Have you been exposed to this case since you made those observations in Dyton on January 29, 2022?
I have.
Have you seen other video footage and evidence about that taillight since January 29, 2022?
I have.
Have you seen other information since you last testified last summer about the taillight?
I have.
And seeing this extraneous information, this other information, do you think that played a part in some of your difficult memory?
Objection.
I'm going to allow that.
Your Honor, can we approach?
Okay.
I'll allow it. Of course you will. And so we have this, this attempt by Brennan, and I don't fault the attempt. This is typical cross-examination of a witness you're trying to shake on a subject that is pretty darn positive for the defense. Is this taillight damaged? In this photo, the photo we know that has been produced by the Commonwealth to show damage caused at or about 12:32 on 1/29/22, is this what the taillight looked like when you saw it the next day at roughly, 3, 4 o'clock? No, it's not. So he's trying to shake that recollection. I just don't think he's going anywhere. And then he's trying to make this guy somehow look like a bad guy or, not credible. I don't think that helps much either. But I appreciate it. I understand it. I know what he's doing. But bottom line is, I just don't think it's paying off.
You've seen quite a bit of information about this case and the issue regarding the taillight since you first made the observations back in 2022. Wouldn't that be fair to say?
It would be fair to say.
And based on all the additional information you've read and seen, would you agree it's had some effect on your memory?
I guess.
No, I don't want you to guess. You testified that you made explanations at the last trial that you didn't make, right?
Correct.
You had a memory as you testified in direct examination under oath, and you tried your best about things that just didn't happen, right?
Right.
Would you agree that you have some difficulty with your memory?
I'd agree.
I want to show you some evidence of that taillight before you had a chance to see it in Dyton. If we could have the ring video at 5:07:58, please. Have you seen this video before, sir?
I have.
Before you proceed, Ms. Gunn, have you seen this on social media?
The news, social media.
Has anybody else shown you this video?
No.
How many times do you think you've been exposed to this video?
Too many to count.
Because you were involved in this case, and I'm going to say as a predicate, there were no orders for you not to look at anything. I'm not suggesting any impropriety. But because you were involved in this case and issues regarding the taillight, do you think you had a particular interest when things like this came on TV and social media to take a look compared to your memory?
Did I have a particular interest? No, I didn't follow this case.
But you've seen this many, many times.
Because of what is out there on social media and the news.
I understand. Please play this, please. Turn the sound down. Thank you. Stop, please. Do you see that white part of the back rear right taillight? Objection.
I'm going to allow it.
You see that? Sir?
Can you zoom in a little bit more? I can.
You can or cannot?
I can.
You can. C-A-N can?
Yes.
Thank you. Continue, please. Continue. So, bring it back to stone. Back more. Open, right there. Zoom, please. You see, sir?
I can see that.
Is that consistent with the damage that you saw when you looked at that Lexus in Dayton hours later?
Consistent.
Can we go to Exhibit 10, please? And before you show it, I have a couple questions. This was a snowstorm, kind of like a blizzard that day.
Yes,
And when you got to the driveway, it had not been shoveled or plowed.
correct.
There was quite a bit of snow accumulating and ongoing.
Yes,
And there was snow coming down on top of everything, the ground, the streets, the cars, correct?
correct.
And snow was accumulating, did you notice, on cars and packing onto cars?
Yes,
When you looked at this house, when you looked at the defendant's Lexus in Dayton, you didn't go over and scoop out any of the snow that was in that broken taillight, did you?
I did not.
You didn't try to remove any snow off it or that was accumulated inside of it?
I did not.
And the snow that was, there was snow packed on that car, wasn't there?
There was.
There was snow packed around the light, wasn't it?
There was.
And would you agree with the snow, since you didn't tamper with it or try to remove anything, that could impede your ability to accurately observe the depth of the damage? Would you agree with that?
I would.
If we could have Exhibit 10, please. Does that appear to be the same Lexus you looked at when it was in Dayton? And it's a far view, so I don't want you to guess. If you're not sure, you can tell me.
I wouldn't be able to tell you. I can't.
Okay, we have Exhibit 11, please. Can you take a look to the right? You see that right tail light, the white part?
I can.
Missing, yes?
Looks like snow is packed on it.
Does it look like there's a right tail light there?
Does not.
This is before you saw the car in Dayton? Do you know that, or you wouldn't know that?
That doesn't look like the Reed's driveway.
Do you know if this photograph was taken before or after you made your observations in Dayton?
I do not.
The right rear taillight and the missing parts there, is that consistent with what you saw around 3:27 on January 29, 2022?
Yes.
I have no further questions.
Okay, lights on, please, Mr. Jackson.
Thank you, Your Honor. I'll be brief. Sergeant, did you celebrate your birthday 2 years ago?
I did.
Kind of a big deal. It's your birthday, right?
Yes.
What day of the week was your birthday 2 years ago?
No idea.
Do you have a difficult memory, sir?
Yes.
The fact that you had a birthday, you recall, correct?
Correct.
The day of the week of that birthday may fall by the wayside in your mind, right?
Right.
Sustain us to the form, Mr. Jackson, is
Of
your
course.
witness.
The fact that you can't remember the day of the week, does that mean that you have a bad memory?
Objection.
I'm going to allow it.
Correct.
You remember being in Dayton, correct? Being called out to Dayton to the residents of the Reeds.
Correct.
Do you remember the time?
I do.
Do you remember the weather?
I do.
Do you remember who you met there?
I do.
Do you remember the conversations that you had?
I do.
Do you remember the phone calls that you received?
I do.
The first one?
I do.
The second one?
I do.
Do you remember being in the garage and speaking with someone?
I do.
You remember it was this lady, pretty lady right here in the blue?
I do.
You remember meeting Mr. Reed?
Briefly.
Handsome gentleman with the gold tie?
I do.
You remember all that? Right?
Mm-hmm.
Do you remember the SUV?
I do.
Do you remember the condition of the taillight?
I do.
You were asked whether or not you saw Trooper Proctor in any way manipulate that right rear taillight while it was out at Dighton while you were there, correct?
Correct.
You said no. Honestly, I never saw him touch it, right?
Correct.
Were you in the Sallyport in Canton PD? I'm sorry, in Canton, in the Sallyport at the police station
I wasn't.
at 5:30 p.m.?
Objection.
Sistine.
At any point, did you ever go to the Sallyport at Canton PD that day?
I did not.
Do you have any idea what did or didn't happen inside the Sallyport?
Objection.
Sistine.
You were asked by Mr. Brennan, you could have taken photos had you wanted to, correct?
Correct.
And certainly you could have, right?
Correct.
Was that your vehicle that was being seized?
No.
You were simply there to assist another officer, right?
Objection.
The form, Mr. Jackson.
Of course. What were you there to do?
Just to assist another agency.
Would it have been normal protocol for you to photograph that vehicle?
No.
Did you see Trooper Proctor photograph the vehicle?
No.
Did you see Sergeant Buchanan photograph the vehicle?
No.
By the way, you and I did meet once before, correct?
Correct.
Was that before or after you testified last year at another hearing?
After.
And you were called by whom last year at the other hearing? The defense or the Commonwealth?
The Commonwealth.
You testified for them?
Correct.
Objection.
So that's stricken. It's beyond the scope.
Did the Commonwealth ever contact you after your testimony at the hearing last year?
They did not.
Did they ever call you on the telephone?
After?
Correct.
No.
Did they ever send you a subpoena?
No.
And you testified last year that the taillight was cracked, but not, or damaged, but not completely broken, correct?
Sustained.
You and I met in a hotel in a conference room, correct?
Correct.
Anything sketchy or nefarious about that?
No.
Did I introduce myself to you?
You did.
You happen to know I live in Los Angeles?
Correct.
I don't have a house, right?
Correct.
I don't have an office out here, correct?
Objection.
Sustained.
Do you know whether or not I have an office?
I do not.
Do you remember me asking you if you would mind meeting at a hotel where I was staying in a conference room?
I do.
Okay. Do you have any problem with that?
Nope.
Did you find that unusual?
No.
Did you and I ever speak, ever, before your testimony last year?
No.
Did I ever tell you how I wanted you to testify?
No.
Did I ever tell you what to say?
No.
Did I show you any testimony?
No.
Did I play you any video?
No.
Did I show you a single photograph?
No.
During that conversation, did you tell me how to subpoena you?
I did.
Did you tell me where the subpoena should be directed?
I did.
Did you tell me your vacation schedule?
I did.
Did you tell me your availability and willingness to testify?
I did.
Did we talk about any other thing of substance other than that and whether or not you recalled what your testimony was from last year?
That was all we talked about.
As you sit here, Sergeant Barrows, do you have any difficulty recalling what the condition of that taillight was on January 29th, 2022 at about 3 or 3:15 in the afternoon when you saw the vehicle? Any
No.
difficulty whatsoever?
No.
You remember the condition of that taillight?
I do.
Was the condition of that taillight the same as the photo that I showed you on my direct examination?
No.
You would agree that your memory has changed since last time you testified in this courthouse.
Yes.
In the photo I showed you, the close-up with the missing right rear taillight, is that consistent with your memory of what you saw in Dighton on January 29, 2022?
Objection.
I'm going to allow it. It was opened up. It was opened up.
Is it consistent with what you saw on January 29, 2022?
It is.
Thank you.
All right, Sergeant, you are all set. sir.
Thank you.
For
All right, so jurors, I know I need to talk to the lawyers about a couple of things, so this seems like a good spot to just send you home for the day rather than bringing out witness. So those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be careful with your social media. Remember, tomorrow's a half a day. We'll finish by 1. Okay?
All rise for the court, please. Follow me.
All right, you're all set. Just a happy little person. Yeah. Okay. So I'll tell you who's not all set after that testimony is the Commonwealth. So again, Hank Brennan did the best that he could. I know they're going to have a little conversation here after the jury leaves. So while they are waiting to do that, let's see if I can hit some of the high points. I mean, I know you have some questions here too that we're going to try and get to. And then I will tell you right now, as soon as they truly call it for the day, I'm going to pack up shop real quick so I could bolt over to the courthouse and catch folks as they leave and see if we can throw out a question or two to the folks that will be willing to talk to us. Okay, they're back. Let's see what they're going to wrap.
There have been some motions, I think, piling up. 2 I have not had a chance to read yet, maybe more. Commonwealth's motion for reciprocal discovery, and then the defendant put in writing about the discovery from Aperture. I've not had a chance to read the prosecutor's opposition. I'd like to do all that before I hear you on that. But the only one that I did read is the reciprocal discovery. Ms. Giannetti, are you examining both Brian Loughran and Karina Kolakithis?
Yes, and there are 3 issues that I believe we should dispatch with today.
All right, so why don't you, sure, I have time. I just don't know what you're talking about. Sure.
All right, so the whack-a-mole continues. It's pop down, pop up, pop down, pop up. So yeah, she's admitted there are a number of motions she hasn't had a chance to prepare for, and I understand that. I get that. So I guess it doesn't matter if it's defense motion denied, Commonwealth motion granted. But anyway, she is at least going through the motions, so to speak, of hearing the motions. And the one they've got to deal with right now has to do with some alleged discovery violations, reciprocal discovery. How often have we heard that in this case? Enough times to make you want to vomit. That's how many times you heard it. Let's see. Talked about the memory issue. This was interesting. They showed him the video of the 507 departure of the SUV. Hey, what a surprise. Here comes another siren. The departure of Karen Reed's car from John O'Keefe. Stand by. Right, I wish them the best of luck. The ambulance going by this time. So the question was on that both that video and then the still that came from it, or the freeze frame. It does tend to show a little bit more questionable light condition than that one very clear photo that has been used by the defense to suggest through this witness to the jury. Look, this is what they're telling you it looked like. Here's what this witness is telling you it looked like, which is a stark difference. Here's the deal with that 507 video and anything they pull from it. It's so messy, and some have suggested it's been manipulated. But it just, I don't know if you get enough from that. I will concede it looks more damaged than what this officer sergeant is describing. But so what? Consider the condition of the photograph and the video. It's horrible. And then they showed him the other still from the car parked in the driveway. And the first thing he said was, well, that doesn't look like the Reed's residence. Good for him. It wasn't. It's not John O'Keefe's driveway. And so he wasn't, shown this before, not an issue for him. He's the guy that was helping get this car seized from Dighton. So he would never have seen that before or have no reason to see it. And from that picture, first thing he says was, yeah, it looks like snow is all packed around the light. Well, that's what a lot of folks have said, because if you look at it just on its face, manipulated or not, it looks like there's a chunk missing, unless it was, in fact, snow packed around it. So he's observant. And as he told Hank Brennan at some point, I don't live under a rock, because Brennan suggesting that everything this guy has seen or knows about this case is as a result of his meetings with the defense. Well, that's ridiculous. And does anybody really live under a rock? I'm not sure how that phrase began. Let's see. He also talked about how long he was at the scene, and this was somewhat on direct, but also on redirect. So he has a chance to look at this light. Either, he's not analyzing it. He's not an accident reconstructionist. He's looking at it like, I'm about to tow this vehicle, and I'm making some observations that, as a trained observer, these might be important. Yeah, the taillight has some damage on it. Is it cracked but not completely damaged? Is it broken but not completely broken? Does it have that 2 to 3 inch by 6 inch dollar bill size piece missing? And is that on the side versus the back? That's up for the jury to figure out. But one thing they will pull from this guy is who's he fighting for? Does he really have somebody that he's trying to help here? That's actually the bottom line for any manipulation of a witness, right? What's the reason that he's here? He's here because he was an observer to an important detail. He's being brought in to talk about it. And the interesting thing about his testimony from the first trial, and of course we don't know, it wasn't a trial, right? We know that. It was just a prior proceeding. He wasn't cross-examined. He was examined directly by Lally. The prosecution called him, as they called a number of cops, as you would expect they would in this case, but they did not in trial number 2, which is a whole different issue. But practically speaking, that's why he did not testify in the first trial for the defense, as he is now, and he wasn't cross-examined. I think maybe they should have cross-examined him then, but the fact is he was giving the defense what they needed on his direct examination by Mr. Lally. So there was a note here. Let's see if I can remember the specific phrase. He was talking about when Mr. Lally asks them the questions about the piece missing. There's some verbiage discussion. Was it cracked but not completely damaged? Was it cracked? There was a piece broken but not completely damaged. I think that the thrust of his testimony and his observation is clearly at odds with what Proctor and the Proctor gang and through the prosecution they want you to believe, and that is they want the jury to believe it was just totally trashed as a result of the impact with John O'Keefe's arm. That's the upshot. This witness does not help them get there. This guy is a defense witness, and I think he held up pretty well. I don't think there's anything that he said other than, and you heard on the Recross, the redirect, you heard Alan Jackson trying to fix any sort of suggestion that, you met with me in my hotel conference room. So Jackson's plan, and effectively I think it was, just say, look, dude, I don't live here. I live in California, so it's not like we're meeting up for a clandestine get-together at a hotel. I'm staying there because I don't live here. And he used the famous word now, nefarious. Nothing you thought was sketchy or nefarious about that, correct? And he said, of course not. So they did go over his testimony. And again, as I mentioned before, and I give credit to a cross that brings this up. Will the jury buy it or not? Who knows? When he says, we talked about my testimony, talked about scheduling, well, it's up to the jury to figure out whether they think that discussion about his quote testimony was superficial or was leading in some way. Like, hey, it would be helpful if your testimony meant blah, 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 or you said blah, blah, blah. There's no evidence in this case that he was directed in that way. So jury, again, if they have some weird spin they want to put on it, and it happens, there's not much you're going to do about that. There is no direct evidence that he was there to do anything but meet with these folks. And it's always good to meet with witnesses face to face if you can. There's nothing like that kind of rapport. You're going to have this person on the stand in a murder trial. Spend a few minutes face to face with them. I don't think that's nefarious. Just because other attorneys may decide they don't have the time to do that, too bad on them. And then on Hank's recross, he did get him to admit that his memory quote had changed. Well, I think it had changed a bit in the semantics. The jury will get to decide whether it's in substance or not. I don't think it changed in substance at all. And as I was watching the cross, I just felt like Brennan was running out of places to go. Like he wasn't getting what he needed, and then he was taking 2 steps back and trying to figure out where am I going? Where am I going from here? What have I got? And it just never paid off. Did you notice also the continued, I'll allow it, I'll allow it, I'll allow it? It's just, it's so predictable. If you had the chance to place a wager, I think you can make some money on this. So now, as we can see, they've kicked the jury loose. Jury is gone, but they are still now deciding how much, if any, of this one motion that the judge is prepared to speak about, that they're actually going to argue. And the motion, it's a defense motion I think it was a defense motion. It was a reciprocal discovery motion. Let's see if we made a note here. Just a moment. Let me just take a look here. Let me take a look. I'm pretty sure it was a defense motion. Stand by. Stand by. Anybody hear what I didn't hear? Don't see it in my notes here. Anyway, they're working on figuring out what they're going to do with this motion and whether it's going to be argued full-throated or not. Yeah, I have it listed as a reciprocal discovery issue relating to Commonwealth violation. So unless I misheard that. Let me go to, well, we got a few minutes here. Let's go to some questions I found here that popped in. Okay, Kay, I've been in court when a prosecutor was found to commit a Brady violation, which of course is exculpatory information kept from the defense. The court took it seriously and it stopped the case. The judge was pissed. Yes, and pissed is a legal term, I do believe. So, I mean, you can think of the Baldwin case as probably the best, most recent example of that. Remember the Baldwin case, the prosecution was found to have withheld evidence of some of the bullets or blanks that were the subject of the case and the death of Helena Hutchins in that Alec Baldwin shooting case. Because that was so egregious and so clearly could have been exculpatory, the judge should dismiss the case with prejudice. I mean, that's the death sentence. That is as bad as it gets. Talk about a judge being pissed. Go back and re-rack that. Everybody in the courtroom really was surprised. Among many of them, defendant Alec Baldwin, he was shocked. And so, yeah, that can happen. There's no doubt about it. Bumbelina, the defense needs to mention how the video they just shown is so highly manipulated and the coloring is still off. Yeah, there's some colors in that imagery, yellowish, that I don't think exist on the light in any form or portion. So I'm not sure why that hasn't been discussed. Maybe it was the subject of some pretrial motion regarding the foundation. Obviously, we know all of these photos and much of the evidence put on by the Commonwealth has some interesting possession, custody issues, and who was touching them when and where is all kind of a blur. So, yeah, the defense may have been prohibited from getting into that. Again, it all depends on what was taken care of prior to trial, but I'm confident it has been discussed at some point. And this, to the point that I was just suggesting, Adventurous Spirit 66, yeah, what does this officer gain by lying? Exactly. Would he rather be anywhere else on the planet right now? Yeah, probably. But he did his deal. He's all set. You're all set. And so, you know, he goes on about his life to live not under a rock. And I think he came off pretty favorably. And I have no dog in this fight. So I have to assume that he, in fact, feels like he did his duty and now he's going to move on. So this is one, I'm sure Bev's not allowing the defense to say anything about the video authenticity. Yeah. And again, I think it may have been something they discussed prior to trial. And as a result, hey, if the defense is actually following a pretrial ruling, maybe that's exactly how it should be, right? Let's see. Anthony, or is it Anthony? Sorry. Wild, fighting for someone's rights and life, and her team's being dealt half a deck of cards versus the prosecution. Yeah, I don't know how the court, I just wonder what's going through the judge's brain when making these rulings that clearly slant one way or the other. It's not you know, like by chance that they would fall that way. Of course not. It looks like it's intentional. It looks like there is a predisposition to suppress every bit of defense testimony or evidence by sustaining an objection and to allow the Commonwealth to do whatever the hell they want by overruling an objection. She doesn't overrule objections. She just says, I'll allow it. I don't know if she has some objection to the word objection or sustained, but she'll allow it. I think for no other reason, the record should be clearer than that, right? We do hear from, this is from Steffi D. Has anyone heard what the jury is doing? Well, we did hear from Dina. She was not in there today, but believe me, she's got some folks sitting in there, so it's one step removed. Hey, what a surprise. Rescue vehicles. Now they're trying to squeeze through. There goes Dedham Fire Department engine number 2. So that will soon be followed by an ambulance, I'm certain. I don't know if they, per capita, do they have more fires here in Dedham than anywhere on the planet? These guys are busy. I hope nobody is seriously hurt. No property damage is serious. But they're getting their tax dollars worth, I'll tell you that. So anyway, yeah, we'd heard that they were very attentive to most of the testimony. They drifted a little bit when we got to some of the tech stuff, but most importantly, especially with today's stuff, which was very real world type discussions, dog bites, broken taillight. It wasn't a deep sense of what was being told to this jury, especially that's because in part, credit to Dr. Russell, she just boils it down, and she doesn't get shaken. Here's the simple details. Here's what I believe. Here's why I got there. Here's why I think these teeth marks could be teeth. That's my primary opinion, but it's not 100%. So yeah, there could be a scratch or a claw that's factored into that mix. Just like with my arm. There we go. There it is. Oh yeah, here comes the ambulance. That's pretty. But, I got it. Is that a claw? Is that a nail? I'm not sure. My dog has both very sharp. And when we're playing and goofing around, who knows? Either could happen. Okay, so while we're listening to the sounds of emergency, let me see if I got any more here. Oh, there goes Dedham Fire Department number 4 and an ambulance, and there is the hook and ladder is now coming. Okay, Anthony, I think pronouncing somebody's name is very important, probably because I'm called Michelle quite often, but nonetheless, I try. I definitely try. Okay, you hear that engine warming up? It's just warming up. It's warming up. There we go. And that is Dedham Fire ladder number 1. So we've had engine 2, engine 4, ambulance, now ladder 1. So I have no idea if there's some concerted effort to bother me or not. That's probably a little too arrogant. Anyway, it looks like they're getting back at it in court. The question now becomes, what are they going to do? Half day of court tomorrow. Okay. I'm always the last to know. But okay, well, we will deal with it as we go back to the fan. So let me get back to a couple more questions if we can before I bail out. What I'm going to do is I'm going to jump ship real quick so I get out there before or at about the time the participants leave. What was that question I just tried to queue up and it disappeared? There it is. Do you think Bev spends time in her mirror going, I'll allow it, and ask it differently each morning? Yes, I think Tom Gully show, that's possible. She may spend some time as well saying, you're all set, and acting very positive about the experience for everybody. Okay, let me see what else I got here. No, can't do that. Can't do that. Can't do that. Okay. Hank's liars for hire and bites are free. And money for nothing. Hank confused the officer and it went downhill from there. Let's just hope the jury took enough from it. Yeah. I think there's a difference between making somebody look like they were lying or mistaken and then just kind of confusing them based on the series of questions you're asking. Yeah, would it be better if a witness is never, ever, ever confused? Of course. But if you put it in perspective, the takeaway, in my opinion, that this jury gets from this guy is, why would he lie? And how different did that taillight look when he saw it at 3-ish the afternoon after the alleged event, and the picture that's been shopped by, not photoshopped, shopped by the Commonwealth as the damage done by what, if anything, happened at 12:32 on 1/29/22. That's the takeaway. That's what it looks like in the picture. That's what it looks like from this guy's recollection and his testimony about these different pictures. Believe it. Believe it or don't believe it. Just cruising through, see if we can find out a couple of other items here before we break this ship. Are they? They're back on the fan again. Just so weird, very weird. Oh, okay. Yes, and this was important because you'll see how a redirect in this case by Alan Jackson paid off and played out. Collins 6-hitter. Hank criticized the cop for not taking a photo, but neither did Proctor and Yuri, and it was their case exactly. And Jackson did that exact line of questioning when he got back to his redirect. This guy, we have between this guy and is it Officer Deor or is it Private Citizen Deor at this point? Very different folks, very different testimony, but people that were plopped into this case in very innocuous ways and ended up being kind of important witnesses in this case for very different reasons. Deor, never say Deor, because she's just an idiot and because she's just made herself look like a fool and in the process made the Commonwealth look like a fool. So this guy, he's just got some very important precipient witness information. And unless you think he's a total liar, sandbagging for the defense, and can give me some motivation for him doing that, then he's bringing some information to this jury. Do with it what you will. He truly has, not only has he not been living under a rock, but he has no dog in this fight. Okay? We've had so many amazing questions, and I am so bad at getting to them and filling out the... Okay, this is interesting. This is deep. Oh, it's Anthony again. Oh my gosh. Paula, I'm not. This is to one of the other chatters. I'm not religious. I know for a fact she's not going to be looked upon fondly, and her legacy will be on the wrong side of history. I don't think. I think we're talking about Judge Beverly Kenney. I don't think she gives a rip. I think she knows her future is going to be just fine, whether it's on the bench right here or at some higher destination, some higher calling, as it were, a better job. Yeah, I do not think she acts with impunity, and that you can only assume comes from above. That, and I don't mean above, like I mean from the bosses. This is an appointed judge. I assume. Remember, she's person of the year. If she wants that job for a longer period of time, she gonna keep it. Okay. As to this witness, Gaynor Rands, I agree. He saw it for himself with his own eyes, no matter how Hank tried to spin it. All Hank did was make himself look stupid. Again, he's doing his job, and this is a brutal witness for the Commonwealth. So he's trying to do his best. I don't think it paid off. I don't know if he made this testimony more important for the defense, more effective for the defense, but it didn't do much to diffuse the importance for the defense. That is for sure. Legal-minded friends of Karen Cole. If he was directed that way, that he would be trying to influence a law enforcement officer. I think he's talking about, or this person is talking about, if somebody would be directing a witness's testimony, obviously you can't do that. You could specifically ask, what are you going to testify about? What is your recollection? You could, but the more detail you get into that with an independent witness, and technically this guy's a precipient witness, you as the defense have a right to talk to this witness. The more you get into the substance of the testimony, the trickier it is, and the more likely it's going to look like you're going to be accused of a little manipulation. And remember, the goal is, we have short memories, as we've heard so often. Although I am amazed that Officer Barrows, or Sergeant Barrows, did not improve his memory over time, as so many of the witnesses for the prosecution have in this case. But nonetheless, I always tell a witness, I mean the last thing. Remember this. If you don't remember anything else we talk about, tell the truth. That's it. Just be honest. And it is amazing how that sticks to the cerebral cortex. And then a witness then gets up there and is asked that question. Well, did you talk to Attorney Bryant about your testimony? No, not really. He talked about, if I remembered the case and was ready to testify about it. Yeah. Anything else he told you? Well, yeah, he told me to tell the truth and be honest. That is so powerful. Not only does it make the attorney look pretty good, but the jury says, oh, well, if that's what this witness remembers from that interaction, you get sort of a little bit of a pass. You're not going to be looked at it as somebody trying to manipulate a witness. You just want the truth, because that's all the jury wants, is the truth. Okay. And I'm sure those conversations took place. These guys, they know exactly what they're doing. How come I keep banging away on these Anthony questions? I'm just looking at them briefly, then I bring them on, and then I go, oh, it's the same person. She has a free ticket to do what she wants to do for the Commonwealth to make all the money worth it in the media. Do you think that's her goal, that she's in the end going to be some sort of media darling, that she's going to be a talking head, that she's going to, not that there's anything wrong with it. I don't know. I don't know about that. I think she's got a pretty cush. I mean, what other kind of job, really? Think about it. What other kind of job that pays decently do you go to work at or about 9, and you're totally out the door by 5 at the very latest, and you got a few breaks along the way? You got some half days here and there. I mean, I don't know that Judge Beverly has any aspirations of anything, above and beyond what she's doing right now. What do you guys think about where we go next? We assume that Lucky is coming up, right? Lucky, the snowplow op. Who else? Who else do you want to hear from? And are you surprised? I am. I know how they're trying to work around Proctor. Even the defense seems to be trying to work around Proctor. I just don't know what the downside is to bringing him. And some people say, well, I mean, if he was going to claim the 5th, obviously, and if they've had discussions suggesting he might claim the 5th, and I know last night, LKB and Nan was on, and they had a conversation about ability to claim the 5th. Would he? Could he? Yeah, I think he still could. They went into that discussion in detail. I won't take more time to do it. But have they had a conversation, and were they represented? Where was the defense told, look, he's going to take the 5th, so why bother? We don't know. We don't know that. Or was it a strategic decision to not call Michael Proctor? Or are they going to? And we just don't know yet. But the way we're seeing different witnesses used to bring in bits and pieces of the texts, the jury knows he was fired for his work in this case, so they can go on and on about that in their closing. They've got all the bits and pieces that they need to talk about why he was fired, and their argument can go a little bit afield of the actual evidence that's been presented. They can go with inferences, and they can make all those arguments as it stands right now. But I don't know, maybe it's just me. I would love to see this guy on the stand after the fact, talking about, how he botched this. I mean, there's nobody that can talk more directly about the investigation or lack of investigation than the lead investigator. And of course, I mean, sure, in closing, you can say, and why didn't the Commonwealth call the lead investigator in this case? I'll tell you why. It's because you could do that. Then that's fine. But man, I'd rather just see the guy squirm. Just get him up there. See if he can, somehow make himself look better than, whatever the jury envisions of this guy now. Let's see. This is Snarkastic Sam. Never should have been a cop. She doesn't have the Constitution for standing up for the truth. It's not a parking ticket issued by her that should withstand. I think we're talking about Never Say Never. Yeah. My mind's still boggled by, and again, she's young. I get it. I think she was led astray in being told, just here's what you do. This will be fine. You'll be fine. Go in there and tell them about this whole false memory planted by the defense. And it'll be great. Obviously not so great. And I think her career is dead in the water. So, start looking up, I don't know, maybe something on Angie's list, something going on there. Is this a rhetorical point here? Tony Amar, I don't believe that the judge is being too fair in this case. I would agree with you. And I don't say that because I give a rip about either side. I mean, from a 30,000-foot view, I just want to tell folks what I think is going on. And we've seen week after week after week of things that suggest you're right. You're absolutely right. tonight, don't forget tonight we will be back at 6 o'clock. And I am waiting right now to see if they're going to call it for the day. I don't see the fan or anything now. Diz, Missy, do you have some insight? Is there anything happening there? Have they called it and not told me? Because I don't want to miss catching them leave. And I will if I just sit here waiting and then I don't know that they've already left. So any insights you guys can give would be very, very helpful. It's such an irritating tone. She says, I'll allow it. Yeah, her whole tone is just bizarre to me, you know. It's so fake. It's just fake. You're all set. Yeah, they've been done a long time. So they bailed. Then I got to get the hell out of here. So we'll be back at 6 o'clock. I'm going to go try and get some sound from somebody. In the meantime, I'm Michel Bryant. Thanks for joining us for JSTV TV. Try to do the right thing, and we will see you very soon.